So pending a fresh.
Lord, sir, 2:30.
General fresh matters ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ.
Milords, fresh.
2:30.
Give it,
Milords.
Sir, ನಿಮ್ ಮುಂಚೆ ಸುಮಾರು ಜನ ಮೂವ್ ಮಾಡಿದ್ದಾರೆ. People have moved the matters prior to all of you. Those will get precedence and don't move 10 memos for one case. It will come, give it, yes.
Milords, fresh matter.
Why should I show indulgence? ಬೇರೆಯವ್ರ seniority ಇಲ್ವಾ? Nothing.
Sir, 2:30, my lord.
Reporting settlement, please give.
Vacating entry order, my lord.
Vacating interim order ಕೊಡಿ.
Lord, sir, 2:30, my lord.
2:30, no matter, give it, yes.
Milords,
No matter at
Fresh.
2:30, give it.
Milords,
ಹೌದಾ, ಯಾಕೆ? ಯಾಕೆ ಬೇಲ್ ತಗೊಳ್ಳಿ?
Lord, connected matter.
ಬೇಲ್ ತಗೊಳ್ಳಿ sir.
Lord,
bail.
connected matter, there is stay by.
If somebody has come to arrest, take bail. This is
Lords,
482 court, not bail.
Milords, fresh.
Connected
Milords.
matter, there is.
Settlement, please give, sir. Settlement whenever you want, please write and give.
Lord, connected matter.
Give all the memos.
Connected matter, there is.
No mentioning in memos, please give.
Lord, connected.
If it is pending on the designated days, fresh Monday.
Lord, connected matter, there is stay, my lord.
Maybe, sir, give it, sir.
2:30, my lord.
No 2:30, sir.
The entire female.
No
family
2:30 at all.
members- Female
My lord.
family members have been.
No 2:30 at all.
Atrocities Act, my lord.
No problem. Take bail, sir. Give, sir.
Milords, Milords,
Your lordship, I have a small submission, your lordship. If your lordship is convinced, we will take.
No, I am not convinced at all. Yes.
Kindly let me explain the emergency, your lordship.
The what emergency?
Your lordship, I am an advocate, your lordship. The
Ah.
only allegation on me is that I've represented accused number 1 and 2. For that, they have filed me under SCFC Act and other.
All right.
sections of BNS, your
Tomorrow, Kodi.
Milords,
No,
fresh matter.
2:30.
My lord,
Tomorrow,
tomorrow, my lord.
Tomorrow, sir.
Tomorrow.
498 settlement tomorrow, Lord.
Pending matter ಕೊಡ್ಬೇಡಿ, only fresh matter.
Milords,
Pending
fresh
matter on the designated
Milords,
days it will
fresh
come.
matter tomorrow, Milords. Fresh
Give it,
matter
sir,
tomorrow. Tomorrow.
FR number ಇದ್ರೆ if FR number
Fresh
is there,
matter.
it will not come at
File
all.
has been cleared, Milords, on 23rd
If it is
January.
cleared, it will come. FR number, it will not come even if you move. Yes.
Tomorrow, Milords.
Because ಆಮೇಲೆ you will never comply with the office of justice.
Please.
Give it, madam. Give it, madam. No.
One submission, my lord. Lord, without rejecting B report, Lord's cognizance is taken. Lord's accused they decide in Monday. The case is posted for tomorrow. In the previous day also, my lord, we filed for exemption. Lord, next-
Case is postponed for tomorrow, arrest ಮಾಡ್ತಾರಾ? ಮತ್ತೆ ಕೊಡಿ.
Lord,
Yes.
decided in Mumbai, my lord. Previous date, at
Give it,
least for
sir.
tomorrow.
Give it.
Lord, for tomorrow, my lord.
Tomorrow ಕೊಡಿ.
Madam,
Give it, sir. Monday, you please give all the fresh, don't waste time. Give all the fresh matters.
One submission, my lord.
You give it, sir. If it is FR number, it will not come. You give the
Monday.
FR number, huh? Baralla. I will not take, I will stop taking memos on FR numbers now.
Lord,
Give it. Maybe, sir. You give it for tomorrow. If FR number is complied only, it will come.
Lord, the trial court is our charge frame ಮಾಡ್ತಾರೆ.
ಒಳ್ಳೇದು. ಕೊಡಿ.
Monday,
ಏನಿಲ್ಲ ಕೊಡಿ.
kindly have it on
ನಿಮ್
Monday.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಡೇಟ್ ಪ್ರಕಾರ ನಾನ್ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಕೊಡಿ. Yes.
498 settlement tomorrow, Lord.
Give it.
Kindly have it on Monday.
Settlement whenever you want, give it. Please give the memos, sir. Please give the memos. No mentioning, please give the memos. Please, if you want to give the memos or I'll call the cases now. Please, settlement, please give all the memos. Don't even ask. Whenever you want, write and give.
My lord, for Saturday, my lord.
ಮತ್ತೆ ಅದೇನಾ?
Fresh matter.
In every Facebook post, give it. Yes.
Lord, for your lordships kindly.
Lord, I am the.
Lord, for sorry to.
2:30 ಇಲ್ಲ sir.
2:30,
Yes.
Kada. This matter was filed 2nd of December. It is only adjourned. There's a fresh matter, my lord. Though it is 25.
If it has not reached and adjourned, it will come on Monday. Give it.
Please, my lord.
Milord,
Give it. Sir.
Monday.
No, and tomorrow urgency there. Tomorrow I can't take another 1,000. Give it. Yes.
Milord, I am a,
Saturday? No, sir.
Milord, I am a chairman of a reputed real estate company, Milord.
So what?
In my, one of my tenants, Milord, there was an incident.
So what if
with
you are a
third party.
reputed
I am
company
arraigned as
chairman?
an accused, Milord. I am arraigned as an accused.
ಅಷ್ಟೇ ಹೇಳಿ ಸಾಕು. You are an accused equal with everyone.
No allegation
No
against.
problem. Give it.
Milord, now I am receiving calls from the police, that's it. Tomorrow, Milord.
No, sir. Take bail.
I filed it in November, Milord. Office objections.
Oh,
are
ತುಂಬಾ
complete.
lot of urgency. Office objections, you don't comply.
Complied in December itself.
Let-
Milord. I
It'll
moved
come-
it twice, that's why.
No problem, sir. Give it. Give it,
Tomorrow.
sir.
Please, may I make?
It will come. Give it. ಈಗ ಮೆಮೊ ಕೊಡ್ತೀರಾ ಇಲ್ವಾ? Give it, sir.
Fresh matter.
Please give the memo. Call the cases, madam.
Fresh matter.
Give it, sir. No 230. Give it.
Case and counter.
I am not taking any memo for 230. Please give it. Tomorrow we'll see. FR number idre ಬರಲ್ಲ.
Case number.
Oh, tomorrow also I think there is division bench. Tomorrow ಇಲ್ಲ ಅಂದ್ರೆ Monday ne.
This
Give
is
it.
a case and counter case.
I can't fix my dates according to your trial court dates. Give it.
My lord, this is a case and counter
You
case.
should know what
The
to
other
do
case
before the trial court.
is- This is a case and counter case. The other case is already been stayed, my
No
lord.
problem, sir. Give it.
Listed.
Yes, yes.
The ED has attached the properties of.
Very good, sir.
He is being
Yes.
dispossessed today.
No problem, sir. Give it.
That's on Monday, my lords, kindly.
Give it, sir.
My lords,
Monday.
based on settlement negotiation, we undertook to pay 6 crores. Now there is a, they have backed out and there is a notice for us.
Very
We
good.
filed an application for recalling of.
No problem. Give it,
The
fresh matter.
proclamation is sent, a small submission. my lords. It's a
Give it,
fresh
give.
matter.
Pending matters, please give. Not one pending matter out of 10 I'll take. Give it. Yes.
My lords,
Huh? Even if you file 200 memos, it will not come. Give it.
my lords,
It will
small
come according to
submission.
its turn.
Small submission, my lords. In this case, the petitioners are a institution head, my lords.
So,
Just to take back the mark sheets from the petitioners, they have just to harass the petitioners, they have filed an FIR complaint, my lord.
take bail, sir.
My lords, bail already taken. my
Already
lords.
granted. No urgency.
May I
Give it.
make
My lords.
a proclamation
Give it,
is sent privately by the complainant, my lord.
By proclamation, you have not gone before the court.
I
No
have
indulgence.
mentioned it
Monday,
earlier, my
Monday.
lords.
Monday, my lords.
There's some urgency in the matter. For
No
15 years
emergency,
he's unable
sir.
to come to India.
Proclamation is done only because of your
Such
conduct. Give
proclamation,
it.
my lords.
No, sir. Give it.
Not 7A matters, not 31st ಉಳಿದಿದ್ ಬರ್ತಾ ಇದೆ.
ಇದೇನು ಪೆಂಡಿಂಗ್
ಇಲ್ಲ, not the fresh matter, my lord.
ಬರ್ಲಿ.
It's in fresh
7
matter,
ಏನು ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ ಕೊಡಿ sir.
not the 31st. my lord.
ಏನು ಅರ್ಜೆನ್ಸಿ.
Not,
Into section 16 my lords,
Please.
advocate is made a co-accused my lords, the advocate is the petitioner my lords.
So what?
Complied with all the office of.
Pending or fresh, sir?
A fresh matter. my
It will
lords.
come, sir.
Lordship may have it on Monday. my
No
lords, and
date,
date
sir.
may be
It will
given.
come, sir. There, I told you, 7,200 memos are pending to be posted. What can I do?
Written matter, actually, written matter.
ಈ ಬಂದಿಲ್ಲ ಇವತ್ತು.
Different fresh one.
ಯಾಕೆ ಮತ್ತೇನಾಗಿದೆ?
ಇನ್ನೊಬ್ರು ಬೇರೆಯವರು.
ನಾಳೆ.
Number 20 is non-sitting.
Not sitting.
My lords,
Oh.
the stay vacation was also dismissed.
Ah.
Stay was continued,
Ah.
but it was not came into the order. Therefore, police has issued again notice.
If 20th court is not sitting, stay was dictated and it is not found in the order, what can I do?
My lords, my humble submission is I have come all the way from Jaipur.
Jaipur,
Yes, my lords.
where are the police?
Bangalore.
Why did you come here?
My lords, the stay vacation was dismissed on last occasion. On virtual hearing, I requested the court that since the stay vacation has already been dismissed, despite that the order, the matter is listed in orders category.
So what?
Therefore, the honorable court directed to list the matter for final disclosure and interim continued. But that interim continued did not came into the order. And stay vacation was already been dismissed.
I will take it. Tomorrow that court is there.
Tomorrow, my lord.
Tagoli, yes. Tomorrow.
Obliged, my lord.
No 230, sir. Please give it. FR number either, please give it.
Further hearing NDPS matter, lord, that IBAR matter.
Give it. We'll see.
Any date
No,
we can-
after the interviews are over next week. Yes.
Any date.
Yes, we'll see.
Further reading, still number 1.
Yes, sir. I think the learned attorney would.
Yes, yes. I was just tempted to say something before I open the medical.
No, this is our daily dose.
No, I was remembering a book which was given to me by Professor Menon.
Yes.
It's titled Doing Justice, a Trial Judge at Work by Robert Satter. He opens the book by saying, I look at the men and women who assemble in my courtroom every morning. Those women, those black women, who, with all their sullen faces and expecting that today justice will be done. I look at them, I pierce into their mind and heart. I think that's where my job is done. That's how the book begins. It's an interesting book. I think you all should love to read that
I
book.
will.
Yes, yes.
Because every day begins like this.
Today was exceptional. Lots of people moved memos right under the nose of the learned attorney general.
Yes, sir.
I had a difficult time shielding.
That's what it is. Yes, sir.
No, I need to do a bit of a masonry job.
Yes.
And do a bit also, because the other side said that the commission's walls have too many holes.
Yes, yes.
And so I do a bit of masonry job and then whitewash.
So-
So the whitewashing.
Covering everything.
Right.
Yes, sir.
If I'm trying to recapitulate the grievances of the petitioners, which runs broadly like this, there has to be a order under section 26(1) of the Competition Act for each party used to be added subsequently by the Director General. And then, yes. And then therefore, in the absence of such an order, quite a few rights, I think, are lost. Right to inspect files, right to cross-examine, right to provide exculpatory and contextual materials, and finally, an apply for a commitment under section 48B. Before I deal with each one of them, I think it's important for us. I don't say that like being cold to Newcastle. Important for I think the commission, since the Competition Commission is a sui generis body. We have too many regulators today to deal with economic pre-market and regulators in vastly different areas, from TRI to ERA, the Airports Regulatory Economic Authority, or SEBI for that matter. So we have each one of them operating in different fields, and for the competition law is designed in such a way that before the commission can come to the stage of holding an inquiry and extending all possible opportunities in order that somebody can defend themselves in due process of law, a pre-inquiry stage is also contemplated. In the pre-inquiry stage is where the Director General of Investigation comes in and gathers information, material, and puts it up in the form of a report before the commission. So this two-tier structure in the competition, you try to stop the investigation process or scuttle it on any ground whatsoever. Let me put it like that. Then the result is that the Competition Commission is not in a position to really find out where it can play its important regulatory role in the market. When you talk of the market, and today, who lays down the rules to be played in the market? If all of us are happy with the market players playing their own good roles, like on ethical ground, there's no difficulty at all. We don't need a regulator. So the regulator comes in because the self-imposed rules are probably very often absent. Therefore, the investigation authority plays a role to aid the commission in order that the regulatory role played by the commission is discharged efficiently and expeditiously. So the expedition part of it is equally important. You allow parties to play with the market and try to deflate the competition dimension in the market. Then the whole rationale of the raison d'etre of a competition commission being there is lost. So while we keep that in mind, in order that the way we interpret the provisions of the Act and give meaning to them where there's some hidden meanings that are available. So I think it's important to keep that larger picture in mind. And therefore, I think this is a second round, you also know, the second round when Amazon and Flipkart, first they came here directly.
Yes.
Now they allow somebody to shoot from their shoulders. So it is their alter egos or things like that. And so may I like President to paint a broad diagramical view of the statutory scheme.
Yes.
All the petitioners know that they are party to anti-competitive agreements. Only the difficulty, they don't want to acknowledge it. It is like a small annex story, like a case of a murder, and the defense attorney knew that the evidence was strongly against the accused. The only problem was the corpse was not found. He thought he could play with that. So he told the jurors, said that they were assembling. So in a few minutes, you will find the body, the dead person who we thought is dead, will walk into the courtroom. So everybody, the jurors looked at the door and said, well, probably it is something true. So a few minutes passed and nobody walked into the courtroom. And the jurors said, we are now need to go back to our discussion. And the defense attorney said, now that you are expecting that the dead body will walk in, I am entitled to an acquittal. You are all eagerly expecting to look at the door, somebody will walk in. So after a few minutes, the jurors came and said, guilty. And the defense attorney said, what's happening? You saw what I told you. He said, yes, we all looked at it, but the accused did not look at the door. And you know it's a story. Therefore, they're all looking at people who know the real story and then conjuring up something under what I would call rights which are not really available under the law. I'm going to make that proposition good. Let me give this diagrammatic speech.
Yes.
At the top, we have section 19(1)(a), the receipt of information. I'll take your lordship to a provision a little later. Then flowing from that, we have 26(1), where the commission forms a prima facie opinion that there is a contravention and directs the Director General to conduct investigation. And then at that point of time, according to us, parties do not have a right to be heard before the commission, nor the parties do not have a right to notice. Then when section 26(2), the commission forms an opinion and then there is no prima facie case, then the matter is closed. So one, if there is a prima facie case, the matter proceeds further. If not, it's closed. From forming of a prima facie opinion, then comes 26(1), 26(3). The DG conducts a factual investigation of the matter, directed to be investigated, and submits a report. We'll come soon to section 41 and regulation 41. If you look at section 26(3) capital A and 3B, there are some additional powers given to the commission and the Director General. Commission may require a supplementary investigation and report if found necessary. Then follow the next stage under section 26(4), read with the regulation 22. The commission gets the report, forward the report to the parties and calls for their objections and suggestions. At this stage, parties may submit all their objections, suggestions to the DG report on merits and substance, seek cross-examination, then adduce additional evidence if required, point out any other errors in the DG report or inquiry process. Then all these rights would also exist in respect of the supplementary report the Director General in respect of the process outlined below. Then we follow like this. If the DG report finds no contravention, the parties have provided their objection suggestion. Then, after hearing the party, the commission may close the proceeding if it finds there is no contravention. Then commission may direct the DG to further investigate, and the DG would then submit a supplementary report, which would be forwarded to the parties concerned to seek their objection suggestion. So let's go all over again. Your right to provide subjections and suggestion is also available at the second stage. So commission may carry out further inquiry itself and read with regulations also. But then another stage, if the DG report finds contravention, the parties have provided their objection suggestion. Then, after hearing the parties, if the commission finds a contravention, pass an order under section 27, that's the culmination. Or the commission may, if it thinks, conduct further inquiry if necessary. Then we go to the last stage. The commission shall, after receipt of objections, suggestion to the supplementary report, the commission may, after hearing the parties, if no contravention is found, then close the proceedings under section 26(9). And if contravention is found, then pass an order under section 27. If after conducting further inquiry itself, in terms of section 26(7) and 26(8), the commission then shall issue a show cause notice to the parties and provide a reasonable opportunity to the parties of being heard. After the hearing, if no contravention is found, then close the proceedings under section 26(9). The contravention is found, then pass an order under section 27. Therefore, there are multiple layers of opportunities where suggestions and objections and the need, if any, to provide for cross-examination, all those well-settled features of an inquiry are all available. Therefore, given the scheme of the things, now where will the court find? Where can the court find that we read into the act certain rights which are clearly, expressly available, and then therefore, if those rights at the stage of investigation are found to be infringed, the investigation either must be halted, or the commission cannot proceed further, or if the commission proceeds further, the commission will find it impossible because the deficiency in the so-called investigation report, the commission will find it a lot of handicaps in a proceeding further. So for whether the court will proceed on those lines or not is a question for consideration. A few dates, Your Lordship.
Yes.
Pick up from me too. We had a common list of dates handed over to the court. It goes back in 2019, 4th of November 2019.
Yes.
Lord should have that a common list of dates. Just give some more.
Sir, I don't want to trouble you, but I'll request one of your colleagues to give me those stuff.
Even I don't have it here.
Sure. Your copy.
Otherwise, I will go and do others.
Your copies of that.
Yes.
Yes.
Yes, sir.
You want a list of things? The common list of things given to the court.
I want to.
Madam. Okay, madam. ಇದು ಅಲ್ಲ ಇದೆಲ್ಲ ಜಡ್ಮೆಂಟ್ಸ್.
Not with the court.
You have it?
The list of dates.
No.
I thought it was. Yes, list of dates.
Have a copy of it? Dates copy.
Court Master, I'll hand over a copy.
Yes, sir.
4th of November 2019, Delhi Vyapar Mahasangh filed an information alleging contravention of section 3134 and 4 of the Competition Act by Seller Services Private Limited and Flipkart Internet Private Limited, with Amazon and Flipkart. Information was registered as a case number 40 of 2019 by CCI.
Yes.
And 13th of January 2020, CCA passed an order in section 26(1) of the Act directing the Director General to conduct investigation into the matter. And this order was passed against Flipkart and affiliate entities and Amazon and affiliated entities. The allegations in this note capture in the order para 6 so and CCA's findings refer to preferred sellers in multiple places. I'll come and explain it a little later. 11/6/2021, the High Court of Karnataka, through a common order, dismissed writ petition number so and so filed by Amazon and Flipkart challenging the 26(1) order. Then 23rd of July 2021, the division bench of the High Court of Karnataka dismissed the writ appeal filed by Amazon and Flipkart. 9th of August 2021, Supreme Court dismissed the SLPs preferred by Amazon and Flipkart, assailing the final judgment order dated 23/7/2021. Then thereafter, when that stage is over, 17th of August 2021, the DG began the investigation, got resumed notice in the section 41, read with 36(2) were issued to the Appario and almost all the other parties here. Then 25/4/2022, Director General filed an application, obtained a warrant of authorization from so-and-so to conduct search and seizure of race in respect of certain parties. Then 28/4/22, DG conducted a search that then we have in respect of those searches conducted, serial number 9, 1st of June 2022, Cloud Tile filed writ petition before the High Court of Delhi challenging the search and seizure. Then 11th of December, DG initially submitted a confidential and non-confidential version of the investigation report in a consolidated manner that pertains to Amazon platform and Flipkart platform. CCI directed the DG to prepare and submit separate investigation reports for Amazon and Flipkart. DG submitted on the 9th of August, submitted 2 separate investigation reports. Then 28th of August, CCI passed separate orders under 26/4, so-and-so in case of 40 and case of 40 so-and-so, and Amazon. And then on the basis of the findings in the respective investigation report, in case number so-and-so, CCRI 40 entities, opposite parties, including the original Flipkart. In case number 40, 2019 of 2, 13 entities were right as opposite parties, including the original so-and-so. Then 26th of September, Appario filed the writ petition and present writ petition. Several writs also filed also writ petition. That's how we are before the court. What's important for our purposes is the fact that 17th of August 2021, serial number 6, we have the Director General got going the investigation, which was directed by the Commission way back on 13th of January 2020. So this period was lost when Amazon, Flipkart went through all litigation procedures and lost till the Supreme Court. Now, having said that, I want to read the 26-1 order. Lord will kind turn please to this writ petition 26627, Appario Retail.
Yes, sir.
This is Annexure E
77.
at page 77, which was the order passed on 13th of Jan, 13/1/2020, which is a bedrock of the investigation for the Director General. And then our submission that this 26-1 notice is complete in all respects and does not require any further revisiting either by the Commission or by the Director General, as the case law shows that. Now let me quickly read this notice, this order.
Yes.
The information is given by Delhi Vyapar Mahasangh. That's in terms of section 19. Anybody can give an information. And again, whom are the information given? Flipkart Internet Private Limited and its affiliated entities, and Amazon Sellers Private Limited and its affiliated entities. And I think it's possible to not only look at this principle or idea of an affiliated entity in regard to in the company law sense. So anybody who is affiliated through an agreement, both in the company law sense or by anti-competitive agreement, they are all affiliated to these people. It's in that sense, I think, the notice and the order have been passed. The present information has been filed by so-and-so and all that. I skipped that and come to page 78. Facts and allegations stated, as stated, the informants members comprise many micro, small and medium traders which rely on trade of smartphones and related accessories. It is stated that many such traders regularly list their smartphones for sale. Online marketplaces take the benefit of online distribution channel. Flipkart having its registered office in Bengaluru is an e-commerce portal operating as a platform facilitating third-party sellers to sell their goods to consumers in online marketplace. Then paragraph 5, there is also about para 4 about Amazon.
Yes.
And para 5, the informants state that there are instances of several vertical agreements between Flipkart with their preferred sellers on the platform and Amazon with their preferred sellers respectively, which have led to a foreclosure of other non-preferred traders or sellers from these online marketplaces. It has been alleged that most of those preferred sellers are affiliated with or controlled by Flipkart or Amazon, either directly or indirectly. The informant alleged there is a clear violation of Section 3(4), read with Section 3(1) of the Act. Allegedly, there is an existence of various vertical arrangements between Flipkart with their preferred sellers on their platforms and Amazon with their preferred sellers on their platforms, respectively, which leads to a foreclosure of other non-preferred sellers from their online marketplace. These preferred sellers are also alleged to be affiliated with or controlled by Flipkart, Amazon, either directly or indirectly. Next page. Further, these platforms are allegedly capable of influencing prices being charged by sellers by providing several discounts as well as inventory in the form of so-and-so. The opposite parties are said to be both Flipkart and Amazon, including their affiliated entity. That's how they have to be read there. The opposite parties also gather data on consumer preferences and allegedly use them to their advantage. As per their information, the arrangements between Amazon and their sellers and Flipkart and its sellers respectively can be said to be in violation of so-and-so, which is an omnibus clause. The informant has alleged the OPs are involved in following practices which are anti-competitive in view of Section 3(1), read with Section 3(4) of the Act. Para 7.1, deep discounting. Flipkart provides a deep discount to a select few preferred sellers who are all before the court today, such as Ovintech Retail on its platform, which adversely impacts non-preferred sellers such as members of the informant from competing with such sellers on a Flipkart online platform. The informant alleges there is evidence in the form of communication from Flipkart to his sellers stating that it will incur a part of the cost during the big billion days and sellers and Diwali sales, etc. However, no such offer is available to other sellers who are unable to compete with such preferred sellers. Amazon has preferred sellers on its platform, namely Cloudtail, who is also before the court, a joint venture between Amazon and Catamaran Ventures, and Apparel Retail is also before the court, a wholly owned subsidiary of joint venture between Amazon and Mr. Ashok Patni, which received a round of investment from Frontier Business Services Limited, which are related to Amazon. Similar allegations of deep discounting by Amazon to detriment of non-preferred sellers have been leveled. Further, the fact that Amazon and those preferred sellers have the same contact details are also evidence of linkages between them. Moreover, Amazon has own private label brands which are sold only through these preferred sellers. Then Flipkart lends the word assured seller to the products sold by its preferred sellers such as Vision Star, Flashstar, so-and-so, and allegedly creates a bias in favor of preferred sellers to the detriment of other sellers. Besides receiving deep discounts, the assured sellers also received preferential listing on the website of Flipkart. I say all these are part of anti-competitive agreement. Pushing the results of non-preferred sellers further on the search results without any basis whatsoever. Amazon also reads the same thing in the next paragraph. Then 7.3, exclusive tie-ups and private labels. Both the OPs have several tie-ups and private labels, which get more preferences in terms of sales. The OP's private label brands sold through their platforms are routed through a few preferential sellers. It's submitted by the informant that his modus operandi is being employed by Flipkart across all categories, including smartphones, alleged that by having exclusive so-and-so with a smartphone company provides exclusivity to discounting and preferential listing. This leads to other competitors being excluded and foreclosed from the market. And who will take care of that but with the Competition Commission? It is stated that any benefit of the consumer is only an apparent at the initial stage till critical mass the network effects reach or comp is eliminated, as far-reaching consequences in the economy as the non-preferred sellers are relegated to sell only through traditional brick and mortar setup, which involves significant fixed costs and devoid of wide pan-India reach, which online marketplaces offer. It is alleged that Amazon and Flipkart are able to cross-subsidize because of the huge amount of funding received from their investors, which has resulted in incentives that allow price below cost on the platform through their sellers, resulting in creation of high entry barriers and high capital costs for for any new entrant in the market. Resultantly, the existing sellers find it difficult to launch their own portal or marketplaces in order to compete with the OPs. Now, kindly turn to page 80, page 81 bottom, para 10.4. Due to the huge market base and market power, OPs have large repositories of so-and-so with a large advertisement. And having said that, kindly turn to page 82, paragraph 12, or para 11. Based on the above, the informant alleged that Flipkart and Amazon have established an inherently anti-competitive model for e-commerce, which consists of providing deep discounts and preferential treatment to select people so-and-so and so-and-so. Para 12, it is thus prayed by the informant that an investigation be caused into the matter and the OPs be directed to cease and desist from indulging in anti-competitive activity and maximum penalty and will be imposed on the OPs. Then para 15. Then we come to paragraph 19 at page 83. The IT, it's talk about the huge, financial pickup, and then kindly turn to paragraph 20. On a careful perusal of allegations leveled by the informant and the documents provided, the commission note there are 4 alleged practices in the marketplace, namely exclusive launch of mobile phones, preferred sellers in the marketplaces, deep discounting, and preferential listing and promotion of private labels. I skipped number 1 for the time being. Let me come to page 85, paragraph 23. The informant is also alleged that Amazon and Flipkart have their own set of preferred sellers, and these preferred sellers have nexus with the e-commerce platforms, either by way of direct or indirect ownership or some understanding. It's observed that there are only few online sellers which are selling these exclusively launched smartphones either through Amazon or through Flipkart. Based on the evidence adduced by the informant and the information available in the public domain, it can be prima facie inferred that there appears to be exclusive partnership, exclusive partnership between smartphone manufacturers and e-commerce platform for exclusive launch of the smartphone brands. Thus, exclusive launch coupled with a preferential treatment to a few sellers and the discounting practices create an ecosystem that will lead to an appreciable adverse effect on competition. That's the index by which the commission will proceed to inquire. Then paragraph 25 on the private labels, etc. Let me read that. The issue of preferential listing should also be reviewed in conjunction with the foregoing. Competition on the platform may get influence in favor of the exclusive brands and sellers through higher discounts and preferential listing. Thus, the allegations are interconnected and warrant a holistic investigation to examine how the vertical agreements operate, what are the key provisions of such agreements, and what effects do they have on competition. Given that both the major platforms are stated to follow the same mechanics in terms of the exclusive tie-ups and preferential terms with brand sellers, competition between the platforms prima facie does not play a role in mitigating the potential adverse effect on competition on the platform. That's how paragraph 26 and 27 must be read. The commission observed that the exclusive arrangements between smartphone, mobile phone brands and e-commerce platform select sellers selling exclusively on either of the platform has demonstrated the information, coupled with the allegation of linkages between these preferred sellers and the OPs. We're looking at the linkage. So we talked about the affiliation part of it, directly, indirectly, the nature of affiliation, whether it's in the business sense, the legal sense, or in any other sense. Therefore, the linkages between these preferred sellers and OPs, alleged by the informant, merits an investigation. It needs to be investigated whether the alleged exclusive arrangements, deep discounting and preferential listing so-and-so, are being used as an exclusionary tactic to foreclose competition and resulting in an appreciable adverse effect in competition, contravening the provisions section 3(1) so and so. Now, therefore, what is to be investigated? The linkages, very important. How do you, then next paragraph. In view of the foregoing, the Commission is of the opinion that there exists a prima facie case which requires an investigation by the Director General to determine whether the conduct of the OPs have resulted in the contravention of the provisions of section so and so. And detail it. Accordingly, Commission direct DG to cause an investigation to be made into the matter, under the provisions of section 26(1) of the Act. The Commission also directs the DG to complete the investigation, submit investigation report, so and so. So what is the investigation is about? The investigation is about the matter and not primarily about the people. The people come in because the matter is important. So it is the focus said to be from President's point of view. So we are the focus. But I think what the
So this is an order.
conduct, is that a conduct?
Yes.
What kind of a conduct is that? And what kind of therefore I'm looking into a conduct which is reflected in the allegations, 4 allegations. So that is a matter to be investigated. And who gets involved into it? The linkages will certainly be unearthed in the course of investigation. So the unearthing of linkages is most important for understanding whether these 4 allegations really constitute the matter for investigation by the Director General. Having therefore laid out, you may read at this point of time section 19 for a minute, then go to section 26. This is how the inquiry under 26 gets triggered. Because an argument was raised that some under regulation 10. The competition.
Then I have.
Wait. This is a 2025.
This is also, yes. So get the latest book.
It is all the subsequent amendments came in 2023, 2024.
Yes. Good.
I think
Yes.
Competition Commission should print a barrack of its own with all the commentaries. Like many senior counsel do these days.
Don't look at that.
Section 19.
Yes, sir.
The Commission may inquire into any alleged contravention of the provisions contained in subsection 1 of section 3 or subsection 1 of section 4, either on its own motion, very important, either in its own motion,
Yes.
or on a receipt of any information in such manner and accompanied by such fees as may be determined by regulations from any person, consumer, or their association or trade association, or by a reference made to by the central government or a state government or a statutory authority, provided the Commission shall not entertain an information or a reference unless filed in 3 years, provided further so-and-so limitation. Then without prejudice to the provision contained in subsection 1, the powers and functions of the Commission include the powers and functions specified in subsection 3 to 7. In fact, regulation 10 as general regulations talk about how an information can be received by the Commission and how the Commissioner will act on the basis of the information.
Yes.
I'll go into that later.
Yes.
Now kindly turn to section 21.
Yes.
Where it's talked about reference by a statutory authority.
Yes.
Then comes reference by Commission. We come to section 26.
Yes.
On receipt of a reference from the central government or a state government or a statutory authority or on its own knowledge or information received under section 19, if the Commission is of the opinion that there exists a prima facie case, it shall direct the Director General to cause an investigation to be made into the matter. This is what the 26(1) order, 13th of January talks about. So as I said, it is made into the matter, provided so and so substantial same, and then come to, we go to the next stage. You can case law. I think. So when it asks the DG to hold an investigation into the matter, the commission is informed by its duties and function. What is the important so economic regulatory obligation cast upon the commission? Section 18 talks about the duties and functions of the commission. As I said, this is a sui generis body, and we have 135 years of history of the Sherman Act in US. And I was recently reading a lot of literature, and still the struggle between market and how market can be manipulated by keeping competition away. So that's probably even Adam Smith talked about it long ago. So the sui generis body like the commission plays an important role in a developing economy like ours. And if it is stifled at any point of time and its wings are clipped, I mean, what an important effect it may have on the regulatory dimension of competition in our country. So Section 18 is very important. Subject to the provisions of this Act, it shall be the duty of the Commission to eliminate practices having adverse effect on competition, promote and sustain competition, protect the interests of consumers, and ensure freedom of trade carried on by other participants in the markets in India. So how will the Commission go about discharging these duties? To eliminate practices, and how will the Commission determine what exactly in what circumstances there's an adverse effect on the competition, and how will you promote healthy competition? So it's, I think, entirely in the domain of the Competition Commission to find how, after having received a whole set of information and the report to the Director General, then how will it tend to promote act in discharge the duties under Section 18? I mean, it can't be charted out in any do and don't manner. It has to be left to discretion of the Commission, a wide discretion and a wise, mature way of doing it. Now, kindly turn to a few judgments I would like to place at this point of time on how the law has been settled on
this law, section 26.
Yes.
Procedure. Because the entire submission is foundationed on procedural aberration. Because in 26, in the 26 order that is passed now, there are only 2 persons as opponents. But while an order comes about which is impugned, there are many added. Now your suggestion is that no hearing is required at the stage of 26 to anybody. It's only a direction to render investigation.
That's the law.
That's what, direction to investigate into the matter.
Yes.
After investigation, if they have had an opportunity, that's enough, is the submission. Yes.
Broadly, that's a submission. That's why I said if it is a one-stage process under the Act,
yes.
If the Commission alone does everything.
Correct. The multiple stages where investigation is
Exactly.
directed. Yes.
And I think it will be important for the court to keep in mind that whatever the Director General does by way of investigation is not in the nature of a determinations.
Correct. It's a recommendation.
Nothing, he determines nothing. Determinations happen in the hands of the Commission.
Commission, that's what. The investigation is conducted, a recommendation is sent to the Commission. The Commission then conducts a detailed inquiry on it. The consequences would follow later.
And then wisely, of course, the law does not say the Director General report is binding on the Commission.
No, that's true. It's only recommended.
It cannot be.
Yes.
It cannot.
Yes.
I mean, no investigation report can bind any adjudicating body.
Correct. Commission directs the Director General to investigate.
Yes.
And submit a report. It's a report for the Commission to act upon later.
In fact, in the Mahindra case, the challenge was, there is a judicial and executive power are combined in the Commission. That would have been a very interesting argument. If the Commission wants to do everything, then we can.
The Commission doesn't do anything.
No. It comes in at a later stage when the Commission has something before it. Commission can find fault with the DG's report. A further investigation can be ordered by the Commission.
Yes,
the Commission can agree with the DG's report. So there are very wise ways of going about it. Therefore, the argument that we lost something very precious in the hands of the Director General, And that is final, conclusive, and the commission will be bound by it. I think it's not the way to look at the whole scheme of the act. Yes. And I will presently point out that when the commission, when the DG issues a notice under section 41 to all the affiliated other entities, the contents of the notice are revealing. So I'll deal with that a little later. Now let me go through
the law.
Where's my note? No. Is the sequence. The first judgment we have the sale judgment.
Yes.
Let's start from page 12, paragraph 5. And paragraphs 5, 6, and 8. I may have to read the judgment a little in extenso.
Yes.
And the overall intention of the competition law policy has not changed markedly over the past century. Intent is to limit the role of the market power that might result from substantial concentration in a particular industry. The major concern with the monopoly and similar kinds of concentration is not that being big is necessarily undesirable. We have too many of them in our country, all over the world, of course. However, because of the control exerted by a monopoly over price, there are economic efficiency losses to society, and product quality and diversity may also be affected. There is a need to protect competition. Primary purpose of the law is to remedy some of those situations where the activities of one firm or two lead to the breakdown of the free market system, or to prevent such a breakdown by laying down the rules by which rival businesses can compete with each other. That's what section 18 talks about. And the model of perfect competition is the economic model that usually comes to an economist's mind when thinking about competitive markets. As far as the objectives of the competition laws are concerned, they vary from country to country, and even within a country, they seem to change and evolve over the time. However, it will be useful to refer to some of the common objectives of the competition law. The main objective of the competition law is to promote economic efficiency, using competition as the means of assisting the creation of market responsive to consumer preferences. The advantages of the perfect competition are threefold: allocative efficiency, which ensures the effective allocation of resources; productive efficiency, which ensures the cost of production are kept at a minimum; and dynamic efficiency, which promotes innovative practices. These factors, by and large, have been accepted all over the world as the guiding principles for effective implementation of competition law. Paragraph 8. The bill sought to ensure fair competition in India by prohibiting trade practices which cause appreciable adverse effect on the competition market within India, and for this purpose, establishment of a quasi-judicial body was considered essential. The other object was to curb the negative aspects of competition through such a body, namely the Competition Commission of India, which has the power to perform different kinds of functions, including passing of interim orders and even awarding compensation and imposing penalty. The Director General appointed section so-and-so is a specialized investigating wing of the Commission. In short, the establishment of the Commission and enactment of the Act was aimed at preventing practices having adverse effect on competition, to protect the interests of the consumer, and to ensure fair trade carried out by other participants in the market in India, and for matters connected therewith or incidental thereto. Then the various provisions of the Act deal with the establishment, powers and functions, as well as discharge of adjudicative functions by the Commission. The Commission is vested with the inquisitorial, investigative, regulatory, adjudicatory, and to a limited extent, even advisory jurisdiction. Vast powers have been given to the Commission to deal with the complaints of information leading to invocation of provisions so and so, and exercise the powers 64, the Commissioners framed regulation called the General Regulations of 2009. Then next paragraph, the Act and the regulation framed thereunder clearly indicate the legislative intent of dealing with matters related to contravention of the Act expeditiously and even in a time-bound program, keeping in view the nature of the controversies arising under the provisions of the Act and larger public interest. The matters should be dealt with and taken to the logical end of pronouncement of final and orders without any undue delay. Now, almost 6 years have gone in this matter. In the very purpose or the object of the Act is likely to be frustrated, and the possibility Can I just read that then paragraph 30 at page 19? Though it was in the context of that case, it's important to look at two formulations set out in para 30. The following points for determination: whether the directions in exercise of prima facie opinion would be appealable. 2, what is the ambit and scope of power vested with the Commission under Section 26(1) of the Act, and whether the parties, including the informant or the affected party, are entitled to notice or hearing as a matter of right at the preliminary stage of formulating an opinion as to the existence of the prima facie case. Then we have 6. 4, at what stage and what manner the Commission can exercise powers vested in Section for temporary restraint order. Then whether it's obligatory for the Commission to record reasons for formulation of a prima facie opinion in terms of Section 26(1) of the Act. And then finally 6, what directions, if any, need to be issued by the court to ensure proper compliance in regard to procedural requirements, while keeping in mind the scheme of the Act and the legislative intent, and also to ensure that the procedural intricacies do not hamper in achieving the object of the Act, that is the free market and the competition. Then paragraph 31. This is how the court formulates the conclusions. Conclusion number, let's say, look at number 2. Neither any statutory duty is cast on the Commission to issue notice or grant hearing, nor can a party claim as a matter of right notice and a hearing at the stage of formation of opinion by the Commission in terms of 26(1) of the Act. And that a prima facie case exists for issuance of a direction to the Director General to cause an investigation to be made in the matter. How the Commission at page 20, second placitum, just with placitum A, the Commission is expected to form such a prima facie view without entering upon any adjudicatory or determinative process.
Para 89 to 91.
So in many sections, the word the Commission determines comes. So at that point of time, there's no determination or adjudication.
So the law is clear. Paragraph 89 to 91, Supreme Court says.
May then read paragraph 38.
The crux lies in 81 to 91, 89 to 91, I guess.
38 and 39 at pages 25.
Now, what the Commission does, you will find in what should it do rather, 87, 89, 91.
87, 89 to 91. We'll also make a note of 2 more paragraphs.
Yes, sir.
38 and 39, and also 125.
Yes.
Paragraph 125.
Yes.
Let me just, I thought of 38 and 39
yes.
are also read. Let me read
So
38 and 39.
You carry on, sir, no problem. In your own way, you can.
No, I just want to say that if this judgment propounds a certain understanding, and rightly so. How do you understand the Competition Commission Act and what all the commission can do and what the court may not do it on the view taken by the commission at the preliminary stage. And therefore, if the prima facie opinion, we had another case where, in the case of automobile, in Mahindra's case, the DG had some doubt. Should I not go and expand the inquiry and have more automobile, manufacturers brought into the investigation? The commission says you are not required. So once the motion is set in motion, you have all the powers to continue to investigate against any party and any person who may be found to be involved in an anti-competitive agreement or a practice or a conduct.
Yes.
With your permission, just quickly
Yes,
read
yes.
38 and 39,
Yes.
and then I go back.
Yes.
In page 25.
Yes.
In contradistinction, the direction under 26(1) after formation of a prima facie opinion is a direction simpliciter to cause an investigation into the matter. Issuance of such a direction at the face of it is an administrative direction to one of its own wings departmentally, and is without entering upon any adjudicatory process. It does not effectively determine any right or obligation of the parties to the list. In fact, I say there is no list at all at that stage. Closure of the case causes determination of rights and affects a party that is the informant. Resultantly, the said party has a right to appeal against its closure. On the other hand, mere direction for investigation to one of the wings of the commission is akin to a departmental proceeding, which does not entail civil consequences for any person, particularly in the light of strict confidentiality that is expected to be maintained by the commission in terms of section 57 and regulation 35 of the regulation. Wherever, in the course of the proceeding before the commission passes a direction or interim order, which is at the preliminary stage or of preparatory nature, without recording findings which will bind the parties, and where such order will only pave the way for final decision, it would not make the direction as an order or decision which affects the right of the party, and therefore not appealable. Therefore, what the commission does is not appealable within the scope of the act. I suppose what the Director General does in the course of investigation will not be subject to a 226 jurisdiction. So we still have to go through the process. If what the commission did is
That's how
not
the
appealable.
earlier orders were challenge was dismissed. It went up to the Supreme Court.
No, let me put it slightly in a different way.
Yes.
What is the Supreme Court wanting to, while laying down the broad foundation? Now, it talks about the intricacies. The intricacies can be said to be, say, all right, I have a set of rights, which the court say the intricacies. What kind of rights are they? Do you find them expressly stated in the law? I mean, I'm not talking about the principles of natural justice, which not be stated in a law.
Yes.
It's always available outside the statute.
Yes.
And but we're not talking about that natural justice, which can be read, which is probably sought to be made available in this case. We are talking firstly about those provisions which either expressly or implicitly talk about a set of rights.
It is like reading natural justice at the investigative process, which is not the law.
That's one. Well, how will the Director General go about conducting investigation?
No,
So I will read section 41.
There he will all opportunity.
There are several.
To a proceeding under section 26(1), there need not be natural justice.
Certainly not. That's a settled law.
That is the law.
I'll go further. Even the investigation that's being conducted by the Director General.
Even there, unless he forms an opinion and later comes back to the commission, till then also natural justice is not required, is what you're saying.
This is what I'm trying to
Yes,
point.
that's right.
Why would I say that? I mean, if the court may have to answer that question. 67.
Because whatever the DG submits,
60.
whatever the DG submits.
Yes, yes.
Is in the nature of an inquiry report, investigation report, or whatever.
Yes.
The commission will give all opportunities
We'll
to
take
those
stock of the whole
persons.
thing. That's right.
That's the submission.
That's right. That's what I'm trying to labor on that point. But there are very many fine, subtle nuances that can be brought into the act. Saying,
Yes,
no,
yes.
no. There I can read into section 41, all those rights. I'll read into regulations certain rights.
Yes.
So I'll try to answer each and every one of them. Kindly turn to paragraph 63 and 64 at page 33.
Yes, sir.
One of the parties before the commission would, in any case, be agreed by an order where the commission grants or declines to grant extension of time. That every such order passed by the commission would have to be treated as appealable as per the contention raised by the respondent before us, as well as the view taken by the tribunal. In our view, such orders cannot be held to be appealable within the meaning and language of section 53A of the Act, and also on the principle that they are not orders which determine the rights of the parties.
Yes.
No appeal can lie against such an order. Still, parties are not remedialist, as when they prefer an appeal against the final order, they can always take up grounds to challenge the interim order directions passed by the commission in the memorandum of appeal. Such an approach would be in consonance with the procedural law prescribed in Order 43, Rule 1A, and even otherwise of the Code of Civil Procedure. The above approach will subserve the purpose of the Act in the following manner. First, expeditious disposal of matters before the commission, and the tribunal is in apparent legislative intent from the bare reading of the provisions of the Act, and more particularly the regulations framed thereunder. Second, if every direction or recording of an opinion are made appealable, then certainly it would amount to abuse of the process of appeal. I think I only substitute Article 226. Besides this burdening, the tribunal with appeals against non-appealable orders would defeat the object of the Act as a prolonged litigation, harm the interests of the free and fair market and economy. Finally, we see no ambiguity in the language of the provision. But even if, for the sake of argument, we assume the provision is capable of two interpretations, then we will accept the one which will fall in line with the legislative intent rather than the one which will defeat the object of the Act. Paragraph 71. Then paragraph 68 at page 34. I know, I'm going to read that. In paragraph 67, around placitum D, however, the exclusion of the principles of natural justice is also an equally known concept of the legislature as the competent to enact laws, which specifically exclude the application of principles of natural justice in larger public interest and for valid reasons. Generally, we can classify compliance or otherwise with those principles mainly under these three categories. First, where the application of natural justice is excluded by specific legislation. Second, where the law contemplates strict compliance with the provisions of principles of natural justice, and default in compliance therewith can result in vitiating not only the orders but even the proceeding taken against the delinquent. And third, where the law requires compliance with the principles of natural justice, but an irresistible conclusion is drawn by the competent court or forum that no prejudice has been caused to the delinquent and the non-compliant with regard to an action of directory nature. The cases may fall in any of these categories, and therefore the court has to examine the facts of each case in the light of so and so. My submission is that this case falls in the last category. 71. We can go back to how 19 to 26 gets interlinked at page 35, paragraph 71.
Yes.
The intimation received by the commission from any specific person complaining of violation of section 348 with 19 sets into motion the mechanism stated under section 26 of the Act. Section, as already noted, require the commission to form an opinion whether or not there exists a prima facie case for issuance of direction to the Director General to conduct an investigation. This section does not mention about issuance of notice to any party before or at the time of formation of an opinion by the commission on the basis of a reference or information received by it, language of so and so, and for that matter, any other provision of the Act does not suggest that notice to the informant or any other person is required to be issued at this stage. In contradiction to this, when the commission releases a report to the Director General, not already taken a decision to close the case under 26.2, the commission is The commission
Yes.
is not only expected to forward a copy of the report, issue notice, invite objection or suggestions from the informant, central government, state government, statutory authorities, but also to provide an opportunity of hearing the parties before it, arriving in a final conclusion under section 26(7) or 26(8), as the case may be. This obviously means that wherever the legislature has intended that notice is to be served upon the other party, it has specifically so stated, and we see no compelling reason to read into the provision of section 26(1) the requirement of notice when it is conspicuous by its very absence. I only tried to expand upon this proposition and this observation to say that even when the Director General is calling upon a party to provide information to the Director in the course of investigation, he is not issuing a notice saying, I put you on the mat. Defend yourself. If you don't put you on the mat, then you can't defend yourself. That's not what the Director General is supposed to do. Therefore, if 26(1) stage, no notice is required, the Director General, all that is called upon to do under the Act is to collect information, gather them from all possible sources. So those who are involved in an anti-competitive agreement are also those sources from where you can collect this information. So the argument based on section 41 about opposite party and third party, I'll presently point out is a hollow submission. And then before I do that, 70, 78, 79. At page 37, can I read a couple of more paragraphs? 77, issue of a notice to a party at the initial stage of the proceeding, which are not determinative in their nature and substance, can hardly be implied wherever the legislature must be so specifically. This can be illustrated by referring to the custom tariff identification on so-and-so, rules 1995, custom tariff act, so-and-so, that while dealing with an application to be agreed on so-and-so, in all that, notify, and then come to talk about notice prior to initiation is what is talked about in these provisions. Then paragraph 78. Cumulative reading of these provisions in conjunction with the scheme of the Act and the object sought to achieve suggest that it will not be in consonance with the settled rules of interpretation, that a statutory notice, an absolute right to claim notice, and hearing can be read into the provisions of 26(1). Discretion to invite has been vested in the Commission by virtue of the regulation, which must be construed in the plain language without giving it undue expansion. Now, it's difficult to state as an absolute proposition of law that in all cases, at all stages, and in all events, the right to notice and hearing is a mandatory requirement of principles of natural justice. We'll kindly make a note of it. I'll come a little later. Regulations 40, regulations 41(5), regulations 43 and 44. I'll read them later to how we keep this in mind. Furthermore, the non-compliance therewith would always result in violation of fundamental requirements which shown so and so. Different laws are provided for inclusion of principles of natural justice at different stages, particularly at the initial stage. Such laws have been upheld to this court wherever such exclusions found a larger public interest and these for compelling and valid reasons. The courts have declined to entertain such a challenge. It will always depend upon the nature of the proceeding, the grounds for invocation of such law, and the requirement of compliance with the principle so in the light of the above provision. Now, paragraph 82. There's a reference to Maneka Gandhi, etc. in paragraph 82. I'll skip that. Paragraph
87.
87. 89,
9.
85, 86.
In fact,
86, paragraph 86.
entire ratio is in 91.
That's right. Paragraph 86, we may also notice that the scope of a duty cast upon the authority or a body and the nature of the function cannot be rendered nugatory by imposition of unnecessary direction or impediments which are not postulated in the plain language of the section itself. So I tried in vain to find out which provision casts what kind of a right which they have been very ably tried to point out before
86,
the.
no right to be heard. No doubt about it. Now, in fact, if you travel further, where Delhi High Court has held in the subsequent judgment.
Yes.
So I saw the entire thing now.
That's right.
So Delhi High Court holds, this is Ravindra Bhatt division bench,
Mahindra?
holds that
Kadila.
it cannot be restricted only to the parties that are present or opponents at the time of examination by the commission to direct investigation. It can include others as well. There you are bringing in that all these entities or preferred sellers who are affiliates, who are wanting to shoot from the shoulder of Flipkart and Amazon can be bought in. And the entire inquiry will be in the commission, nothing before that.
That's like the proposition that FIR
what-
is not an
That's
encyclopedia.
it. That's the Vin Chadda and
That's right.
Natwar Singh both.
I'll read a few more judgments to show how the Director General has expansive powers under the Competition Act. Let me conclude reading this judgment.
Yes.
Paragraph again 97.
87, 91.
87 I've read. Para 87, the court, the middle of that class item B, the court held the investigating power granted to an administrative agency is normally the inquisitorial nature. The scope of such investigation to examine the reference to the statutory power, proceeding so and so is neither civil nor criminal, but sui generis. Then paragraph 92. And also para 91, para placitum, after placitum D.
The entire 91, it completely lays down.
Just after placitum D. The function is of a very preliminary nature. Departmental does not condemn any person, and therefore application of adi alteram partem is not called for. As I stated, as I made a submission earlier, the same logic would apply to the Director General also.
Now, that's now clear with your submission. The Competition Commission, when it takes up an issue under section, a complaint can be filed under 19(1) or a petition can be filed. It takes up the proceedings under section 26. Under 26, it delineates what is necessary to be done, directs the Director General to investigate into the matter. Here, this is the first stage, no natural justice, because it is not determining anything, but only directing investigation. Now, when the Director General conducts investigation, it is akin to a preliminary report or an inquiry report that is to go back to the commission. So before sending back to the commission where it is only recommendatory, it is in the nature of an investigation report akin to criminal law, where the accused need not be heard at that stage. Now, when the proceedings are taken up before the commission, after the recommendations of the DG, then all the procedure of hearing or others, there the powers of the commission or the powers of the Director General is not restricted to only those two parties who was directed to be investigated. It's like saying investigation report, while filing a final report, can include other accused also into it. It is not restricted to whoever was in the FIR. So now while the recommendation is being sent, all others are being added. Then proceedings are now before the commission. Before the commission, every opportunity will be given. That's the sum and substance, I guess.
Your Lordship, please. Therefore, the final picture before the commission happens after we cross through all these stages. It's at that stage somebody will come and say, look here, my rights have been infringed by the commission.
Yes, by the commission.
By the commission.
Then yes, that is open to them to say.
And even at an interlocutory stage, if the commission says I'm not given opportunity of inspection, I'm not given opportunity of cross-examination, then of course, even at interlocutory stage.
So you mean to say there at intermittent intervals, they can definitely agitate their right before the constitutional courts, and not at this stage where it is at the threshold before the commission.
See, if at all a constitutional court were to be drawn into this discourse, there is very compelling reasons, both say by reading a provision of the Act, that this is so express, it doesn't warrant an interpretation at all. I don't find that the Competition Act provides for any such express rights the way it has been presented to the court. I'll deal with them before I close with the judgment. Right. This is the next one. South Asia. Actually, so Excel. Page 54. Show me that. In the next judgment, in the same, kindly turn to paragraph
26, page 69.
135 at page 54.
That's not needed.
No, in the same judgment, same.
Same judgment. Yes.
Same.
Mm.
Para 135 begins at page 53.
Mm.
I read B.
Conclusions.
134, the scheme of the act and the regulations framed thereunder clearly demonstrate the legislative intent, investigations and inquiries in the provision should be concluded as expeditiously as possible. The various provisions, regulations connect direct conclusion of investigation so and so within a reasonable time. Concept of reasonable time has to be construed meaningfully, keeping in view the object of the act and the larger interests of the domestic and international trade. In the backdrop, following direction need to be issued. Page 54, para B, all proceedings, including investigation and inquiry, should be complete by the Commission most expeditiously and while ensuring the time taken in completion of the proceeding does not adversely affect any of the parties, as well as the open market in purposeful interpretation of the provisions of the Act. Then, para 136, again, it is reiterated. That's how the regulations are framed about. So in as many as more than 6 or 7 places, sales says expedition. It's like a mantra.
Oh,
You can't close your eyes for the mantra of this act.
6 years have passed by. So, yes.
Which is the next one? South Asia.
That's
South
it, page
Asia,
69, para
we have
26.
Para 54.
54 also.
Say 1 minute. Factual matrix in the next judgment at page 57 can be just noticed.
Yes.
Paragraph 1.
Yes.
To the intra-court appeal impugn the judgment dated so-and-so of the learned single judge court dismissal and writ petition. The petition was filed impugning the order dated 1st July 2013, the respondent one Competition Commission, exercise the powers under 26(7) and referring back the complete complaint information filed by the respondent to so-and-so, Director General CCA for allowing respondent number 3 informant to cross-examine the witness of the appellant on the ground that the said order was passed without issuing notice to and without hearing the appellant. Summons issued to the witnesses of the appellant for cross-examination in person to the order of CCA were also impugned in the writ petition. Paragraph 26 at page 69. Kindly turn to page 69, paragraph
26. Yes.
The reasons given by the Supreme Court for holding that no notice or hearing is required to be given to the person enterprise informed referred against by the CCI before forming a prima facie opinion and directing investigation apply also to the stage under section 26(7) of the Act. The stage of section 26(7) is also an initial stage, which is not determinative in nature and substance. Further investigation is also a pre-cognizance stage. And that's the flexibility in the competition law. So issuance of a notice to the person's enterprise informed referred to at that stage cannot be implied. Besides, the judgment cited in so-and-so support the proposition that there is no difference between investigation and further investigation. Supreme Court said judgment relying on the dictionary meaning of further when used an adjective well further investigation to be a continuation of an earlier investigation and not a fresh investigation or re-investigation to be started ab initio. And just like secondly, just like section 26(1) does not contemplate any adjudicatory function, and the function that CCI therefore held to be of a preliminary departmental administrative nature with no person being condemned at that stage. I say even the DGI does not condemn anybody.
Paragraph 34 are the conclusions drawn.
Yeah.
Yes.
I just read it. Then paragraph. Just make a note of paragraph
34 also.
27.
27.
27 at page 70. Paragraph 32 at page 73. In our opinion, investigation includes all proceedings for collection of evidence, to form an opinion whether any law has been contravened or not. When inquiry is akin to prosecution, indicate after hearing the accuser, the opinion formed after investigation having been contravened is established or not. That's where the DG and the commission's stages enter into picture. Then, that's right. Next judgment. Excel. Lord, kindly turn to the next judgment, Excel crop.
Yes.
Paras 21. 18. 1 minute. Okay, I'll do it.
Forty-five, actually.
Can you turn to page 100, the issues which is framed by the court?
Yes.
10 point,
Yes.
2, whether CCI was barred from investigating the matter pertaining to the tender float with so-and-so because of the reason that FCI in his complaint or so-and-so given to CCI had not complained about this particular tender. Then whether in the facts of the case, conclusion of CCI had entered so-and-so and person so-and-so indulged in a collusive bidding resulting in contravention so-and-so is justified. That's how the issues are framed. Then we come to para 22. Yeah. No, before that. Also keep in mind how today we are living in such a globalized economy. So a small sneeze somewhere, I think has a greater ripple effect somewhere else. So page 107, they talk about the guidelines which the court notices in guidelines which are set out in the Asian regional guidelines and all that. Page 107, 22, 2.2.3. Just make a note of that.
No, this 10.2 at
Yes,
page.
para 22.
Page 100,
Page 100
10.2.
and, page 100.
That's the clause where whether the Competition Commission was barred from investigating the matter pertaining to the tender floated by so-and-so merely because it was not complained of. The answer is at page 45, before the issue 3 begins, that the hands of the commission is
117.
not restricted, or the DG is not restricted to what is complained of.
That's right.
Paragraph 45.
44, then
Page 119.
117, and then we have, although at page 117, page para 44 at page
Yes,
117.
Jurisdiction, issue
And then
2.
119 para 45. So para 44 says CCI at 117 had entrusted the task to DG after receive representation. The argument to the appellant is that since the communication did not mention about the 2000 tender of FCI, which is in fact even floated after the aforesaid communication, there could not be any investigation in respect to this tender. It's more so when there is no specific direction in CCI's order dated 24th of February 2011, and therefore the 2011 tender could not be the subject matter of inquiry. And when it is not referred to in the communication of FCI or order of CCI. All that it means to say is, what does the commission receive? I read section 19.
45, it is beautifully delineated.
Yes, yes. If the contention of the appellant is accepted, it would render the entire purpose of an investigation nugatory. The entire purpose of such an investigation is to cover all necessary facts and evidence in order to see as to whether there is any anti-competitive practices adopted by the person complained against for this purpose, adopted the person's complained against. And there can be many more,
That's exactly.
not only at the initial stage. So it's like an unfolding drama. For this purpose, no doubt, the starting point of inquiry would be the allegations contained in the complaint. However, carrying out this investigation, if other facts also get revealed and are brought to light, revealing that the persons and enterprises had entered into an agreement that's prohibited so-and-so and effect on competition, the DG would be well within his powers to include those as well in his report.
That's most important.
So the argument is, no, you cannot do that. Because he
Argument is
initially
that-
called as a third party. How can he change his mind? We have a right flowing from his designation calling us a third party, therefore that cannot be done. I'll presently point out that the argument is fallacious by even reading a reading of the provision of section 41.
Yes.
And then little later, in the DG at Placitum D,
Yes.
and direct the DG to conduct the investigation.
Yes.
At the initial stage, it cannot foresee
Yes.
and predict whether any violation of the act would be found upon investigation and what would be the nature of the violation revealed through the investigation. If the investigation process is to be restricted in the manner projected by the appellant, it would defeat the very purpose of the act, which is to prevent practices having appreciable adverse effect on the competition. I say the Competition Commission is the final word on what is the appreciable effect on the competition and how does it reach a conclusion. So therefore, the path is paved with the Director General providing all that necessary information which can come before him at any stage of investigation. So I tie his hands and say, first you must give an opportunity of cross-examination. You must first tell them what's your status, and they can keep quiet, the Miranda warning, so and things like that. Where will the DG go about? Kadila. Then the next judgment, Kadila, read paras 43, 44.
43, 44. Last two lines of 44.
Para 1.1, 11.
From there, yes. The CCI has not yet examined the investigation report in the light of
Paragraph
Kadila's
11 at,
all rights are available to it to argue on the merits are open.
Yes, para 11 at page 149.
Yes.
You also made a note of that?
Yeah, already.
Very well.
Yes. I've already
And at page,
seen
the
43,
argument
44.
advanced at page 150 bottom. About 6th or 7th line from the bottom. He highlighted that the initial prima facie order is premised on an assessment of certain preliminary standard of proof regarding the material discernible at that stage. However, the same yardstick would not be applied if the DG is authorized to carry out investigation into the conduct of other parties. That is shot down the court. 151. Yes, kindly turn to page 151, paragraphs 15 and 16.
Yes.
15 primarily. It's argued that the questions of jurisdiction or those issues that go to the root of jurisdiction and the exercise of power where CCI acts beyond the provisions of the Competition Act cannot be decided by the CCI at the time of final argument or later by the appellate tribunal. It is submitted the same has to be looked into by this court. Argued CCI is required in the law to form a prima facie opinion on each allegation in the information, and not only in each allegation, on every party will be found to be on the wrong side of the law by the DGI.
If I may disturb, this last four lines in
Yes.
page 150, just before paragraph 15. Further, in the absence of any material which is overseen by the CCI, would be to permit to it a roving inquiry which can be interdicted by judicial review. So unless the CCI examines everything, at the preliminary stage, there cannot be judicial review.
That's right.
Yes.
That's why it's underlined again in paragraph 15.
Yes.
And conclusion of the paragraph at page 150 bottom, going on further, last line. Counsel
Yes.
further argued
Yes.
that permitting the DG to proceed further in the absence of any material which is overseen by the CCI would be to permit to a roving inquiry, which can be interdicted by the courts in judicial review.
Now CCI oversees an investigation. When the investigation is on by DG, which is overseen by CCI, there cannot be intermittent judicial review at that stage.
That's right.
That's the,
And paragraph 16,
yes, sir.
it contended that basic unsustainability and formation of the order in the section 26(1) can only be argued before this court and not before CCI. The DG's notice dated so and so to supply information is vitiated. It's also clarified that CCI's order had not formed a prima facie opinion and consequently not by the prima facie order and so against Kadila. The DG's action in proceeding to investigate and to go beyond the order under section 26, if accepted as so-and-so, put to foreclose before the CCI during the final argument. That is the submission. One I'll come.
In fact, last 4 lines at just before para 45.
Just make a note of one more paragraph
Yes,
at page 156, para 29.
Yes.
Counsel urged that while carrying out the investigation, if the facts are revealed and bring to light information about concerns and organization or individual who enter into agreements or arrangements prohibit so-and-so, the DG acts within the power to include them in the report that he may furnish to the CCI. Then the further submission is on CCI's counsel.
Yes.
At the para 30 last line.
Yes.
According to him, the court should not interfere the CCI's order or the subsequent order so-and-so or relegate to Cadla to CCI to enable it to argue report by so-and-so was defective or illegal. That's a relegation submission. Now we come to 157. Page 157, the middle of that page, points of controversy. Whether the DG's investigation in the absence of a specific order having formed a prima facie opinion is vitiated, is the impugned judgment correct in upholding sound CCI so-and-so, any denial of principles of natural justice, rejection so-and-so, cross-examination, and so on. And DG could have issued notice to Cadela's officials under section 48. The court notices in extenso sales opinion at page 170, paragraph 43.
Yes. 43, 44.
Cadela's argument issue was inclusion of more than one instance of incident within the ambit of investigation is distinguishable, is in this court's opinion insubstantial and needs to be rejected. His reliance on consumer industries is no longer apt. At the stage when the CCI take cognizance of information based on a complaint, it does not necessarily have complete information on facts relating to the pattern of behavior that infects the marketplace. It's only when the information given to it, based on it, the DG is asked to look into the matter. Despite during the course of inquiry, based on so-and-so information, facts leading to pervasive practices that amount to abuse of dominant position on the part of one or more individual or entities might unfold. At this stage, the investigation is quasi-inquisitorial to the extent that the report given is inconclusive of the rights of parties. However, to the extent that evidence is gathered, the material can be final. Neither the DG's power limited by the remand or restricted to the matter that fall within the complaint, nothing else, then or else the Excel crop care would not have explained the DG's powers in broad terms. If other facts also got revealed abroad so-and-so, and entered into an agreement that is prohibited of section 3 with an appreciable so-and-so, the DG would be well within his power to include those as so-and-so. Then after the bracketed portion, the trigger for assumption of jurisdiction CCI is the receipt of so-and-so, commission the opinion exists prima facie case, the succeeding order, the administrative, however, that order, disclose application of mine should be reasoned. Up to that stage, and with the enunciation of law, no doubt, arguably Cadela could have said that absent a specific order as regards his role by CCI, the DG could not have inquired into his conduct. However, with the Excel crop care specifically dealing with the question of alleged subject matter expansion, in the absence of any specific order, Supreme Court clarifying.
Get a stool for him.
Not required.
Not required.
Not.
Which one?
Hands-on pain.
That's okay.
What is it?
He's saying stool for you.
I will use this.
Oh, there's another here.
Madam. Okay, put in.
The sheep's bed, that's it.
No, no, no.
Yeah. Yeah. Now you're fine.
That's very kind of you.
Yes.
Because when this happens, I want to take the lordship's leave and inform my esteemed senior AG. Generally, there are large language models of artificial intelligence to analyze big voluminous papers. But this court over time has brought in a natural intelligence for critically analyzing multiple volumes of papers.
I know, I've still not fallen a prey to artificial intelligence. ChatGPT is kept somewhere.
That's No, these judgments that you've now placed, of course, I've seen all of that.
I know, you lost it certainly. I mean,
I've
for
seen,
a
I've marked,
council-
whatever you're now saying, I've already
council,
marked and I've
when we
finished
try
it.
to read along with the court, we always think, probably beyond a little illusion, we always think that the court is going along with our thought
No,
process.
I'm going along with, no problem at all, but just to be ready to digest your submissions, I've just gone through the whole thing.
I'm glad, I'm so glad. Then we have few more paragraphs in this judgment.
Yes. In fact, paragraph
54.
44, if you see last 4 lines,
Para 44.
therefore, this court finds
That's right.
no merit in the argument to the procedure adopted by the DG in going ahead with the inquiry and investigating into the market behavior of so-and-so in any way affects it so prejudicially so as to tarnish reputation. CCI has not yet examined the investigation report in the light of Cadilla's contentions. All rights available to it to argue on merits are open.
So the entirety of the arguments
So
on the
if
other
it,
side
it does not go before the CCI, then no right is now prejudicially taken away, effective.
Will the court probably
Intervene or interfere.
receive and also swallow an argument that the DG has done so many wrongs that the commission will be blindfolded?
It's only recommendatory.
And the commission will be probably have a lot of limitations on the understanding of how will I go about the DG report. Is that all that is being cancelled in so many ways in these observations? 172. Yes, I read that. Just make a note of one more paragraph.
Yes, sir.
Yes, one I'll come. What? Here. In the previous page, page 171.
Yes.
This quote. Yes. Para 43, page 171. About 10, 12, 13 lines from the top.
Already marked.
First one, the sentence beginning, Cadilla in the opinion of the court is precluded. Specific order authorizing was a necessary condition. This court is further reinforced in its conclusion in the regard, but the express terms of the statute says takes of action by CCA directing the DG to inquire into the matter. I keep repeating this question, into the matter, right? At the stage, there is no individual. The scope of inquiry is the tendency of market behavior of the kind frowned upon in section 3 and 4.
Yes.
That's all right. In the paragraph, that's okay. Then, Grasim?
Yes.
Grasim. The next judgment, Grasim Industries.
Yes.
We can go to paragraph 27. Before that, a few background facts. Page 5, paragraph 5, at page 186. On 30th May 2011, information came to be filed with the CCI that all manufacturers of MFF, including GIL, had imposed anti-competitive restrictions on the Indian textile industry. GIL is a manufacturer of viscose staple fiber. 22nd June, CCA passed an order section 20 concluding that the aforementioned information prima facie disclosed violation section 334, etc. CCA therefore directed the DG to investigate the matter and to submit a report within 60 days. Paragraph 27 at page 195, analysis and reason. Before proceeding to consider the above submission, the relevant provisions of the Act are required to be referred to. The object of the Act is to ensure fair competition by prohibiting trade practices which have an adverse effect on competition in the markets within India. Focus is to prohibit anti-competitive agreements with subject matter so-and-so, views of so-and-so. Then we come to paragraph
36.
35.
35, 36 is again beautifully said.
35, 36.
As to what happens during investigation.
In fact, all is a further reiteration of sale and
yes, same.
And
49, it says the hands of the DG would not be tied.
And paragraph 36, last line.
Yes.
We are always fond of the word triggering, so therefore it triggers.
Triggers of the
Triggering an
investigation.
investigation. Then we come to paragraph 41, 42.
49, again, hands of the DG is not tied to examine other things.
Excel core is again, kindly turn to page 40, para 41 at page 204. Last four lines on the bottom of the paragraph.
Yes.
It was held that the language of the order passed by the CCI is broad enough to enable the DG to look into all the facts till the investigation was completed. So looking into the fact is what we are talking about. While looking into the fact, am I required to say that I am taking this fact which is supplied by you, but then the way you supply this fact depends on, I am calling you either as an opposite party or a third party. Therefore, there is something which is doubtful, which is not very clear. And if you had been called as an opposite party directly, or I want to steer clear of all this expression. In the Act does not talk about this for a limited purpose.
No, the
So
submission
assuming
was
there's
that
something called an opposite party,
natural justice should have been followed by the DG and all.
I will read section 41 as a duty casting provision and
Even
not a right conferring provision.
And para 54 of Grayson clearly holds what is the scope of 41. If you see para 54 at page 208.
208
of this division bench judgment.
Yes. 54.
What
yes.
is the purport of regulation 41? What should be followed?
Can determine the manner in which evidence may be adduced in the
Yes.
proceedings before them. The DG has also the powers to call for information, examine witnesses and documents. It is not mandatory that in every such investigation, the DG has to necessarily exercise all those powers. When I exercise them, what care and caution should I undertake? And if I don't exercise them, you can't say you must necessarily exercise them.
You can't force the DG to exercise those the powers under the provisions under section 41. If exercised, what should be there is what is said.
And then in a given case, not certainly in this case.
In a given case.
In a given case,
not in this.
the DG does something and then he doesn't give an opportunity to cross-examination. The commission is there to take care of that. It can issue all that material gathered by it. It will give a fresh opportunity of cross-examination before the commission and correct all those possible discrepancies that might.
Para 54.
Correct.
That.
And then it's not mandatory that in every such case, even the stage of investigation, the party will have to give an opportunity to adduce evidence, cross-examine persons who may have given evidence adverse to them in the course of investigation. So that's not the position that emerged in a collective reading of section 26 of the Act. That was regulation 2041 and 45 of the CCI regulation. Then para 57, the next page.
Yes. Scope and powers.
57 and 58, that's right.
Yes.
58 says, I don't concur with the learned single judge. Yes. There is a cross-examination opportunity was
You have
denied.
the judgment of the learned single judge? You don't have
This is Mahendra. Copy of the judgment.
That's okay.
Not now. We'll read later.
What's this? This is not a
There's
part
one
of-
more judgment to the
not a
Delhi
part of the
High Court
compilation?
on
Yes, sir.
para 75, page. The running pages. Very good. Small print. At page, top of each page, you have the running page.
Yes, page 54, para 75 are the
Issues needing determination.
Yes, para 75.
This court is of the view the issues involved in these batch of petitions are the following. The CCI tribunal exercising judicial functions, performing administrative and investigative functions, and also adjudication. So, 5, for the power exercised by the CCI to expand the scope of inquiry and notice in the section is an illegal and in an overboard manner.
Yes.
We turn to page 50, page 117, para 179. That is answering the question about whether it expanded the scope of
That is
inquiry.
issue number 5.
That's
That's
right.
answered at para 179.
Correct, para 1179.
Yes.
The petitioner had impugned the expansion of scope of the initial inquiry. The facts here that are based on the complaint by the informant supplementary material. CCI recorded its prima facie opinion, complaint needed investigation. DG conducted investigation, the allegation made the informant submitted the investigation report. DG report requested for permission to expand the scope of the investigation to include other car manufacturers. By the order of 26/4/2011, CCI expanded the scope of investigation being conducted by the DG to include the petitioners herein and certain other car manufacturers operating in India. DG thereafter issued notice to other car manufacturers, petition so and so and so. Then the DG, it's a few lines later.
Yes.
The DG's request for expansion reads as follows. In terms of CGA audit, so and so, I skipped those A, B, C, then para 3.
Yes.
However, in few of the facts, these practices may not be confined to these entities. The case involves larger issue related to the prevalent conduct of the players in the automobile sector. Now we are talking about a different sector.
Yes.
A sector we are talking about. So, and its implication on the consumers at large. It suggested that the investigation may not be restricted to the opposite parties mentioned in the order. Accordingly, it's proposed that the scope of investigation be expanded to examine the practices in the areas under consideration of all the car manufacturers in India, or so and so obtained. Then, para 181, the commission by its order dated 26 recorded as follows. Information was referred to DG on so and so. The DG with a night dated 19th of April had requested direction to initiate investigation against other car manufacturers. Investigation needs to be widened in this case. Then paragraph 4. Commission further observed that whenever a commission orders investigation in any case, it need not be confined to the parties mentioned in the information. The investigation is ordered on certain issue, and all the parties which are covered by that issue should be investigated. And there's no need to obtain the orders of the commission on each individual case. So that's what the DG has done in this case.
One clarification I would need, sir. If you see paragraph 198 of this judgment.
I'll come to that. One more paragraph at page,
Yes, yes.
page
Yes.
119, para 183 again. Third line, at that
Yes.
stage, the CCI decides to act on a complaint that the investigation does not always have so-and-so. One line later, it's only the information premised on that information, the DG is tasked to look into the matter. Therefore, looking into the matter is repeated in almost all the cases.
Correct.
That's how the focus should be.
Yes.
Right. Based on, so then we come to paragraph 184 also again. Para 183, last 4 lines, it talks about subject matter. 184 again, it talks about the matter in question. And at page 121, conclusion of para 184.
Yes.
Consequently, at
Yes.
top of page 121,
Yes, yes.
consequently, the argument that a specific order applying its mind into the role played by each of them was essential before the DG could have proceeded the inquiry is unmerited and is therefore rejected. Then we have paragraph.
There 27, constitutional validity of 27 was under challenge.
I'm sorry.
Constitutional validity of 27 was under challenge. While repelling that challenge, the Delhi High Court holds at para 198, it is constitutional, no doubt. Why of it is said, this clarification I want.
Para 198.
Para 198.
This court of the opinion, the Supreme Court felt compelled to say what it did. In each of the decisions in the long line of successive authorities, because the action taken by the executive government or the public agency was not preceded by a fair procedure that encapsulated any opportunity of hearing. Here, CCI
however,
followed all the steps indicated in the statute.
Yes.
The DG held an inquiry, the petitioner permitted to participation.
One pause there, sir.
Consequent reports and documents were shared with them.
One pause there, sir.
Yeah.
Here, however, the CCI followed all steps indicated in the statute. The DG held an inquiry during which the petitioners were permitted participation. The consequent reports and documents were shared with them, or they were given access to the record. So does this run in conflict to what submission of 41 that is now projected?
No.
Saying that there need not be participation of the opponent opponents at the time of inquiry by the DG.
No, nobody says they need not participate. Nobody's case that we have not participated in the inquiry.
No, the other.
The question of participation means, what do you mean by participation is the question.
That is what is said here.
So participation means I solicit information from you,
Yes.
right? And then if in a given case, I'm asking somebody else to give a material or a document or an evidence contrary against you, in that case, I will give an opportunity of cross-examination. So when it's not happened, the question is therefore, you must allege, here a set of materials collected behind our back, and we not given an opportunity of cross-examination when the DG said, I'm going to look at somebody else who is giving information to me, I'll allow him to place evidence orally and things like that.
That's all the clarification.
That's right. That's 198. Then 192. 192 for what? 1. Coming back to page 125, paragraph 192.
Yes.
Fourth line from the top.
Yes.
However, a deeper analysis of the nature of the proceeding before the commission would reveal that the procedure it adopts and is required to adopt gives sufficient safeguard to the parties likely to be affected adversely, both as regards findings and the sanction. First is, of course, there with the issue notice, Excel cropped, the later decisions have now conclusively, if the administrative does not contemplate prior notice hearing. Next stage is investigation by the DG. At this stage, the parties, whenever needed, receive notice and opportunity. If it is denied, they can seek direction to the DG from the CCI. At this stage includes evidence gathering and wherever necessary cross-examination on behalf of one or more individuals before the DG and later before the CCI if the complaint is that cross-examination is not granted. The next stage is the report to the DG, which is shared by the parties, who then make their comments and are granted full opportunity of hearing. This step is very significant because when the parties do address the CCI and some of the contention, they have foreknowledge of all the materials, including adverse materials and comments made in the DG's report.
Yes.
And this stage is, I say this having a foreknowledge of everything in the DG's report constitutes full compliance with any dimension of natural justice. This stage is a full-blown hearing when the parties know and have a fair awareness of the range of options available, the CCI in terms of findings and sanction, the forewarning as it were and statutory cap is a broad guideline within which both CCI and the parties therefore operate. In conclusion, yeah. That's right. Just make note of one more paragraph.
Yes.
207.
Yes.
Just to highlight how do you look at this law?
Yes.
Middle of that paragraph, in the light of the experience gained and the felt necessities of the change times, and having seen the experience gained by other nations in the course of so-and-so, the Act was introduced due deliberation. Recent decisions have emphasized the importance of CCI in imbuing the marketplace with a culture of competition and even underline that sectoral regulator decision or regulation cannot foreclose inquiry and consequent lack by CCI is overarching concern with respect to market domination and anti-competitive behavior of airing entities. And I quote Bharat Sanchar, and it's a very
Even para 208. 208.
Yes, Lordship.
208 also.
Of the judgment, yes.
Now the same, the rise in the tire. Sherman Antitrust Act.
Parliamentary effort to innovate and legislate new market regulations gained the light of so-and-so, later to enact the Competition Act. The rather on that, such laws is the objective of promoting competition, eliminating disparities that will ensue in the event of a market dominance by a few, resulting in concentration of resources of the nation. Then Article 39 against to resource of the competition. Subserve the common good.
Yes, that's object of the act. Conclusions at para 212.
Oh, no, huh? I'm just coming.
Yes, sir.
Which page is it? Page 138. In view of the findings of this court in the previous part of the judgment, the following conclusions are recorded and directions issued. 22 declared unconstitutional, 53 declared unconstitutional. Then all other provisions of the Competition Act were valid, subject to the following orders. The CCI shall frame guidelines with respect to the direction contained in 179 that they ensure that one who here decides is embodied in the letter and spirit in all cases where final hearings undertaken and conclude. That's because of the composition of the commission.
27, yes.
In that particular case, there was a, in other words, when final hearing completed, by so-and-so, members should not, we don't think so. Then D, the parties in all cases at the final hearing stage, under the argument taking into consideration the factors indicated and any other relevant factor, they may also indicate the written submission, no submission, why penalty should not be awarded, etc.
That's on the facts of that case.
That is my note. We have seen that what is the expansive scope and the nature of a 26-1 order. And we also seen that it's an inquiry into the matter. I suppose it's correct to say that a prima facie order is not for inquiry, is an inquiry into the matter, namely an anti-competitive conduct, and not with reference to any particular person who may be involved in that conduct. As I said, the unfolding nature of investigation may reveal more than one or perhaps none. We do not know. Therefore, you can't probably read any provision in a way to circumscribe or restrict the nature, the scope of the inquiry investigation by the Director General. Then may I just quickly read out a few propositions and then come to some submissions.
Yes.
The propositions run like this. 1 minute. So these propositions we color out from the case law we have
Yes.
set it out. I say the Competition Act is a socio-economic legislation with the object of curbing anti-competitive practices which causes harm to the free competitive process to the ultimate detriment of consumers, number one. And number two, the express intent of the Competition Act is the expedition of the inquiry dimension and determination in respect of the conduct which will be anti-competitive, and then interpretation and application of the Competition Act, and therefore subserve the express intent. And thirdly, parties do not have a right to be heard at the time of 26(1), and certainly the nature of participation in the course of investigation before the Director General is also limited to the extent the statute prescribes. Then next, prima facie order is the inquiry, I said, on matter, not about parties. And a prima facie order in 26(1) need not be all encompassing. It's, as I said, is only a trigger point. And so what can be unearthed will, as I said, comes much later. Therefore, what kind of powers the DG will have? And if the commission has certain larger set of inquiry powers, the DG is only an departmental aid and assistant to the commission. So will you say that the DG should conduct an inquiry consistent with all possible expansive dimensions of natural justice? And before you gather information from me, you must tell me, as I said, I want to put you on the mat, defend yourself. You can withhold information. Can anybody have a right to withhold information or materials? Probably not. Nobody has a right to withhold information. I understand the entire investigation powers conferred on the Director General is to collect, gather, unearth information from any source whatsoever. That's why in that context, Section 41 talks about.
Correct. That's the purpose of investigation.
Correct. Therefore, Section therefore talks about any other party in Section 41(3). It is not a combat between a party who will come under 41(3) and a party who is supposed to be drawn into the picture under 41(1). So I don't find the act contemplates two distinct classes of parties. Everybody is called upon to assist the Director General to provide information into a conduct and a subject matter of inquiry. And do you have any other rights in the course of investigation to the extent the act provides for it? Okay, let's take your lordship to section 41 for a minute at this stage. 41 in its amended form came later.
Yes.
In 2023.
Yes.
Though I would be tempted to say that 2023 amendments to the act will not probably go back in point
Cover
of
the
time.
petition that sprang in 2021.
2019 was the inquiry
2019, rather.
initiated.
Yes.
So you had the luxury of litigating that before 2023 came. Now for 2023, there's a history behind 41 amendment. There's the report of the committee which said why we probably have some kind of a clarity on that. I'll presently praise that report.
Yes.
But before I do that, if I am correct in reading section 41 the way I think I would like to read, namely keeping in mind all the propositions advanced. Now, why would you require somebody to be called a party under investigation? 41, I'm reading 41.
Yes, I'm at 41.
Prior to its insertion in the statute book in 2023, the previous 41(3) read like this. It referred to the Companies Act, provisions of the Companies Act. Hand over. Will the court have this?
We can pass it.
The pre-amended 41(3), if you will have the 2023 Act.
Yes, sir.
41 subsection 3 as it originally stood reads like this.
Yes.
Without prejudice to the provisions of subsection 2, sections 240 and 240A, so far as may be, shall apply to an investigation made by the Director General or any other person investigating under his authority, as they apply to an inspector appointed under the Act. Kindly also probably will also look into the provisions of the Companies Act for a minute. 239 and under the 2013 Act, it is section 217. Under the 1956 Act, it is 239 and 240.
Yes.
What the Parliament had in mind is an inspector under the Companies Act. We have the image of inspectors generally, you know. So the inspector in section 239, you also have that Companies Act.
Companies Act.
I just for a minute kindly look into section 239 of the 1956 Act.
Copy of 1956 Act.
Can you have? Do we have? We have the 239.
Power of inspectors to carry investigation.
You see? 239 is currently 216 and 217. Now I look at 239.
Yes.
Wherever it appears to the central government that there is a reason to do so, it appoint one or person, the inspectors, to investigate and report on matters relating to the company and its membership for the purpose of determining the true person. So all these subject matter of investigation. So any one of them or more than one of them. Also then 217, which is now 240,
Yes.
under 250 Act. So it shall be the duty of all officers and their employees and agents, including the former officers, employees and agents of a company which is under investigation.
Yes.
So that's what we're talking about in 241 subsection 3 as it now stands amended. So a company under investigation. So what is that they are required to do? Duty of all officers and employees, including so and so, to do what? To do all that. And A, B, C, and A and B under the original section 240. Therefore, as I said, I think I'm right in saying that instead of referring 239, 240, a legislation by reference, it has become a legislation by incorporation. So they brought in this dimension. So somebody is under investigation. So what is the duty of somebody under investigation? So if I don't tell you you are under investigation, you have no duty. So the duty is to do what? To preserve all this, preserve and to produce all information, books, papers, documents, records, and etc. And then clause B, to give all assistance in connection with the investigation to the Director General. That means beyond preservation, if I have any doubt in regard to your conduct, you must render such assistance to me. Then subsection 4 as now stand, the Director General may require any person other than a party referred to in subsection 3 means any number of persons who may offer an assistance information regarding that. So I don't think it is proper to.
That's how notice is issued by the DG to others, which they term it that they were third parties when information was sought. But when the impugned order is passed, they are drawn as.
I'll address it.
That is their submission.
I will address that argument.
Because
if I'm right
the
in
crux
saying.
is when you treat us as a third party, we do not have any opportunity. But when you bring in us as opponents while passing the final order, we have lost that opportunity that is perhaps there according to them.
I would only say a bit of linguistic jingoism
That's
here.
all. That's the submission.
If I am right in saying that this is a duty casting provision.
Yes, it's not a right generating.
Not a right conferring provision. It's a duty conferring casting provision. And merely because.
As you just now said, that the DG may want information. He will call information from everybody. Whether they should be opponents or not, it depends on the information that it receives. That doesn't mean they should be heard at that stage.
Suppose on the basis of an information provided by a person under investigation, I continue to use the word investigation.
Yes.
I get some material. Yes. I think on that material, somebody else can throw a light.
Yes.
And somebody else can throw a light. Can I prevent them? So therefore, it is not exactly the terminology of a third party in the sense the distinct line of demarcation between a party investigating and third party as propounded. I think it probably cannot fit in well with the scheme of the act.
So mere saying it is a third party would not mean that they would not be dragged into the web of proceedings later. It is only the drawing information. That information may lead to them being drawn is the submission.
Can I now straight away go to the notice issued by the DG to these people?
As a third
because I'm going to say that the use of the word third party in that letter is not determinate of anything in the DG inquiry.
If you just come to page 88, annexure F.
Yes.
Notice under 41.
Page 88, it begins.
It begins.
Whereas the Competition Commission, so and so, etc. The order of CCA can be accessed and so and so. Therefore, 26(1) order is brought to their notice.
Yes.
Is well within their knowledge. In this regard, certain information is required from you as a third party. Right. Now, I ask myself the question, what kind of information will you require from a third party? Somebody comes and select the Vyaparsan. I know they're engaging so and so got a preferred platforms. A third party may have a limited information with them. It's available from either whichever you are making it available. When you say the third party, what kind of information am I asking from you? Am I asking from you information which will reveal and disclose the kind of conduct you are into in the context of anti-competitive agreements? If that is so, then you are not exactly a person throwing light on somebody else's conduct.
Your own.
We are throwing light on your own conduct.
That's because at the second paragraph, you delineate what is that is required from a third party.
The following information and
Following
documents.
information. All this information that is required runs into several pages. After this information, a search and seizure takes place. The product of the search and seizure and this information that they have divulged is they are drawing them as opponents before the commission by the DG.
The information to which you are privy.
That is what.
You are the master of the information.
Here, it is not somebody else's information you are seeking. You are seeking information from this apparel retail or whatever it is.
You'll also look at the entirety of the information solicited here is nothing but information to which you are privy and on which only you can throw light.
Correct.
Only you can throw light.
Correct.
You say, I would have thrown light, but I would have probably thrown not that kind of a light if you had told me I am not a third party.
If only I had known that I would be drawn.
So
as
that
an
means
opponent.
I would have probably thought a bit before I would disclose what I need not disclose, and I'll disclose what I may disclose. Is a choice of disclosure with you? Or a discretion to say I will not disclose with you? Certainly not. So 41(3) begins saying a duty to do all those things. That's why it says a duty conferring provision, not a right conferring provision. If I read, I think paragraph after paragraph of this notice, it's all about what you are doing in the context of your.
Furnish as information.
For instance, page 89, last paragraph, subpara 8. Explain in detail your relationship with Frontizo business so-and-so, etc. and any other company, the Amazon group, and submit copy of agreements, if any, entered into with them. Vyapar Mahasangh will not supply that information.
So
A third party may or may not, they can't probably lay their
No,
hands on the information.
The complainant has only a complaint.
Yes.
The information is now by the DG, investigation is by the DG. So while in the course of investigation, he calls some information, which is permitted under 41.
Therefore, I'm not able to buy the argument. You gave me a very happy position by calling me a third party. Now you're disappointing me. The transition from a third party to a opposite party, I think, in fact, in the 26-1 order, Aparia was one of the parties.
It was
clearly
a party, yes.
And as we said, more parties are added because the DG find they are like bees calling into the bonnet. So it's therefore the test would be to read the notice and to find out whether how does the DG really understand his role in conducting an investigation. Give me that. Let me quickly again understand about 4 or 5 propositions advanced by the petitioners. One is, what are the obligations of the party during investigation? And in the course of investigation, has the DG violated any of our rights, namely a right of
No, that's already
and
judicially
right of
determined.
inspection? And
Judicially determines, no right.
and then strangely, a right against self-incrimination.
That also is covered.
I'm not sure whether competition law enters in the field of self-incrimination. Then I don't think any regulator can ever do their role at all. And then these are social, economic, statutes which have a certain larger object. And how do you frustrate them at every stage? And then let me address one more
This, in fact,
concern.
the
Right?
apex court interprets this very self-incrimination in Vijay Madan Lal Chaudhary while interpreting the provisions of the PMLA. Whether calling them and asking information would amount to self-incrimination while revealing the information. Supreme Court says it can be done. In that.
So assuming.
With this way back determined 1960 in a judgment that you.
I'll refer to that.
Yes.
I'll refer to that. So assuming that I have called you rightly as an opposite party or a party under investigation, will you then say you are asking me to incriminate myself? So where is the question of incrimination here? So then if incrimination has to be necessarily brought into the scheme of the act, I suppose the CCI investigation and inquiry will completely collapse. Because many parties will have said definitely have a conduct which is anti-competitive. So why should I admit my anti-competitive conduct? So anything which is anti to a social ordering, then you can bring it in self-incrimination aspect. I mean, will the court read? Will the court read that into that? And we know all from a long experience in this competition law, the markets, cartels are by and large secretive. Cartels do not, as I said, write things on their forehead for people.
Correct, that's there. Yes.
So if nothing can be seen, so how do you really unveil them? Let me address one argument before on the question of right to commitment. Only that section 48A and 48B. I have a twofold argument here.
Yes.
I'm just trying to the larger legal proposition. Some individual cases, some facts are there. I will try to rebut it later.
Wanting to refer to section 240 of the Companies Act.
Yes, I just read that. That
Yes.
is now 217.
217 now, 214 of the Companies Act.
No, I'm looking at 48 EB and the Competition Act.
Competition Act, yes.
Forty-eight A, 48B, 48 and few other provisions were inserted in April 2023? March 2024. 2024. Let me read these two provisions. 48 capital A. Any enterprise against whom any inquiry has been initiated under subsection 1 of 26 for contravention of subsection so and so may, for settlement of the proceeding initiated with the alleged contravention, submit an application in writing to the commission in such form and upon payment of such fee as may be specified by regulation. So let's say settlement is the nature of something akin to that, not necessarily close to that. So an application under subsection 1 may be submitted at any time, after the receipt of the report of the Director General. That means I know what is being put against me. And I don't want to get into an entanglement with the inquiry before the commission. I want to put an end to it. So then, on the basis of that, I make an application. The commission, subsection 3, the commission may, after taking into consideration the nature, gravity, and impact of the contraventions, agree to the proposal for settlement on payment of such amounts so and so, terms and manner of interpretation of settlement and monitoring as specified by the regulation. But we keep in mind now, these provisions again, how do we fit them in the larger context of a wide range and dimensions of our economic situation? We have goods, commodities, services, provisions of so many aspects in the economic system today. Therefore, if you try to read them narrowly, then we probably the reason why somebody wants to buy peas is kept out. If you read them too broadly, of course, another consequence ensues. Therefore, this report, I can come. But then the commission is not bound by the application. Commission may set in a proposal, settlement is agreed, settlement is not agreed, it is dropped. Now then come to commitment. And commitment is stands on a different footing. It doesn't necessarily entail a financial dimension, not necessarily, but can. Then any enterprise against whom an inquiry has been initiated under subsection 1 for contravention of subsection 4 of section so and so may submit an application writing to the commission in such form and so and so. Subsection 2, an offer for commitment under subsection 1 will be submitted at any time after an order under subsection 1 of section 26 has been passed, but within such time prior to the receipt of the report of the Director General. So this is buying peace in a different way. Now, which means the commission issues a notice, and I know for certain that probably I am in the net There's an anti-competitive agreement. I don't want to get into this issue again. I would probably say I would commit not to continue with my anti-competitive practice. Therefore, it's prior to the report of the DG. Before the DG collects materials from me, I don't want to share any materials. I don't want to be part of any inquiry, investigation. So I come here. Therefore, between settlement and commitment, there's a conceptual distinction. The one happens after the DG's report, the other happens before the DG's report.
Yes.
When they come into the statute book on 2024, obviously, I don't think they can fly back in point of time and be applicable retrospectively.
So the only argument about applicability is nothing had been finalized as on the date of the amendment.
That may apply as far as 48A is concerned.
That is after the submission of the report.
After the
of
submission, before 27 order is passed.
That's the submission.
So if in a settlement before 27 order is passed, matters are kept pending. That's why subsection 2 says submitted any time after the receipt of the report. But you can't read the same language into 48B. 48B precedes an investigation by the Director General. It is sans an investigation by the Director General. Therefore, you can't say, therefore, it's like Section 6, General Clause Act, matters pending, inconclusive.
So all submissions demolished.
So I'm not able to persuade myself that 48B should be extended to them. 48A may perhaps or not, we don't know. And then perhaps in cases which have been initiated after 6th of March 2024, well, of course, there is always a room for 48B.
Yes.
Always a room for 48B. Nobody can foreclose it.
So the procedure of settlement that happens prior to the submission of the report is not available. Light of the amendment
provision of commitment.
Is not available because of the
not
26th March 2024, I guess.
That's
the
right.
6th March, is it? 6th
6th
March.
March.
Yes.
It's not available. You can't by any stretch of reasoning read it retrospectively, retroactively, whichever way one would like.
Retroactive or retrospective, but the submission is that it's still pending. It could have been acted upon.
Our argument was not on retrospectivity or retroactivity. Our argument was that for a commitment threshold to kick in, it kicks in from a 26-1 order vis-a-vis.
That's what.
Prior to a.
No, we'll rejoinder you have anyway. Yes.
Therefore, from that context.
We'll see. Yes.
No. Therefore, my question is, if these are provisions which were contemplated by the Parliament at a given point of time, to probably infuse a certain element of flexibility in saying that why should we continue with certain inquiries, investigations, if parties come and admit their wrongs. So that's how this provision proceeds. So you don't want to admit you're wrong. Till now, you want to say I'm not in the wrong at all. Nobody prevented from saying, oh, let me work an application for the commission. Keep aside all these issues. I'm making an application to the commission. You have not finally determined anything so far. Please consider for this 48B commitment. You know that you want to have a game in the court and then try for possible throw a, yes, I know. So therefore, I don't know whether 48B can be extended by any logic and reasoning. And this is that argument seems to be a little hypothetical. But as far as settlement is concerned, of course, that's an open question.
Yes, that's there.
Somebody wants to have a settlement. Yes.
That is after the report of the DG.
And then subject to all those
The
niceties of a
rigorous
settlement.
there. Yes.
So you'll have to pay some money. You'll have to say, I will not do
subject
that.
to
I will do
rigorous
this.
there. Yes.
Right. So it's not that you can easily ask for a thing merely for the asking. There are a few more aspects I thought I need to deal with on the regulations, which have been extensively read out. I may require a little more time to rebut some fact-related arguments that the Lordship will give me. And
You can fix another date.
yes.
All right. Whenever you want. At your convenience.
Which date? February itself. Not too long. Then, no, I have some.
How long will you take? Well, ಮತ್ತೆ rejoined.
And after the learned age finishes, one of you must request a date.
20th. Correct.
One date,
That's,
everybody will finish.
that's what. Probably I'll fix a Saturday.
I only seek short amendments.
Wait, let the Attorney General finish. Wait. Yes.
Will,
After the attorney
Wait,
general-
wait.
will 20th February suit?
Any day is fine with me.
Right.
If you want it on a Saturday also, I'll
I-
ask
I-
the permission of the Honorable Chief Justice and sit.
The 20th is a Friday or even 21st Saturday. if
No
you want.
problem, sir.
21st Saturday.
Absolutely. No. Sitting day, is it? Then we'll fix it on 21st. Yes.
21st.
21st is a working
21st.
Saturday.
Ah.
We'll fix it on that.
All right. Very
That should, I think that day, submissions from
I can
your side
conclude.
could be
I
over.
can conclude, yes.
Yes. Then one more Saturday for, whether it's working or non-working, one more Saturday. So that the other judicial work. Shall we do that?
Very
sir?
well.
Yes. Heard the learned Attorney General. The learned Attorney to hear the learned attorney further, list the matter on 21st February at 10 a.m. We'll start at 10 a.m. Yes.
Grateful to you, Lordship.
Yes. Thank you. ಆಮೇಲೆ ಒಂದು
But I think your Lordship must read that book.
I will, I will definitely, I will.
Abdul's, just Robert
Sorry
Satter.
if I have stopped you from, because I
No.
went through the judgments, then just thought I should,
Just Robert Satter.
that I'll do, sir. Yes. That will, the interim order subsisting in all these cases shall stand extended till the next date of hearing. So 20th, 21st, sir, then 28th or any other day.
Yes,
28th is also a working day, I guess.
28th is a working Saturday.
We'll see.
21st Saturday, no?
Even if it is not, yes.
Yes.
28th will finish.
21st Saturday.
ಒಂದು ವಾರ ಸಾಕಲ್ಲ.
28th, is it?
Yes.
Not the 28th, maybe a week thereafter.
All right, 5th March. That
Once,
was.
which day?
No, 21st is good.
21st is fine, sir.
Very good.
21st is fine. For the rejoinder submissions,
Very good.
either it is on 28th or the 5th of March, we'll see. Yes.
Very good.
Yes. Interim orders as subsisting today shall continue till the next date of hearing in all these cases. Yes. Yes. Come to the regular list. You wanted to say something? Sorry. Yes.
I only wanted to mention I'm appearing for R3 in this matter.
I know the complainant.
So we are only
Pramod Nair appears, right?
in the Amazon matter only.
Amazon matter.
He is arguing. So I'm only seeking that we may be given 15 minutes after he finishes.
Definitely. Don't worry about it.
Pramod Nair is also.
That's all. That's all you wanted to say. Fine.
Okay.
After the learned attorney finishes on 21st. 21st he would finish.
Yes.
You finish whatever you want on that day. Be ready, that's all. Yes.
Okay.
Fresh matter still number 2.
Pass over. Grounds of arrest.
Grounds of arrest, my lords.
ಯಾವಾಗ ಆಗಿರೋದು ಅರೆಸ್ಟ್? 9/10/25. Where are the records?
My lords,
Where are the records, sir? Grounds of arrest ಕೊಟ್ಟಿದ್ದೀರಾ ಇಲ್ವಾ? It's UAPA.
ಕೊಟ್ಟಿದ್ದೀವಿ.
Is it UAPA?
UAPA matter,
Then grounds of arrest ಕೊಟ್ಟಿದ್ದೀರಾ ಇಲ್ವಾ?
37 minutes. And 6 days.
Not 37, get the records.
I'll put it.
The petition projects that the petitioner is arrested without furnishing the grounds of arrest as is held by the apex court in the case of Mihir Rajesh or Vihan Kumar prior to that. The learned HCGP submits that the grounds of arrest have all been furnished, which are appended to the petition itself, and nothing more need be furnished to an accused prior to taking him into custody, even under the provisions of the UAPA. The records ಕೊಡಿ. list the matter on Monday in the fresh matters list. Let me see this. Yes. Next.
Number 3.
Yes, Samir, what is this? Maintainability? Ah.
Insofar as maintainability is concerned, Lordships may recall had produced a judgment of the Honorable Supreme Court in Naveen Chandra.
Maintainability overruled, right?
Insofar as another objection, office objection was concerned, it was overruled.
Yes.
Insofar as maintainability was concerned, it was not overruled.
What is the?
If your Lordships were to please see, had filed a memo on the previous occasion.
Correct.
Producing a judgment of the Honorable Supreme Court in
Naveen
Naveen
Chandra Manche, yes.
Yes. Now, what I would seek to present to service insofar as that judgment is concerned is the litmus test to see as to where jurisdiction lies is not where the FIR is registered, but where the cause of action arises. Now, there is a concurring opinion in that judgment as
Justice
well.
Narendra.
Sorry, Your Lordship.
Justice Narendra has written.
Please, and there is a concurring opinion of Justice K.T. Thomas as well.
Yes, correct.
Please.
So that's in Naveen Chandra itself.
That's in Naveen Chandra. So therefore, the litmus test is where does the cause of action arise? Now, if your Lordships were to please see my petition papers for a moment, page 38. The entire substratum of the offense is in Bangalore. The sole allegation is.
What is the allegation here?
The sole allegation is that there was a business transaction, business relationship that went sour. The contention of the respondent number 2 is that I asked her to introduce me to certain hotel entrepreneurs.
No, you don't worry about the maintainability. Come on, merits.
Please, on merits, insofar as merits is concerned, Lordship may please come to page 38. This is the complaint, the impugned complaint.
Before in Uttar Pradesh.
In Uttar Pradesh.
All right.
I wish to inform you that the above mentioned so and so, that is the petitioner, has associated in business for several years with my husband so and so.
You are in Bangalore, is it?
I am in Bangalore. The entire business operation is in Bangalore. This hotel that they're referring to is Kailash Parbat. Your Lordships are aware, different chains across Bangalore.
Kailash Parbat. Kailash Parbat, I'm aware.
Insofar as the restaurant is concerned. So therefore, recently due to certain reasons, some disturbances have arisen in the said business. Taking advantage of the situation, she so and so, that is a petitioner, has been exerting undue pressure upon me to introduce him to prominent hotel entrepreneurs. In addition, he has been unnecessarily making basis allegations and counter allegations against
That's all right. That is the allegation.
That is all. And on this, a charge of section 351 of the BNSS has been attracted.
351 is 504.
351, yes. Criminal intimidation.
506.
So therefore, my respect for submission on merit says this is purely a business transaction, civil nature given a criminal color.
We'll see.
Now, if you're
come to the allegation.
Yes, allegation is at page 38.
No, you just now read out.
Yes.
Page 38.
Yes.
I wish to inform you, mentally distressed. Whom are you harassing, saying that divulge the information?
No, it is the contention of the respondent number 2, that is one Chaitra V. She says that I have been exerting mental duress all because of a business transaction. Now, if your Lordships were to please see the date of this FIR for a moment. Now, this is registered.
Samir, where do I get the date?
Sorry, Your Lordships.
Where do I get the date?
Lordships may please come to page 35. 35, it is registered on 7/8/2025.
All right.
Now, what I want to point out to your Lordships just for a moment, could your Lordships please come to page 109.
Yes.
This is a share purchase agreement that the parties entered into.
Which party?
That is that is the petitioner herein and the husband of the respondent number 2. That is at page 109. Now that, if your Lordships were to see, is executed on 3/9/2025, which is almost a month after the FIR is registered. Now, by virtue of this, I sell.
The learned counsel Samir Sharma appearing for the petitioner. The office has raised an objection qua maintainability as the crime is registered in Uttar Pradesh before the Anand Nagar Lucknow Central Police Station. The learned counsel would submit that the issue qua maintainability stands answered by the judgment of the apex court and that of this court. The issue of maintainability thus stands, we'll keep it open, wait. Issue of maintainability would be decided at a later point in time. The complainant in the case at hand is a civil servant hyphen an officer of the Indian Administrative Service in the Lucknow cadre, in the Uttar Pradesh cadre, in the Uttar Pradesh cadre. A crime comes to be registered against the present petitioner, projecting that the petitioner has indulged in the offence of section 351 within bracket 2 of the BNS, which is section 506 of the earlier regime, the IPC. The crux of the complaint is that the petitioner is asking the complainant to divulge certain details about hoteliers. It is ununderstandable as to how this could become an offence under section 506 of the IPC, as section 506 of the IPC or section 351 of the BNS would require the ingredients as found in section 503 to be met, which is ostensibly absent in the case at hand. In that light, further investigation into the crime shall stand stayed only against the petitioner. The added circumstance that the learned counsel would project is 1 month after the registration of the FIR, the husband of the complainant enters into an agreement with the petitioner on certain business transactions. If that be business transaction, on all the aforesaid reasons, further investigation shall remain state keep. The issue of maintainability will be decided at a later point in time.
Can I just point out one more thing? In all transparency, I had filed a memo before the office unwittingly and unwarrantedly saying that it bari 226 agbeku anta. Now there is a circular that I came to learn of later on, passed on the administrative side of this honorable court, which says that when you are challenging an FIR, it has to be read
here
with
only.
250.
You can't GM alla.
Yes, so therefore,
So don't worry about that.
ಆ
Yes.
memo na not press ಮಾಡಕ್ಕೆ ಇನ್ನೊಂದು ಹಾಕಿದ್ದೀನಿ. Just want to bring it to lordship's notice.
ಎಲ್ಲಿ ಮೆಮೊ ಇದೆಯಾ ಇಲ್ಲಿ?
It is on your lordship's file. That memo that was
The learned counsel for the petitioner seeks to withdraw the memo that he had filed before the registry with regard to placing the matter before the court under court hearing petitions under Article 226 of the Constitution of India. Yes,
I'm great.
memo is withdrawn. Next.
Number 4.
For petitioner matter.
PDF ಅಲ್ಲಿ ಇನ್ಕಂಪ್ಲೀಟ್ ಪೇಪರ್ಸ್ ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ.
PDF ಅಲ್ಲ.
ಹೌದಾ, ಅದರಲ್ಲಿ ಸರ್ವ್ ಮಾಡಿ ವಾಟ್ಸ್ಆಪ್ ಮುಖಾಂತರ ಮಾಡಿದ್ದಾರೆ. Only 19 pages has been
ಕೇವೆಟ್ ಹಾಕಿದ್ದೀರಾ?
No, my lord, the advocate has been served through the WhatsApp.
ನೋಟಿಸ್ ಆಗಿತ್ತಾ?
ಹೌದು ಸ್ವಾಮಿ. ಇಲ್ಲ ಸ್ವಾಮಿ, ಡೈರೆಕ್ಷನ್ ಇತ್ತು to serve on the advocate in the trial court.
Oh, trial court. All right. What's the
pages has been
what's the problem?
My lord,
138.
My lord,
138.
138 proceedings.
evidence ಮಾಡಿದ್ದಾರೆ.
I appear this petition is filed by the accused, my lord.
Obviously.
Wherein section 445 application of evidence act is rejected for referring the contents of the check to the handwriting expert.
Please show me the check, sir. It's not appended to the petition?
No, my lord.
Why?
My lord, order. I'll present it.
Where is the check?
It's there, my lord.
ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ದಾರೆ ಸರ್.
Wait, sir. ನಿಮ್ಗೆ PDF ಅರ್ಧ ಕೊಟ್ಟಿದ್ದಕ್ಕೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಿದ್ದಾರೆ. ವೇಟ್. ಇನ್ನು ಫುಲ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ರೆ. What is wrong with this, sir?
My lord, in my cross examination, my lord, page number 21.
Why it should be referred to a handwriting expert, sir?
My lord, in the cross examination, he says that the accused himself has written the check, but it's not my handwriting, my lord. And my contention is that the check was signed under duress, my lord. That is under
That's on merit of the matter.
force.
This need not be referred.
And I had also, my lord.
Reference under 45 is only when the court fails under 73. All right?
My lord, he himself admits, my lord.
His admission Allah. Court exercising jurisdiction under 73 should have a doubt with regard to the signature, then only 45. 45 is not a right for you to seek reference every now and then. Anything else, sir?
My lord, contents of check, my lord.
No, sir.
Regarding the handwriting.
Anything else?
Nothing.
Nothing else. ಏನಿಲ್ಲ. ನೀವೊಂದು ವಕಾಲತ್ ಹಾಕ್ಬಿಡ್ತೀರಾ?
ಹಾಕಿದ್ದೀನಿ ಸರ್.
ಯಾವಾಗ?
On 19/1.
All right, yes. Dismissed.
Yes. In the cross examination, he is admitted, my lord, that I had written. By my contention is I have not written.
You will get acquitted. Don't worry. That is the case. But this check does not warrant any reference. See, under section 73, it is open for the magistrate to consider whether there is a problem in the check or not. In any handwriting, whatever it is. Once he considers that, fails to decipher if that there is a problem or solution, then refer it to 45. It's not your right to seek everything to 45. Both you and the court should concur.
Yes, ma'am.
ಇಲ್ಲಾಗಿಲ್ವಲ್ಲ ಅದಕ್ಕೆ dismissed.
But
Yes. ನೀವು ವಕಾಲತ್ 4 weeks time to file ಅದು ಹಾಕಿದಾರ? Yes, next.
And this is a petition wherein
This is the petition.
challenging this search and seizure, my lords.
AG ಅವ್ರ ಜೊತೆ ಇದ್ದಾರೆ, ಒಂಚೂರು ಪಾಸ್ ಓವರ್ ಬೇಕಿದೆ ಅಷ್ಟೇ.
Puppies tours.
Correct, my lord. That's the partnership firm, and then item 6.
To transport puppies?
No, my lords. It's a tour and travel firm, my lords.
Tour and travel.
And then, my lords, item 6 is the partner, one of the partners. So, my lords can take up item 6. I'm requesting for some interim orders, my lords. And I can briefly explain, my lords, the issue. Just few minutes.
ಕೇಳ್ತಿದ್ದಾರೆ. 2:30. 2:30 ಬರ್. 2:30. Then what's the problem?
My lords, the hearing, because the hearing will be concluded, I'm getting the notices from the
Where will
from
it
the
be
adjudicating authority, my lords, because our challenge
this attachment ಇದು.
it's a search and seizure. They have in the garb of search and seizure in closed cases, my lord, predicate offences completely closed on the date when the ECR was registered. All predicate offences.
There's one more affair which is there.
Then subsequently to the search,
one
my
more
lords,
affair which is
same
there.
case, my lords.
Lords,
All I'm saying,
This ECIR springs from which FIR? Number ಕೊಡಿ. Which FIR?
4 FIRs, all closed, my lords.
4 FIR.
No, my lords,
All
there
closed.
is one more affair
Admittedly.
which gets.
Admittedly, in their own application, they admit that all are closed.
Once foundation goes, where is the
Lordship,
superstructure?
there is one more affair which is registered.
When?
In Bhopal.
When?
I'll produce those documents.
Subsequently.
But that is appended, and we have added addendum to the ECIR.
That's where I'm unable to digest.
No, that is that
where
is-
you can go on adding offenses to, or
That is
go on adding, you update your ECIR.
My lords, my only submission is
My lords,
not only with respect
22nd
to these
July.
cases, not
Sorry.
only with respect to these cases, my lords. Well, there is no concept of each ECIR for each FIR. I think my friend also would accept that.
No.
Now, the reason is, Lordship,
So, one Madhur, one ನಿಮಿಷ. Now, 10 FIRs are registered.
please, Lordship.
Based on 10 FIRs, you draw an ECIR. 10 ECIR ಬರ್ಬೇಕು ಅಂತ ನಾ ಹೇಳ್ತಾ ಇಲ್ಲ. 10 FIRs are there. Now, those 10 FIRs get closed by a manner known to law. Now that ECIR will have no independent legs to stand, because you have premised that ECIR on 10 FIRs. Those 10 FIRs are not there. Now you find out that there is one more FIR registered somewhere in the country. So now you want to, that ECIR which has lost its life, you want to breathe life into it by saying I will update it.
That is how that, because that's an internal document for us. In such a case, Lordship, we will be more happy, Lordship, because each FIR will have each ECIR. In such a case, they'll be at a.
That's why I said 10 ಮಾಡಾಯ್ತು. ಇನ್ನು 11th ಎಲ್ಲೋ ಒಂದಿದೆ ಅಂತ ಮತ್ತೆ.
That is how, because what the issue is, the Lordship, addendum can be added to the ECIR as and when a
ಅದು
predicate
ಒಂದು
offense.
ಕಾನೂನು ಕೇಳ್ತಾ ಇದ್ದೆ ನಾನು ಅವತ್ತು AG
ಇಲ್ಲ, the judgment ಇದೆ.
ಒಂದು
judgment ಇದೆ.
judgment, ಒಂದು provision of law
Please,
that you can go on updating your ECIR.
In fact, my lords, in this very case, on 22nd July, original ECR gets registered based on 4 FIRs, all closed. On 21st of August, they register an addendum. In addendum, they include 2 more FIRs. Now, in those 2 FIRs, one is again closed. The other FIR, there is a B report which is yet to be accepted, and that's the sole FIR. And on that day itself, when the addendum is entered, within few hours, they conduct the search. And the amount in that FIR is 30,000. I am not named in either of them. Interestingly, no summon.
It were to have been
Not.
No, ಆ ತರ if money trail leads to the.
My lord, the predicate offense says it's closed. B report. Only FIR is B report, and that too for 30,000.
It's not yet accepted, my lords. My
Not
instructions are
from
that
2022,
it's not yet
some
accepted.
FIR is.
Now, in every case, ಇನ್ನೊಂದು ಯಾವ್ದ್ರಲ್ಲ 1,200 rupees, 30,000 rupees. Why ED is entering into this?
No, my lords, the issue is, Lordship, what I will submit is, it's not, my lords, I completely agree. There is a complaint which has been given for 30,000 rupees. That's a predicate offense. Now, my lords, under PMLA, Lordship, we will see whether there is a predicate offense or not with respect to that section. It is there. So we will initiate an ECIR and we'll conduct the investigation. Now, my lords, police will conduct an investigation so far as that is concerned. We will see what is emanating from that crime. That may be hundreds of crores. So
No problem. Fair enough.
please,
But you get life from a predicate offense.
please, Lordship,
Predicate offense goes.
please, Lordship.
You still think you can live and do anything?
Then what happens, Lordship? Addendum gets added to the ECIR. And my lords, ECIR is not a dead letter. It stands in law.
No, I'm not saying it's a dead letter. It takes birth only on a predicate offense.
in such-
You tell me, independent ಆಗಿ ಒಂದು ECIR you can register ಅಂತ ಹೇಳ್ಬಿಡಿ, ಬರಲ್ಲ.
ಅಲ್ಲ, ಹಾಗಲ್ಲ.
ಇದೆಯಾ?
Lordship,
ಕಾನೂನಲ್ಲಿ provision ಇಲ್ಲ.
if what my friend were to argue like that, we will be more happier because each FIR will have each ECIR. That's not the, that's not it is.
Better.
No, then we'll be more happier because every
May I
time
say
we'll have
this
to
what
fight
my
it for
learned
each
friend is
ECIR
saying?
in such a case.
May I say this, my lords? A cheats B for, let's say, 10,000 rupees. Now, A has cheated B for 10. Now, 5,000 he keeps in his pocket, he doesn't launder that. 5,000 he may ask some financial expert and launder it in some manner. Can you say that the cheating is for 10,000, but laundering will be for 10 lakhs?
That's what
This case, what they say that it is the tip
No,
of the
that,
iceberg.
no. See, that's what, that 5,000 you said cheating, alla?
Correct.
That may be the trigger point of 50 lakhs.
Tip of the iceberg, my lords.
My lords, but there has to be, then it runs contrary to the Vijay Madan Lal. The Vijay Madan, it has
What
to
I'm
be
saying,
connected.
that's what I'm saying.
The
See,
nexus has to be there.
Whatever now you are wanting to do, the other case or this case, that runs directly, or runs foul of
Exactly,
Vijay
my
Madan
lord.
Lal.
We will
That's the whole
demonstrate-
problem.
Therefore, my lords, there is a
Honorable
provision
Court, where
called section
lordship-
66 in PMLA, which says,
66 is only giving information to the competent
Correct, my
authorities
lords.
for registration of an FIR.
and that's where Vijay Madan Lal says, under 66, you find that prima facie there is some schedule
66
offense.
will not give the enforcement directorate to register
Correct,
an ECIR.
correct, my lord.
It is only an information to be given to
Therefore,
other
they will
authorities.
supply that.
Now, there are other, say, Lokayukta or other police, whatever, they can always give information.
Exactly. Now, what can happen, as my lords have rightly pointed out, let's say they find out for 50 lakhs. They will report it to the local police. Local police, if registers and the schedule offense is established, then they get the
Now, one
jurisdiction.
moment. Now, in this case, there is no information given.
Nothing.
So, there is no FIR registered pursuant to their information.
Correct, my lords.
Now, what they are saying is, there is a 11th FIR found in the 11th hour.
After search.
Whatever, found in the 11th
Findings
hour.
of the search cannot, is not.
I'm challenging the search.
No.
On
my
that
lords,
day, there was nothing.
Let's, if I may submit in point of law, my lords, search may be questioned, but then the findings of the search still exists. Point one. Now, point two. Now, ECIR, there is one more FIR which is registered. So are they telling us that you can go for another search? I don't know.
My
The
lords-
findings of the search will remain.
So I'm not challenging the finding. All I'm saying, you did not have reasons to believe on the day when the search was conducted.
Act I will
no
not-
reasons to believe.
See, reasons to believe or grounds on grounds of arrest, we will not.
My lord, that's one point. Secondly, my lords, under 8 subclause 1, when the adjudicating authority issues the notice, they have to pass an order under section 20 subclause 2. That's the retention order. They have not passed that order also, my lords.
There is here.
Since the AG was here, I thought after.
No problem. 2:30 ಗೆ ತಗೊಂತೀನಿ. I just wanted to know what is the,
No, there's some
predicate
discussion.
offense ಎಲ್ಲ ಹೋಗ್ಬಿಟ್ಟಿದೆಯಂತಲ್ಲ.
He'll leave at 2:30. Till then, Lord, I thought I should be.
No, please, no issues.
I
was
can
just-
make one request if the
I was
learned
just
ASC
questioning Madhu to elicit answers.
if learned ASC agrees, my lords, let them continue with the season. I'm not asking today, my lords, because the matter requires the elaborate argument from both sides. All I'm saying is let the proceedings before the adjudicating authority be stayed. Let the Caesar continue.
I oppose.
There is no prejudice
any
to them.
form of
The
interim
Caesar
writ,
is
Lord.
anyways
I am
continuing.
questioning the maintainability of the writ petition. Lordship may hear the learned counsel for the petitioner as well as.
I have heard.
2:30.
ನೀವು ಮಾಡ್ತೀರಾ 2:30?
2:30.
ಇಲ್ಲ ಇನ್ನೊಂದ್ ದಿನ ಬೇಕಾ? ನೀವು ಹೆಂಗಾಗುತ್ತೆ ಹಂಗೆ?
Caesar continue. I'm not saying this. Let the Caesar continue. Only authority proceedings I'm asking for.
2:30. 2:30.
Fifth,
we are-
that will come.
No, unless he wants some time.
No, my lords, I do not. My lords, learned
I
ASC,
can make my
can't-
submissions at 2:30.
You want time?
No, my lords, my lords, I have no problem. Subject to the convenience of the learned ASC.
2:30.
2:30.
We'll see. If time is needed, we'll take.
Very well.
If both of you don't want and I want, we'll see. Yes. 2:30. Sorry to disturb you. You were there, I guess. Yes. I was asking Madhu, what is it? 2:30 ಗೆ ತಗೊಂತಾ ಇದ್ದೆ. Yes.
Admission seal number 7.
For withdrawal. Learned counsel for the petitioners moved the matter seeking withdrawal of the petition.
I appeared for respond number 2, Your Lordship.
Any objection?
No.
Thank you. Withdraw the petition. Petition disposed as withdrawn. Next.
Grateful, Your Lordship. Interim orders operating, Your Lordship.
Operating. We'll
Respondent
vacate
is
it. We'll vacate it.
No, my lords.
Yes.
My lords, civil offense, the allegation, my lords, is cognizance is taken on.
Correct, sir. B report is rejected. Cognizance is taken. Issue is purely civil in nature. I will
Purely
pass a
civil
detailed
nature.
interim
Yes.
order. Yes. Amale. Heard the learned counsel appearing for the petitioner awaiting the representation of the counsel for the respondent Venkatesh Doderi. Place this matter on next February 10th. 11th, sorry, 11th. 11th for admission, IO till then. Gotatal madam. IO till then. Yes.
9th.
Dilip Kumar. Same order, 24. Same order, same day.
Connected
Yes.
matter is there, my lord. It
Put
can
it,
be-
tag along with so and so. Next.
10, 14%. Prakash.
Madam, I am 14% in this case.
ಅದು ಗೊತ್ತಾಗುತ್ತೆ. ಆಮೇಲೆ
I have challenged the charge sheet in CC number 679 bar 2024 pending before the honorable principal civil judge Malur Mala.
ಆಯ್ತು, come on 10th. List the matter on 10th. Interim order subsisting will continue till the next date of hearing. ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ interim order. Interim order ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ.
Yes, madam, interim order.
ಅವತ್ತು ತೀರ್ಮಾನ ಮಾಡುವ.
Two cases are there, my lord.
11 also.
2:30 ಬೇಕಾ?
Two cases are there, my lord.
11 also.
11 also.
Same, both cases, same day.
12,
Same interim order continues.
12.
We have to petition, my lord, matter pertains to PCP entity, my lord. Lordship has already quashed the
Identical
cases, my lord. It's already reported. Lord, there is no allegation.
Where's judgment?
It's already, it's in the file, my lord.
We'll have to follow this and close it.
Yes, my lord.
ಇದು
There are
report
three
ಆಗಿದೆಯಲ್ಲ,
cases.
ಎಲ್ಲಿದೆ?
Reported judgment.
ಮತ್ತೆ ಇದು ಕೊಡು. ಎಲ್ಲಿದೆ ಜಗದೀಶ್?
There is no allegation of sex determination, no sex selection, no sex determination, no female feticide. There is no allegations. My lord, that the very act has been enacted to curb the sex selection, sex determination, the female feticide.
ಅದಕ್ಕೆ ಸ್ಟೇ ಕೊಟ್ಟು. Same day, same IO.
There are three cases.
10th admission, ಮೂರು ಇದೆಯಾ ಇಲ್ಲಿ? ಮೂರು. 11th, sorry, 11th.
Cyclostyle. ಎಲ್ಲ same complaints.
ಆಯ್ತು ಎಲ್ಲ.
13.
May please, my lord. That, my lord, the challenge is to the successive FIR, my lord, in relation to the same cause of action, please, my lord. Earlier, an FIR was registered, and that, my lord, a B report was also came to be filed after investigation, please, my lord. Against which, please, my lord, a protest petition was also filed and it was pending for consideration. In the meantime, the de facto complainant has approached now the police station, I mean, Kadugodi police station, and filed a fresh FIR on the same cause of action. And therefore, the parallel proceedings in respect of the same cause of action is an abuse of the due process of law, please, my lord. The Supreme Court has held in umpteen number of judgments, please, my lord.
Namkina.
Umpteen number of judgments, please, my lord.
All right, ಕೊಡಿ.
Wait, para 8, please, my lord.
He said umpteen, you must at least know one.
Yes, ma'am.
We'll quash
My
it.
lord- My lords, I'll just file my statement of objections.
How
ma'am.
long,
What's my
sir?
habit?
For
After
2
a week,
years
ma'am.
you have not filed. Last time you were not present.
I was not present.
Yes, sir.
I'll just file my statement of objections. Cause of actions are different for the.
Different. First FIR you have page.
May I take my lord's attention to page number 35. Wide annexure E, please, my lord.
ಒಂದೇ ನಿಮಿಷ ತಾಳಿ ಸರ್. FIR ಎಲ್ಲಿ ಸರ್?
Annexure D, page 32, please, my lord.
This is the first FIR, huh?
Yes, please, my lord.
176/2020.
Yes, please.
Now
my
come to the second FIR.
lord. Now, please come to page number 20, please, my lord. The issue is in relation to a site bearing number 31 and 32 measuring to an extent of 30 into 50 square feet, please, my lord.
Offense is forgery.
Yes, please, my lord.
All right. First 506 420 ಇತ್ತು.
ಅದು ಇದೆ.
ಅದ್ರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ.
ಅಲ್ಲ, ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ದಾರೆ.
ಬಿ ರಿಪೋರ್ಟ್ ಯಾವ್ದ್ರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ?
ಅಲ್ಲ, ಈ ಸೆಕೆಂಡ್ ಕೇಸ್ now it is stayed. In the first matter, in the first FIR, B report has been submitted and pursuant to which a protest petition has also been filed by the de facto
What
complainant.
happened there?
That is pending, still pending for consideration. May I take my lord's attention to the relevant portion in the order sheet, please, my lord. Kindly turn to page number 50.
Come to page 27, unnumbered paragraph, last 7 lines. ಶ್ರೀನಿವಾಸ್ ಮತ್ತು ಬಾಲಕೃಷ್ಣ ಅವರುಗಳು ಮೋಸ ಮಾಡುವ ಉದ್ದೇಶದಿಂದ ಹಣ ಪಡೆದು ಯಾವುದೋ ನಿವೇಶಗಳನ್ನು ತೋರಿಸಿ ಶುದ್ಧ
Same allegation, please, my lord.
ಗೊತ್ತೇ ತಕ್ಷಣ ನಾನು ಅವರ ಹತ್ತಿರ ದಾಖಲೆಗಳನ್ನು ನೋಡಿದಾಗ ನಿವೇಶನ 31-32 ಮಾರಾಟ ಮಾಡಿರುವ ಶ್ರೀನಿವಾಸ್ ಸೋ ಅಂಡ್ ಸೋ ಶ್ರೀಮತಿ ವಂಜನಾ ಅವರಿಗೆ ರಿಜಿಸ್ಟರ್ ಏನಿದು ರಿಜಿಸ್ಟರ್ ಕನ್ಫರ್ಮೇಶನ್ ಡೀಡ್ ಬರೆದು ಕೊಟ್ಟಿರುವ ಸಂಗತಿ ತಿಳಿಯಿತು. ಈಗ ಹಳೆ ಕಂಪ್ಲೇಂಟ್ ಹೋಗಿ
Please, my lord.
ಅದೇ ಸಂಗತಿ ತಿಳಿದಿದೆಯಾ?
May I take my
ಬೇರೆ
lord's,
ಸಂಗತಿ ಏನಾಯ್ತು?
may I take my lord's attention to page number 35.
35.
Second para, from where the relevant allegations.
ಶ್ರೀನಿವಾಸ ಖಾತಾ ಮಾಡಿ ಕೇಳಲಾಗಿ 6 ತಿಂಗಳೊಳಗೆ. ಈಗ ನೀವು ಇವ್ರ ಹತ್ರ ದುಡ್ಡಿಸ್ಕೊಂಡಿದ್ದೀರಾ?
ಅಲ್ಲಿ ನಾನೇ ಸೇಲ್ ಡೀಡ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೊಟ್ಟಿರೋದು.
ನೀವು ಸೇಲ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ದೀರಾ?
ಹೌದೌದೌದು. I don't deny that fact also. No civil suit is filed in respect of this particular issue is concerned, please, my lord.
You are the vendor.
Yes, please, my lord.
All right. Now what is the problem of the complaint?
The problem is that the site was not identified as per the purchaser, please, my lord. The confusion is in respect of identification of the property, please, my lord. That, my lord, it's
We show him whatever you have given.
certainly, please, my lord. And if he file a civil suit also, please, my lord.
You leave the civil suit. Now you go with him.
All right.
Show which are the properties that you have sold. Site number 31, 32 ಎಲ್ಲಿದೆ ಅಂತ ತೋರಿಸ್ಬಿಡಿ. ಅವರೇ ಎಲ್ಲ ವಿಡ್ರಾ ಮಾಡ್ತಾರೆ.
Please come to page 39, please, my lord.
ಇಲ್ಲಲ್ಲ ಸರ್, ಅವ್ರಿಗೆ ತೋರಿಸ್.
No, I'll point out. But this is particularly
ಪೇಪರ್ ಇರೋದಲ್ಲ.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ನಾನು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ರಿಪೋರ್ಟ್ ತೋರಿಸ್ತೀನಿ ತಮ್ಗೆ.
ಒಂದೇ ನಿಮಿಷ. ಈಗ ನಿಮ್ದು ಸೇಲ್ ಡೀಡ್ ತೋರಿಸಿ. ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ರಿಪೋರ್ಟ್ ಎಲ್ಲ ಬಿಡಿ ಸರ್. ನಾವು ಸೇಲ್ ಡೀಡ್ ಎಲ್ಲಿ ಇವ್ರಿಗೆ ಮಾಡ್ಕೊಟ್ಟಿರೋದು?
Please, my lord. In page number 81.
81 na?
No, that's an agreement to sell. Sorry, my lord.
The absolute sale it is at page 90.
Yes, please, my lord. Sorry.
Who is the complainant?
ವೆಳ್ಳಿಯಮ್ಮ.
ವೆಳ್ಳಿಯಮ್ಮ. ಆಯ್ತು. ಈಗ ವೆಳ್ಳಿಯಮ್ಮ absolute sale deed ಮಾಡಿದ್ರೆ ಸೈಟ್ ನಂಬರ್ 33 ಆಯ್ತಾ?
Page 103, my lord would get the site schedule.
ಸೈಟ್ ನಂಬರ್ 33 ಅವ್ರಿಗೆ ಕೊಟ್ರಿ.
31 and 32, my lord.
ಕನ್ಫರ್ಮೇಶನ್ ಡೀಡ್ ಯಾರ್ದು? ನಿಮ್ಮ ಹೆಸರು ಏನ್ ಹೇಳಿ?
ಅಲ್ಲ, ನಾನು
ನೀವು ಎ ಶ್ರೀನಿವಾಸ್.
Yes. ವೆಳ್ಳಿಯಮ್ಮ is the owner. I am the power of attorney holder for ವೆಳ್ಳಿಯಮ್ಮ.
ಇರ್ಲಿ. ನೀವು ಕನ್ಫರ್ಮೇಶನ್ ಡೀಡ್ ಮಂಜುಳಾಗೆ ಯಾಕೆ ಕೊಟ್ರಿ?
No,
ಮಂಡಿ ಸೇಲ್ ಇವ್ರಿಗೆ, ಕನ್ಫರ್ಮೇಶನ್ ಡೀಡ್ ಇನ್ನೊಬ್ಬರಿಗೆ. ಈಗ 31, 32 ಎಲ್ಲಿದೆ ಅಂತ ತೋರಿಸಿ.
That is not in respect of this particular site, confirmation deed.
Sir, ಈಗ ಸೇಲ್ ಡೀಡ್, ಈಗ ಐಡೆಂಟಿಫಿಕೇಶನ್ is the problem.
Of course.
Correct. You go with him, identify those 2 sites that you have sold and get him back.
Certainly, please, my lord.
If it is not identifiable, you have played fraud with them.
No. The important point is that
ನೀವು legal point ಬಿಡಿ, we will come to that later.
All right, my lord.
ಈಗ ಕನ್ಫರ್ಮೇಶನ್ ಡೀಡ್ ಯಾರಿಗೆ?
ಅಲ್ಲ, confirmation is in respect of other property.
ಕನ್ಫರ್ಮೇಶನ್ ಡೀಡ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಆಗಿರೋದು 2023 ಅಲ್ಲಿ. ಸೊ ದಟ್ಸ್ ಅ ನ್ಯೂ ಕಾಸ್ ಆಫ್ ಆಕ್ಷನ್. ಅದು ಬೇರೆ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಸೈಟ್ ನಂಬರ್ 31, 32 ಅಲ್ವಾ ಇದು? ಹೌದಾ ಇಲ್ವಾ?
Please examine annexure M also.
Examine. What examine?
Sorry, my lord. Please see 105 annexure M, please, my lord. It's a MOU between Ramesh and Balkrishna and Srinivas, please, my lord. And this Ramesh is the complainant, please, my lord.
ಹೌದು ಸರ್, ಸೈಟ್ ನಂಬರ್ ಹೇಳ್ಬಿಡಿ ಸಾಕು. ಶೆಡ್ಯೂಲ್ ಪ್ರಾಪರ್ಟಿಲಿ 32, 33 ಎರಡು ಕಾಣ್ತಾ ಇದೆ.
ಹೌದು.
ಮತ್ತೆ ಇವ್ರಿಗೆ ಸೇಲ್ ಮಾಡಿ ಕನ್ಫರ್ಮೇಶನ್ ಬೇರೆಯವ್ರಿಗೆ ಯಾಕೆ ಕೊಟ್ಟು?
ಅಲ್ಲ, ಸೈಟ್ ನಂಬರ್ 31, 32.
ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಇದೆ. ಕನ್ಫರ್ಮೇಶನ್ ಡೀಡ್ ಶೆಡ್ಯೂಲ್ ಅಲ್ಲಿ ಇದೆ.
No, this was pointed out to him and pursuant to this MOU also, please, my lord. Please see deed of confirmation.
ಸ್ವಾಮಿ ಅವರೇ, ಅಷ್ಟೆಲ್ಲ ಯಾಕೆ? You are the vendor, whether you are GPA, owner ಅದೆಲ್ಲ ಇರಲಿ. You just show him which is the property that you have sold today.
That was shown even prior to the sale deed also, please, my lord.
Once more you do it.
Now, if my lord peruse the complaint allegation.
Once more do it, sir.
Certainly, please, my lord. But if
the learned counsel appearing for the petitioner, the issue that is projected as a crime is the petitioner selling 2 properties bearing site numbers 31 and 32 in survey number ಏನದು? In VBMP
56/2.
56/2.
26/2.
26/2 ಅಲ್ಲಿ ಸೈಟ್ ಮಾಡಿದೀರಾ?
ಕಂಪ್ಲೇಂಟ್ ಅಲಿಗೇಷನ್ ಅಲ್ಲಿ ಆ ತರ ಸರ್ವೆ ನಂಬರ್ 26/2 ರಲ್ಲಿ
26/2. The learned counsel for the petitioner, respondent complainant submits that those sites are not even available. Therefore, the sale is a farce or a fraud. The learned counsel submits that he would go with the complainant and identify those two sites that he has sold, sold and report it back to the court on the next date. The petitioner, the jurisdictional police, the officer in charge of the police station of the jurisdictional police shall accompany the two for identification of the sites. List this matter, the copy of this order, idiyal, state idiralla. List this matter on 12th February.
Obliged.
Yes. Interim order subsisting will continue. Objections, if any, by then interim order subsisting will continue to the next date of hearing. ಮತ್ತೆ appear ಆಗಿಲ್ಲ, objection ಹಾಕಿಲ್ಲ ಅಂದ್ರೆ ಎರಡು ಸೈಟು ಇಲ್ಲ. Yes.
Obliged.
Next.
On behalf of the petitioner, offenses 498A, section 3 and 4 of the DPR.
Yes, sir.
Milords, this is not, the petition only says this is a counter blast. In the petitioner's effort to defeat the complaint technically, justice must not be defeated.
No problem. You make a submission. We will
Please,
see to
please.
that it does not get defeated.
Please, please,
Yes,
Milord. Milord, here in this case, now it is not a case of counter blast where all the family members, every imaginary member of the family of the accused is added.
Yes, sir.
Who are the accused in this
Correct.
complaint and FIR?
A2
Milords?
and A3.
Milords, sorry, Milord.
Accused number 2 and 3, sir.
2, 3.
Yes, Milord. And all the accused are the siblings. Accused number 1 is the husband.
Correct.
2, 3, 4, 5,
Or
who are
2, 3,
before,
4, 5, yes.
5 who are before this court are siblings and their spouses. Milord, and number 6 is not before this court. Accused number 1 is before this court by way of another petition. At the outset, Milord, that petition also, for convenience merely, may be heard along with this
husband.
matter. Husband.
We will treat the husband separately.
Yes, Milord.
Yes, sir.
Obliged. Milord, now, I only said because all the these petitions are emerging out of the same FIR. Facts remain the same.
Charge sheet ಆಗಿದೆಯಾ?
Stay, my lord. Your lordship
Stay
has
ಇದೆಯಾ?
passed.
Stay there, Milord. So no difficulty is being caused to these accused.
No problem. We'll
Milords,
take it.
in
But
this
if you
case-
see page 21 and 22, that is your complaint.
Please, my lord.
Milords, just a little more, Milord, before we come to the
No
complaint.
problem.
Now here in
For
this,
the present petitioners, if I may be permitted to
the
submit.
history of this,
At annexure D, I've produced documents to show that we're not even deciding in this.
That's all right.
there is a history
I've
of
heard you on the
litigation
last
before between the parties. Milord.
No, 1 minute, sir. Vineet, see, now if you see the complaint at page 21 and 22,
Please.
what have these got to do in the dispute between husband and the wife?
Milords, both husband and wife are software engineers. Both worked in Dubai. Now the wife is back to India. In these situations, she's got a pink slip from Microsoft. He works with Huawei. Now he has also obtained a divorce in the Dubai court, Milord. And MFA
You
is pending
proceed
before this
against the
court.
husband, sir. What are these
Settles
got
and-
to do?
Settlements are under discussions, Milord. Now they want to use this as
Settlement?
Milords, there's another counsel appearing for them in the MFA court. He has come to India and there was discussion between the
Husband and
families.
wife you settle, sir. No
Now,
problem.
in the complaint, Milord, all our valuables, Milord, this is a single parent. She doesn't have a father. All her marks cards, all her belongings, jewelry, all the valuables are with the siblings of the husband in India. He lives in Dubai. And he's also got a divorce, Milord. That information is suppressed in the MFA court, in the case there, and here also.
So in MFA court, you
Please.
should ask all that as a part of your package of settlement or reunion or whatever.
Please, Milord.
How does a 498A crime lie against these people?
Yes, Milord. Milord, along with the complaint, lot of documents has been submitted, and those are the admitted facts in the family court, Milord, where properties are being bought by husband and wife together,
Husband and wife.
and the siblings are beneficiaries of that property. They
That
used to
is
live here.
separate 498A, sir.
Milord, harassment, physical and mental, even continues today
Mental.
while they are in possession of all her original documents, her jewelry, her clothes, everything is in their
Husband.
possession. Not her husband is living in Dubai, Milord. They are living here in India, and she is not given access here. The siblings have a great leverage. They have ensured separation. They have ensured there are no children till their members of some family are not married. They have continually interfered in this marriage, which has resulted in all these facts and circumstances. This is a genuine case of 498, Milord. Unlike, a counter blast where
No, not a
leverage has
counter
to be obtained. Now, Milord, today we are willing to settle the matter, agree for a divorce, not have any financial claim. But Milord, the wife has been deserted completely by the husband, not responding.
Husband, sir, you go against the husband.
Milord, husband is not alone, my lord. He is being directed by the siblings here. Because when they earn abroad, they send the monies.
Whether this instigation or a direction according to you would amount to cruelty under 490?
Yes, my lord, because
No.
he has admitted in the family code of having
There are
jointly bought properties.
Scores and scores of judgments.
Lords, I can file my objections in detail to this petition and bring on record before this court as to how entire facts and grounds in this petition is only manufactured to defeat the complaint technically. Not in that case, there is no
problem.
application of judicious mind
You've not
necessary
filed
in
your-
any
you
matters
might
like
not
this.
filed your objections.
My lords, because the discussions were there and we didn't want to be,
On the wrong
predicting. I can put it tomorrow.
Put it.
Detailed objections on this matter. It may be
Heard the
considered in
learned
any
counsel
order
from
by this court.
Kirti Reddy appearing for the petitioner and the counsel Vineet Shambat representing the complainant. Learned counsel Vineet Shambat seeks 10 days time to file statement of objections. List the matter on 10th
I
for
just want to
admission.
point out, Mala, since from 24, they have not filed.
One last opportunity. He wants to bring in something. Yes.
Without wasting time, immediately I'll bring it on record.
Yes.
Please.
The learned, in the light of the said submission, list the matter on 10th for admission. It's made clear that it is the last chance for the respondent complainant to file his statement of objection.
Please.
And make his submissions. In the event it is not done, the petition would be answered, hearing the counsel appearing for the petitioner. Interim order subsisting will continue till the next date of hearing.
Please.
10th is Tuesday, right? 11th, sorry, this is 11th,
Please.
24.
Please.
Petition under section for offense under section 498, 323, 504, 506, read with 34 of
represent-
IPC, my lord.
Husband, huh?
Yes, my husband, my lord, in-laws petition.
I'm for the R2 lordship.
Correct.
Considering my request lordship is other day I discussed my friend also. That may be referred to the
Mediation.
mediation.
Mediation
Because
request
I have-
ಮಾಡ್ತಿದಾರೆ. They are asking for a mediation, my lord.
Go.
The reason lordship is, there is a MC, sorry,
Right,
CMS
right.
is
The parties to the list, the learned counsel for the respondent submits that if the matter is referred to mediation, chances of settlement are large. In that light, the parties to appear before the madam, on what day? Any data. On 6th February, list the matter on 13th February.
Please, my lord.
great.
Interim order subsisting will continue to the next date of hearing.
My lord, I'm presenting virtually.
Yes, yes.
I want to read a part of the FIR on page number 28.
You read it coming here, sir. List the matter on 17th. Interim order subsisting will continue till the next date of hearing for admission. Next.
For petitioner.
Same 17th IO. ಏನಿದು offense?
Cheating, madam.
Cheating.
420.
420. Transaction ಏನು? It's not my interim order, that's why.
Yes, madam. Petitioner,
Yes. 24th February, IO, next. 26th, sorry. 26th ಯಾಕೆ madam? 25 ಇದು? 26th, yes.
18?
ಇನ್ನಲ್ಲಿ ಲಾಸ್ಟ್ ಟೈಮ್ ಅವರಿಗೆ ಪೆಂಡೆಂಟ್ಸ್ ಯಾರಿದ್ದಾರೆ ನೋಡಿ ಹೇಳಿ ಅವ್ರಿಗೆ ಏನಾರು ಒಂದು ಸ್ವಲ್ಪ ಮಾನಿಟರಿ
304A.
304 AEE ಮೆಲೋಡ್ಸ್
ಕರೆಕ್ಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅಲ್ಲ ಅವ್ರು ಹೇಳಿ ಕೇಳಿದ್ದು ಲಾಸ್ಟ್
ಯಾರಿಗೆ ಹೇಳಿದ್ವಿ? ದಿ ಸ್ಟೇಟ್ ಶೆಲ್ ಸೆಕ್ಯೂರ್. ನಿಮ್ಮಿಂದ ಕೂಡ ಕೇಳ್ತೀನಿ ಈಗ. List the matter on 10th to comply with the order, state to comply with the order dated 9/1/2026. Interim order stands extended to the next date. Next. 11th, sorry, 12th, madam, 12th February.
19?
for the petitioner.
My lord, the counsel has been appointed as a government advocate, my lord. My name may be.
Which
reflected.
counsel, sir?
Aditya D. my lord.
ಹೌದಾ?
Please.
ನಿಮ್ಮ ಹೆಸರು ಹಾಕ್ಬೇಕಾ?
I'm on record, my lord.
Registry to delete the name of so and so and print the name of so and so.
Please.
ಬರ್ಕೊಡಿ.
But
Yes.
Lordship, this is a BD encroachment of land matter. The petitioner had filed a writ petition against the BDH regarding acquisition. Now that has been reserved, Your Lordship.
ಹೌದಾ?
You know?
ಯಾವ which matter? I have reserved it.
No. The land acquisition court, as in roster.
We'll take it on 26th. List the matter on 26th. Entry mode extends. Continues till then. Next.
20?
For the petitioner in this case, my lords, the petitioner is not signatory to the check, my lords. The accused number 2 on the individual capacity has issued the check, my lord.
Maybe ಯಾರು?
My lords, I am the accused number 1.
Pharma company na?
No, not company, my lords.
Individuals.
Individuals is.
ಆಯ್ತು. Why are you drawn into the proceedings then?
My lords, simply.
kindly pass over the matter.
My lords, there is no. I have not issued any check, my lords. Your lordship may kindly come to page number 24. Check.
Yes, sir.
My lord, kindly pass over the matter, my lord.
Pass over ಇಲ್ಲ sir.
My lord, we'll have it on Monday, my lord.
Passed over to next week. Yes. Unburied. Next 6th list on 5th February.
Much of interim order.
We go till then. Yes, next.
21?
I'm the defendant responding, my lord. I seek leave the court, my lord, to proceed on 11th, my lord. In fact, I was suffering from a kidney stone. So I'll file objections on 11th.
11th ಬೇಡ. We'll take it on 19th.
Much of.
ಏನಿದೆ matter? IO ಇಲ್ವಾ?
No.
Charge sheet is filed, mother's complaint against son, and 498 complaint after 35 years of marriage against the father and the son. And your lordships, on the last occasion, one more FIR was filed against the son for theft of the car, which came to be stayed by this court.
ಯಾವ ಕಾರು?
Car.
ಕಾರು.
Now it is criminal trespass.
Which is that petition?
It is there.
Tag ಆಗಿದೆಯಾ ಇಲ್ವಾ?
It is not a tag.
ಕೊಡಿ. Tag this petition. We'll give you 10 days time.
Please, ma'am.
Counsel Balram ML seeks 10 days time to file statement of objections.
5953
and make a submissions in the matter. List the matter on 19th. Tag the petition along with the
5953.
Interim order if finished shall continue to the next date.
There is
Order
one
has
more
to be
matter
granted.
connected, my lord.
You could, which all matters are there?
Yes, my lord.
Interim order has to be granted today.
On the instigation of my son, my lord, there is a complaint filed by a third party, my lord. It's all connected, matter.
No problem. You all will take all these family problems on that day, 19th.
Interim order has to be granted.
28/3 is the next date of my lord.
ಆಯ್ತು, ಅವತ್ತು next ಮಾಡುವ. You don't worry about it. Sandeep, 28/3 next day alva?
28/3.
We'll do it. Yes. List the matter on ಯಾವತ್ತು ಹೇಳಿದೆ?
19th.
19th February, please.
22?
The main accused has been acquitted, my lords. This is a split up charge sheet that I'm challenging. The lordship's order.
Page. Order page.
Page number 37, my lords. That is the order of acquittal.
One ನಿಮಿಷ. The petitioner, accused number? 2.
Accused number 2.
The petitioner accused, how many accused?
There are 2 accused, my lords.
The
Accused one
petitioner gets embroiled in the petitioner is before this court calling in question proceedings in special case number 1702 of 2025, registered for offences punishable under 3, madam, idralide synopsis alli, page 2 alli. Pokso na, acquitted.
Acquitted.
The petitioner gets embroiled in a crime along with accused number 1, which leads the concerned court to try the offence under section for the aforesaid provisions for the aforesaid offences in special case 1702. First 1702 alla.
962 of 23, my lords.
In special case 962 of 2023, the petitioner accused number 2 was not available for trial at the relevant point in time. Therefore, the concerned court draws a split charge against the petitioner and registers special case 1702 of 2025. The continuance, the 1702. The accused number 1 who was tried in special case 962 of 2023 gets acquitted of the offence in terms of the order passed by the concerned court on 12th September 2025 on the score that the prosecution has failed miserably to prove the guilt beyond all reasonable doubt. The reason so rendered by the concerned court to acquit accused number 1 is as follows, page 78 in the 83, 84. If accused number 1, who was the main perpetrator of the allegations for offence under POCSO Act, the petitioner, who was accused number 2, cannot be accused number 2 need not be permitted to be tried, as eventually he would get acquitted, as the acquittal of the accused number 1 has happened. In that light, permitting further proceedings in special case number 1702 of 2025 will be a waste of precious judicial time. However, with a rider that in the event the accused number 1's case would get reversed by a higher fora, the subject order would also will have to be recalled, and the petitioner permitted to follow suit of accused number 1 later, SUIT of accused number. The view of mine in this regard, adondide. Lord Quast.
Lords, the accused has been arrested last week, my lord. So as far as that is concerned,
Yes, we'll do it. Nale release ಮಾಡ್ತೀನಿ.
there might be an direction with that.
The register, Lord Quast, the registry is directed to communicate the said order to the present jail authorities for the release of the accused number 2 forthwith. Accused number 2 forthwith, without broking any further delay.
The operating portion may be uploaded.
ಎಲ್ಲ ನಾಳೆನೇ ಕೊಡ್ತೀನಿ.
Grateful.
23.
What's the matter?
So the respondent number 2 is the judicial magistrate, my lords. The time of judicial
Why have you
magis-
made him?
Respondent number 2, my
Why
lords. He
have
is
you
the
made him a
complainant.
party?
He is a complainant.
Complainant. Why? What's the offense?
Lords, at the time of the incident, I was working as a doctor in government hospital Sulya, my lords. The complainant has told him to record the dying declaration of one patient, my lords. I'd asked for a requisition due to which proceedings has
You
been
should
initiated.
make the registrar there as a party, not the presiding officer. Change it.
Please.
Huh? KLR matter.
Judicial magistrate is from Kerala, my lords.
Kerala.
Kasaragod.
ಆಯ್ತು ಈಗ ಏನಾಗಿದೆ?
There's requisition. Just because I asked for the requisition, criminal proceedings has been initiated. The patient was from another state, my lords. She was not accompanied by anyone.
Patient, which state?
Patient, my lords. Complaint, my lords.
Patient, which state, sir?
She is from Kerala, my lords. FIR
ಮತ್ತೆ
has been.
ಇನ್ಯಾರು ಇನ್ನೊಂದು ಸ್ಟೇಟ್? You are from Karnataka?
Please, my lords. Incident has taken place in Karnataka, my lords. Sulya. I asked for a requisition due to the reason that she was from another state. No one accompanied her.
Notice ಬರೀ ಮಾಡಿದ್ರೆ ಜಗದೀಶ್ ಸರ್, ಸೊಲ್ಯೂಷನ್ ಬೇಕು. ಅಲ್ಲಿವರೆಗೂ ಸ್ಟೇ ಮಾಡ್ರೆ. The learned additional SPP is directed to accept notice for the respondent, first respondent, secure instructions and make submissions. Further proceedings in so and so shall remain stayed by the petitioner till the next date.
Great.
Yes, next.
24.
ಅದನ್ನ ರಿಜಿಸ್ಟರ್ ಅಂತ ಮಾಡಿದ್ರೆ ಬೆಟರ್. It's not.
Please, my lords. I'll take
Huh?
a copy.
Private
For
capacity.
petitioner's
ಇರ್ಲಿ
counsel.
ಬಿಡಿ. Yes.
Respond number 2, my lord. Lord, in this matter, my lord, Lordship direct matter, my lord.
Foreigners Act.
Lord, in this matter, my lord, we have produced the bills and my lord, account statements to say that, my lord, we have engaged service of one Glam Fame, my lord, for the purpose of
Glam Fame
ad agency for the purpose of
ಹೇಳಿಲ್ವಾ?
promotional activities.
Nigerian
Yes, yes,
ಕರ್ಸ್ಬೇಕಾ?
I come to that, my lord. There are a very interesting thing, my lord. Now, I will make submission first. I am the
Wait.
petitioner's counsel.
You should encourage restraint till he finishes.
And there is a government, my lord, PP is there, my lord.
No,
Complainant's
the
task is,
complainant
my lord,
is
comes later.
entitled. No,
First, my lord,
that's-
petition.
if you are seeking quashing, complainant comes first.
No, but petitioner, my lord, has to make his submission.
ಅದು
my
ಮಾಡಿ
lord.
ಫಸ್ಟ್ ಅಂದ್ರೆ
ತಾನೇ ಬಿಡಲ್ಲ ಅವ್ರು
ನಿಮಗಿಂತ
ಅಂದ್ರೆ
ಮುಂಚೆ ಅಲ್ಲ,
ಹೌದು.
ಗವರ್ಮೆಂಟ್ ಗಿಂತ ಮುಂಚೆ
ಮಾಡ್ಲಿ, no problem, no difficulty.
ಮುಗಿಸಿ.
My lord, now the issue is, my lord, very interestingly, my lord.
ವೆರಿ ಇಂಟ್ರೆಸ್ಟಿಂಗ್.
Yes, my lord. The very same complainant introduced all these models, and my lord, through him we hired them initially. Therefore, my lord, if at all, my lord, violation of national security threat, etc., it should be attributed to the complainant first. I have material to be placed before your lordship. Lord, the very same complainant, Lord, there are transactions.
The rival operator.
Rival operator. Now, our through first year engage madidvi. Now he filed complaint only for the reason that we engaged through some other agency.
ಅದು ಡೈರೆಕ್ಟ್ ಆಗಿ ಅವ್ರ ಹತ್ರ ಮಾತಾಡಿ.
ಅದೇ ಪೇಮೆಂಟ್ ಡೀಟೇಲ್ಸ್ ಎಲ್ಲ ಇದೆ, ಅವರನ್ನೇ ಮಾಡಿದ್ದು. ಅವ್ರು ಥ್ರೆಟ್ ಮಾಡಿದ್ದಿದೆ ನಿಮ್ಮ ಮೇಲೆ ಕೇಸ್ ಹಾಕ್ತೀನಿ ಅಂತ. ಹಿ ಇಸ್ ಥ್ರೆಟ್ ಮೈ ಲಾರ್ಡ್ ಆಕ್ಚುಲಿ.
ಅವ್ರು ಕೊಟ್ಬಿಡಿ ಅವ್ರಿಗೆ, ಅವ್ರೇನು ಮಾತಾಡಲ್ಲ ಅವಾಗ.
ಅಲ್ಲ ಕೊಡೋಣ, ಅದಕ್ಕೆ
ಕೊಟ್ಬಿಡಿ,
ಕಾಪಿ ಕೊಡಿ. Lord, this is the document to say that this number 1. Now, the second aspect is, my lord, if at all Foreigners Act is violated, section 14 and 14A should have been, my lord, invoked in the FIR, and FIR has to be registered against the my lord who has committed the offense. Without, my lord, invoking section 14 and 14A, abatement, my lord, does not arise. The allegation is made only abatement against me.
ಈಗ ಈ ಸಜೆಷನ್ ಕೊಟ್ಟಿರೋದು ಯಾರು? ಪೇಜ್ 32 ಅಲ್ಲಿ ಇವರೇನಾ?
ಇವರೇ ಕೊಟ್ಟಿದ್ದು.
He has a good face.
ಎಲ್ಲ ಅವ್ರದೇ.
ಅಲ್ಲ, he has a good face. You can use him with curly hair.
Yes, my lord. Everything is done by him only.
Just spray gel.
Yes. ಇದೇ ಕಂಪ್ಲೇಂಟ್ ಫೋನ್ ನಂಬರ್ FIR ಅಲ್ಲಿ ಇದೆ.
ಆಯ್ತಾ
This
sir?
is not a mere
Cat
case
is
of
out of the bag.
My lords, I may clarify.
Is the cat out of the
No,
bag?
no, my lords. This, my
definitely
lords will.
cat is
Skeletons out of the cupboard.
No, no, my lords.
Yes, sir.
These are different models.
ಇವ್ರ ಮೇಲೆ ಯಾಕೆ ಮಾಡಿಲ್ಲ?
ಅಲ್ಲ, please.
ಅಲ್ಲ, ಇವ್ರ ನಿಮ್ಮ ಮೇಲೆ ಯಾಕೆ ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿಲ್ಲ?
ಅಲ್ಲ, ಅವರೇ ಕಂಪ್ಲೇಂಟ್.
ನಿಮಿಷ ಸರ್. ಸಪರೇಟ್ ಕ್ರೈಮ್ ಇವ್ರ ಮೇಲೆ ರಿಜಿಸ್ಟರ್ ಮಾಡಿ.
No, no, my lords.
Now, because he is alleging Foreigners Act violation illa, register a crime against him.
Yes. No, please.
You will direct crime to be registered
Very well.
against. No, everything will be all right.
Let me explain.
Yes.
These models, my lords. First
ಒಂದು
and
ನಿಮಿಷ. These models ಬೇರೆನಾ?
ಬೇರೆ.
ಎಲ್ಲಿಂದ?
These are all models, my lords. I am
ಎಲ್ಲಿಂದ?
ಇಲ್ಲ ಇಲ್ಲ.
different places. For example, my lords may see
ಎಲ್ಲಿಂದ?
different places, my lords.
Places ಅಂದ್ರೆ ಎಲ್ಲಿ? ಗ್ಲೋಬಲ್
It could be anywhere, my lords.
ಅಲ್ವಾ?
It
So ಅವಾಗ ನ್ಯಾಷನಲ್ ಸೆಕ್ಯೂರಿಟಿ ಥ್ರೆಟ್ ಇರ್ಲಿಲ್ವಾ?
there is a mode and mechanism to do
So
it.
register a crime against the complainant.
No, my lords.
I will pass an order.
No, my lords, let
230 I will pass an order.
let me clarify.
No, sir.
No, there is a manner to do it. I can apply for an employment visa and get them.
That is what he has
I have done that.
Very same model
They
as
have
See,
not done
1
it.
minute.
No, they have
If
not
a
done it.
rival operator wants to flex his muscles, he should be ready to face proceedings.
No, my lords, I am not a rival operator. Please note, my lords.
No, he is rival.
No, please note, my lords. He is the end customer. He is the one who is getting these
So
models
don't
for
worry,
his
sir.
brand.
I will pass an order
My lords,
to register a crime against you also, because national security
I am
threat
ready.
is what you are
No,
projecting.
if I have done something wrong, I am ready to face the music because I have not done anything wrong.
230 I will pass it order.
Let me argue, my lords. Let me just finish. my lords.
ಈಗಿಲ್ಲ.
I
You may
understand.
have had your lunch. I
Let me
have
finish,
not.
my lords. Let me finish.
I have not.
At 2:30, I will finish, my lords.
Yes,
Please.
sir. You finish your lunch.
Please.
So skeletons are out of the cupboard.
No, my lords, I'll be
So
able to
we'll see.
point out there is absolutely nothing wrong.
Oh,
with it.
we'll see.
62, your lordship, settlement.
I am definitely going to direct police to investigate into your affairs as well.
I am open to that, my lord, but
Yes,
I have not
sir.
done anything wrong, my lord.
Absolutely. 125 ಹೇಳಿದೆ. ಅವರೆಲ್ಲ ಊಟ ಮಾಡಿದಾರಾ? ನಾನು ಮಾಡ್ಕೊಂಡ್ ಬರ್ಬೋದು ತಾನೆ? 230 ಮೇಡಮ್. ಎಕ್ಸ್ಟರ್ನ್ಮೆಂಟ್ ಇಲ್ಲ ಹೆಂಗ್ ಬರುತ್ತೆ?
That has been transferred by special order.
Externment is transferred to this court, special order.
Yeah, by special order.
ನಾಳೆ ನಿಮ್ದು ಎಕ್ಸ್ಟರ್ನ್ಮೆಂಟ್
Since 2011, my lord, CC is pending, my lord. I have filed in the police. Respondents have made their appeal. If it can be taken up, my lord, there is no interim order, my lord, it can be taken up.
2011 ಇಂದ ಪೆಂಡಿಂಗ್ ಇಂಟರ್ ಮಾಡಿ ಕೊಡ್ತೀನಿ ನಾನು. ಮತ್ತೆ
If it can be taken up,
they will see.
My lordship, may I just make a mention, my lord?
Externment the ಕೊಡಿ tomorrow.
My lordship, serial number 29. Other side, na copy has not served, my lord. Yesterday I filed
ಊಟ
wakalat.
ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ.
Lords, may I make a mention, my lords? PP Act matters before my lords by a special order. Lords, rampant construction is happening, my lords. We kindly have it tomorrow. Tomorrow, my lords.
Tomorrow ಆಗದೇ ಇಲ್ಲ.
Lords, any date
Tomorrow
next
ಆಗಲ್ಲ,
week.
ಎಲ್ಲ next week we'll fix it.
Next week, my lords.
Nandakan.
Reporting settlement. Seal number 60.
Hearing for respondent number 2.
Offense.
Offense 498. Filing joint affidavit. Parties are here.
Both. Yes. 490.
Order
Yes.
sheet signatures.
But reunion.
Divorce ಆಗಿದೆ. ಎಲ್ಲ has been
All right. Is sign and ghost. ಅವರು ವಕಾಲತ್
Respondent 2.
ಹಾಕಿದ್ದೀರಾ ಹಾಕ್ಬೇಕಾ? ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ?
ಹಾ ಹೌದು.
ವಕಾಲತ್ is filed.
Fine. Next.
C1, order sheet signature for petitioner my lordship.
Respondent in this case.
Offense.
498 my lordship. Settlement.
Filing ವಕಾಲತ್.
Learned counsel so and so undertakes.
Affidavit ಆಗ್ತಿದೆ. Parties are present.
Present witness.
Yes, madam.
Both the parties are present.
All right. Where is the settlement? Nangen beda. Done. Ordered. Yes.
Order sheet signatures. ಈ ಕಡೆ ಬನ್ನಿ. 62.
62. Pray for time, your lordship.
62 ಯಾವತ್ತು? Offense ಏನು?
326.
326. 326 ಎಲ್ಲಿ ಬರುತ್ತೆ settlement?
ಅಲ್ಲ 2002 ಇನ್ಸಿಡೆಂಟ್ ಲ್ಯಾಂಡ್ಲಾರ್ಡ್ ಟೆನೆಂಟ್ಸ್.
Crime ಯಾವಾಗಿಂದ?
2002 ಇದು.
326. ಟ್ರಯಲ್ ಮುಗಿಬೇಕಾಗಿತ್ತು ಇಷ್ಟೊತ್ತಿಗೆ.
ಇಲ್ಲ ಟ್ರಯಲ್ ಈಗ ಸ್ಟಾರ್ಟ್ ಆಗ್ಲಿಕ್ಕಿದೆ.
25 ವರ್ಷ ಆದ್ಮೇಲೆ.
ಹಾ ಅಂದ್ರೆ ಅವು ಕೇರಳದವರೆಲ್ಲ.
ಪರ್ಫೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಟು ಸೆಟಲ್. ಎಸ್ ಯಾವತ್ ಬೇಕು?
ಡೇಟ್ ಬೇಡ ಯಾಕಂದ್ರೆ ಅವರು
Date ಬೇಡವಾ?
ಅಲ್ಲಲ್ಲ ಯಾಕೆ ನಾ ಮೂವ್ ಮಾಡ್ತೇನೆ ಈಸ್ ಅಡ್ಮಿಟೆಡ್ ಟು ಹಾಸ್ಪಿಟಲ್
ಮಾಡಿ.
ನಿಮೋನಿಯಾ ಅದಕ್ಕೆ ನಾ ಮೂವ್ ಮಾಡ್ತೇನೆ
ಮೂವ್
ನೆಕ್ಸ್ಟ್
ಮಾಡಕ್ಕೆ ಪರ್ಮಿಷನ್ ಬೇಕಾ?
ಅಲ್ಲಲ್ಲ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರೆ ಮತ್ತೆ ಹಾಸ್ಪಿಟಲ್ ಅಡ್ಮಿಟ್
ನೀವು ಮೂವ್ ಮಾಡಕ್ಕೆ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ಬೇಕಾ?
ಬೇಡ ಬೇಡ
ನೀವು ಯಾವಾಗ ಬೇಕು ಅವಾಗ ಮೂವ್ ಮಾಡಿ.
ಪ್ಲೀಸ್
ನೀವು ಮೂವ್ ಮಾಡಿದ ಒಡನೆ ತಗೊಳ್ಳುವ. ಆಯ್ತು. ಕಂಪ್ಲೈ 2 weeks ಬಿಟ್ಟು ಕೊಡುವ.
ನೆಕ್ಸ್ಟ್ ವೀಕ್
2 weeks to comply with the office objections. ನೀವು ಮೂವ್ ಮಾಡಿ.
ಪ್ಲೀಸ್
63.
Appear for petitioner. Some ಇದರಲ್ಲಿ MO ಆಗಿದೆ. ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದೆ, MO ಆಗಿದೆ. ಮದುವೆ ಆಗಿ 1 ವರ್ಷ ಕಂಪ್ಲೀಟ್ ಆಗಿಲ್ಲ ಅಂದ್ಬಿಟ್ಟು ಮ್ಯೂಚುವಲ್ ಕನ್ಸೆಂಟ್ ಫೈಲ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ತಾ ಇಲ್ಲ. ಹಾಗಾಗಿ
ಅದು ವೇವ್ ಆಫ್ ಮಾಡ್ಬೋದಲ್ಲ ಮಾಡಿ.
ಇಲ್ಲ ಮಾಡಕ್ಕೆ
ಸರಿ, parties get the parties here, we will see.
These all parties in Maharashtra.
All parties Maharashtra. What Karnataka case?
ಇಲ್ಲಿ respondent 2 in Bangalore.
Oh, complainant is in Bangalore.
Yes.
All right. We'll give 2 weeks time. Without parties, I can't do anything. Allah, I think.
ನಾನು ಮಾಡ್ಬಿಡ್ತೀನಿ. MO ಆಗಿದೆ. 5 ಲಕ್ಷ ಆಲ್ರೆಡಿ ಪೇಡ್ ಆಗಿದೆ.
ಕರ್ಕೊಂಡ್ ಬನ್ನಿ, ಸೆಟಲ್ ಮಾಡುವ. ಇಲ್ಲ ಅಂದ್ರೆ ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಬನ್ನಿ, ಜಡ್ಮೆಂಟ್ ಬರೆಯುವ.
ಕರ್ಕೊಂಡು ಬರ್ತೀನಿ. ಪರ್ಟಿಕ್ಯುಲರ್
ಯಾವತ್ ಬೇಕು ನಿಮ್ಗೆ? ಯಾವತ್ ಬೇಕು ಅವತ್ತು?
ಅಲ್ಲ ಅವರು ಕರ್ಕೊಂಡು
ನಿಮ್ಗೆ ಯಾವತ್ ಬೇಕು ಅವತ್ತು ಹೇಳಿ. 2 ವಾರ ಬಿಟ್ಕೊಡ್ಲಾ?
2 ವಾರ.
ಸರಿ, ಲಿಸ್ಟ್ ಆನ್ 20th February.
64.
ರೆಸ್ಪಾಂಡೆಂಟ್
Offense? 326. ನೋಡೋಣ. ಎಸ್ ಜಗದೀಶ್ ಸರ್, 326. 324 of 6. 1181 ಏನು? 324 ಅದು. 1181 326. 115 323 118 324. ನೋಡಿ ಸ್ವಲ್ಪ ತೆಗೆದು. BNS ನೋಡಿ. ಜಗದೀಶ್ ಸರ್, 118 is 324, 115 is 323. 4 ಮತ್ತೇನು 181 326 ಅಂತ ಇದ್ದಾರೆ. ನಾನ್ ಕಾಂಪೌಂಡಬಲ್ ಹೌದು. 326 ಆದ್ರೆ ನಾನು ಮಾಡಲ್ಲ. ಕೊಡಿ. ಕ್ಲೋಸ್ ಇಟ್. ಇನ್ನು ನೋಡ್ಲಿಲ್ಲ ಎಲ್ಲಿದೆ BNS? ಮೊಬೈಲ್ ತೆಗಿತಾ ಇದ್ದೀರಾ? ನನ್ಗೆ ಕನ್ಫ್ಯೂಸ್ ಮಾಡ್ಬಿಟ್ರೆ. ಒನ್ 118 ಅಲ್ಲ? 326. Three 118. ಅದು ಗೊತ್ತು ನೀವು 326 ಅಂದ್ರೆ ಕಾಂಪೌಂಡ್ ಅಲ್ಲ ಆಗೇನೋ ಆಗೋದೇ ಇಲ್ಲ. ಎಸ್ ಕೊಡಿ ಅದು ಎಲ್ಲಿ ಪಾರ್ಟೀಸ್ ಅಲ್ಲಿ ಸಿಂಪಲ್ ಇಂಜುರಿಯಾ? ಎಸ್ ಆಲ್ ಪಾರ್ಟೀಸ್ ಆರ್ ದೇರ್.
Please file.
Order sheet signature. 230 mood reporting settlement. Mahesh YL.
ಮಹೇಶ್ ವಯಲ್ ನಂಗೆ ರಾಯಲ್ ಅಂತ
To the petitioner, my
offense
lord, 74, 78, 115.
74 I will not settle, sir.
My lord, the parties are.
354A.
It was a misunderstanding.
354A, 79 is 509.
My lord, both the parties.
Hmm.
From 2018, because of some misunderstanding, a complaint.
Yes,
came to
Jagdish sir,
the-
354A. Yeah. Who is the complainant? Advocate. Student. Where is the settlement? Yes. Studying law. You're a law student? Why unlawful activities?
Respond.
Yes. Hmm. All right, sign.
Much obliged. Much obliged.
Order sheet signature.
ಇದ್ಯಾವ್ದು ಮೇಡಮ್? seal number 2?
Two ವಕಾಲತ್.
Respond number 2. ವಕಾಲತ್ ಹಾಕಿಲ್ವಾ?
Respondent is ಹಾಕಿದ್ದಾರೆ. It is filed.
When? Submits that is entered appearance. Name ಕೊಡಿ. Yes.
Seal number 2, Shri Kiran N.
Matter is settled out, my lord.
Offense.
498. I'm filing an amended writ petition, my lord.
Amended writ petition na?
At the time of filing the petition.
Husband ಇರ್ಲಿಲ್ವಾ?
Husband.
All right. ಅಲ್ಲಿ ಇದಕ್ಕೆ ಈಗ IA 125 for impleading allowed. Amended petition. Petitioner files an amended petition. The same is taken on record. ಅದಾದ್ಮೇಲೆ ಮಿಕ್ಕಿದ್ದು ಕ್ಲೋಸ್ ಮಾಡಿ.
Order sheet signature.
Yes. ಕರೆದ್ಬಿಡಿ. Continue.
Just one continue. 24.
ನೋಡಿದ್ರಾ?
I've seen it, my lords. I have the documents to show that there is no cat, there is no bag, my lords.
ನೋಡೋಣ, we'll see.
A is, my lords. A is, my lords.
Complaint itself, my lord.
Entry ಮಾಡೋ ಕೊಟ್ಟಿಲ್ವಾ?
ನಮ್ಗೆ entry ಮಾಡಿ.
Entry ಮಾಡಿ ಉಂಟಲ್ಲ. Heard the learned senior counsel Arun Sham appearing for the petitioner and Suraj Sampath representing the complainant and the state. List the matter on 12th. List the matter on 12th for admission.
May I just
Entry
make-
order 19th for
May I
admission.
just make one mention?
No
my lord?
urgency in this.
May I just point out, my lords?
List the matter on 19th for admission. Interim order subsisting will continue till the next date of hearing. Registry file ಮಾಡಿ documents. ನೀವೇನಾದ್ರು ಅದಕ್ಕೆ ರಿಬಟಲ್ ಇದ್ರೆ ಹಾಕಿ.
No, my lords.
ರಿಬಟಲ್ ಇದ್ರೆ ಹಾಕಿ.
My lord, may just give me
Argument
one
ಅಲ್ಲ.
minute. My lord, may just give me 1 minute. This is a situation, my lords, that our visa guidelines permits me to bring in foreigners to do work. All my models which they have furnished in that WhatsApp chat, all of them have work visas. I have all of them right here in front of me, my lords. Their models, my lords, are all procured.
We'll see models versus models. No.
Allah, it's not about models versus models, my lords. My lords, they are the end customer. Glam Fame is a photography studio.
So, no,
I have no rivalry with either of them.
Now, whatever
I
it
am
is,
an agency, my lords.
with your conduct, now the issue gets a little diluted. There is no national security involved in this.
No,
We'll
my
see.
lord, no, my lord. All the models that none of the material that they've given today indicates that I have done anything wrong. my lords. The chat only shows that they owe me money. That may be the.
We'll see.
That may be the motive for me
We have better cases to decide. Wait.
my lords, but
Modeling
I'll,
ಮಾಡ್ಕೊಂಡಿರ್ಲಿ.
I'll ultimately, these models come to India, my lords, they do several other things also, my lords.
ಅದು everybody coming, ಅದೇ ಮೊನ್ನೆ ಹೇಳ್ತಾ ಇದ್ದೆ.
For example, my models are, my lords, from Brazil, Russia.
From where are your models?
Brazil and Russia, my lords. I have.
ಅವ್ರೇನು ಮಾಡಲ್ವಾ?
I have the visa.
ಅವ್ರೇನು
Alla,
ಮಾಡಲ್ಲ?
they've all come on work visas following all guidelines, my
So
lords.
ಇವರು ಯಾವ ವೀಸಾನ
ಇವ್ರದ್ದು ಬಂದಿರೋದು business visa, tourist visa, student visa. And then they're
ಮಾಡ್ಲಿಂಗ್
carrying on.
ಮಾಡಬಾರ್ದು ಅಂತಿದ್ಯಾ ಅವ್ರಿಗೆ?
Sorry, my lords.
ಬಿಸ್ನೆಸ್ ವೀಸಾಗ್ ಬಂದು ಮಾಡ್ಲಿಂಗ್ ಮಾಡಬಾರ್ದು.
That is what exactly what the visa guidelines would say. I have produced it with my vacating application.
Will consider it. Visa ಇದೆ ತಾನೆ?
Some of them.
Visa ಇದೆ ಅಲ್ವಾ?
No, my lord, they've all sent back because they violated the visa guidelines. They're all sent back also. That's the situation, my lord. So it is not the same thing, my lord, because for the simple.
19th.
My lords is
26th. Yes.
19th.
19th. Yes. ಮುಗಿಸ್ಕೊಂಡಲ್ಲ ಇಷ್ಟು ಆಮೇಲೆ ನಿಮಿಷ ಕರೆಯೋಣ.
25.
I appear for respondent number 2, my lords.
Petitioner was working as general manager in postal department.
ಅದೇ ಇದು atrocities.
Atrocity. B report ಹಾಕಿದನ್ನ the trial court rejected. It says that mandatory to obtain a permission.
We'll hear it. List the matter on 19th for admission. Interim order subs heard the learned counsel M.N. Kumar, learned counsel P.A. Kulkarni appearing for the respondent complainant. List the matter on 19th for admission. Interim order subsisting will continue till the next date of hearing. Yes, next.
26.
Prayer for the petitioner. Lords, 311 application, lords of the state rejected. Lords, I am the victim. Lords, 498 is the offense.
You are the complainant.
I am the complainant.
Right, list the matter on next Thursday. Further proceedings before the concerned court shall remain stayed till the next date. Yes.
Lords, notice, lords.
Petitioner to serve on the counsel who represents the accused before the concerned court. Yes, next.
27.
For the petitioners in this matter, my lord. My lord, this matter is, the accused is a tenant under the respondent, my lord. The accused and the respondent number 2 have entered into a lease agreement.
Correct.
On 12/5/20.
He is in the United States.
She is in the USA, my lord.
Yes. Again problem agida.
My lord, 12/5/2025 we have entered into a lease deed for 10 years. According to the lease agreement, we have sublet the property. On 14.
In terms of the lease deed.
Agreement, yes. The lease agreement is at page 31, my lord.
It permits subleasing.
Yes, it permits subleasing, my lord. On 14 November 2025, the respondent number 2 returns from USA and started harassing the the tenants who have been sublet in the property. So absolutely they are not
ಯಾರಿಗೆ
talking
sublease ಮಾಡಿದೀರಾ?
to some for one the educational institution is there, and there is one more some consulting agencies there, my lord. There are totally 4 floors on the commercial property. 14/11/2025 she barges into the property and she says, I am the owner. The said petition number 1 is not the owner anta heli she creates a ruckus in the near the property, my lord.
ಆಮೇಲೆ crime register ಮಾಡಿದಾರಾ?
And 8/12/2025 I have issued a legal notice to her.
The petitioner is before the court.
Petitioners
accused 1, 2, 3 and 4 are before the courts calling in question registration of a crime in crime number 464 of 2025 registered for the following offences. The petitioner is a tenant from the hands of the second respondent complainant who enters into a lease deed. The learned counsel for the petitioner takes this court through the lease agreement which permits subleasing of the property. In terms of the agreement on 12/5/2025, it transpires that the the petitioner has sublet the property to other persons for the purpose of rent. The owner, who till then was in the United States, comes back and is said to have created a ruckus, contending that the sublease was not permissible. The crime is thus registered on the aforesaid ground, that too after the petitioner causing a legal notice upon the
There's an
complainant.
injunction suit pending and they have
A legal notice caused upon the complainant and an injunction suit instituted by the petitioner in OS 8836 of 2025. In that light, a purely civil dispute is in that light, criminal law is set into motion on a purely civil dispute which cannot be permitted. There shall be an interim order of stay of further investigation qua these petitioners till the next date of hearing. One addition. What's your name? What's your name?
PR.
Pierre.
Priya.
Pierre. Huh?
Name,
Your name, madam?
name is Priyanka. my lord.
Priyanka, all right, heard so and so, ಅವ್ರನ್ನೇ ಹಾಕಿ ಹಾಕ್ಬಿಟ್ಟು till the next date of hearing.
28,
Petitioner, my lord. Proclamation, my lord. I have
Why
also-
proclamation?
Petitioner is accused number
Next
1.
date ಯಾವತ್ತು?
Not March. March, my lord.
ಮಾರ್ಚಾ? ಎಲ್ಲ ನೋಡ್ಕೊಂಡ್
24th March, my lord. 24th, I'm sorry.
82 ಫಾಲೋ ಮಾಡಿಲ್ವಾ?
No, my lord. Procedure is not followed.
ಯಾವ್ದ್ರಲ್ಲೂ ಮಾಡಲ್ಲ. The petitioner is before this court calling in question an order of proclamation of the concerned court. The learned counsel for the petitioner submits that the procedure as necessary to be followed under section 82 is given a go by. On the said submission, there shall be an interim order of stay, subject to the condition that the petitioner would appear before the concerned court on the next date, i.e. 24/3/2026. In the event he would not appear, the protection that is now granted would automatically vanish.
Great.
Next.
29,
Petition number 1 is the daughter and father, my lords. SCST Act, they are the.
Atrocities Act.
Atrocities.
Father and daughter.
ಅವ್ರ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಆಗಿದೆ. ಕಂಪ್ಲೇನೆಂಟ್, my lord.
Complainant ಯಾರು sir?
Complainant is a business partner.
ಅದೇಳಿ.
My lords, apart from that, my lords, on that day, my lords, they came to my place, they assaulted me.
ನೀವು
Then-
ಕಂಪ್ಲೇಂಟ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದೀರಾ?
ಅಲ್ಲ, later on what I did means I take the CCTV footages and the video records and audio records and I submitted to the commissioner, my lords. In spite of that, without.
Who is, ಇವ್ರು ಯಾರು? Who are you?
Previous serial number.
Huh?
Previous serial number 28.
Yes.
That I have produced in page 134, my lords. I submitted the entire audio records and CCTV video records, my lords, where I have not abused them in any filthy language or by addressing their cat.
ಸುಮ್ನೆ ಬೈದ್ರಿ.
ಏನು ಬೈದಿಲ್ಲ. ಅದನ್ನೇ ನಾನು CCTV footage has been produced to the commissioner. I produced page 34 ಅಲ್ಲಿ ಇದೆ.
ಈ atrocities ಇದೆಲ್ಲಿದೆ? ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ?
Charge sheet ಆಗುತ್ತೆ. In spite of that, they filed charge sheet, my lords.
ಇನ್ ಸ್ಪೈಟ್ ಆಫ್ ದಟ್ ಅಲ್ಲ, ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ.
ಇದೆ.
ಬರೀ ಅದೇ ಅಲ್ಲ, ಅಸಾಲ್ಟ್ ಇದೆಯಲ್ಲ?
Assault, my lords, actually I have produced the photo.
115, 318 ಬಿಡಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. 351.
Assault ಕೈಯಲ್ಲಿ, my lords.
ಅಸಾಲ್ಟ್ ಇದು 323 ಅಷ್ಟೇ.
They assaulted me. I have produced the photographs, my lords. They have assaulted me.
One HCGP 2 emergent notice. The petitioners are before this court calling in question the proceedings in special case number so and so registered for offense so and so. A perusal at the summary of the charge sheet as obtaining in column number 17 would not indicate that the hurling of abuses against by these petitioners against the complainant was in a public place or in a place of public view. The issue stands answered by the apex court in the case of Hitesh Verma versus so and so, 2020-10 SEC page 710. In that light, there shall be an interim order of stay of further proceedings by the petitioners till the next date of hearing. Thanks.
Please.
30,
My lord, the NI Act proceedings, my lord, the 311 application.
NI
is
Act?
rejected. One check one case.
NI Act?
NI Act, NI Act.
Negotiable instruments.
Yes,
Act.
yes, my lord.
Yes.
The 311 application is rejected and posted the matter for on Monday for judgment, my lord.
Very good, sir.
They partly cross examined. In the meantime, we are.
Partly, when did you cross examine?
ಅರ್ಧ cross examination.
ಅರ್ಧಂಬರ್ಧ ಯಾವಾಗ ಮಾಡಿದ್ರಿ ಸರ್?
ಇಲ್ಲ, partly cross examination.
ಅದನ್ನೇ ಅರ್ಧಂಬರ್ಧ ಯಾವಾಗ ಮಾಡಿದ್ರಿ?
Some you are 511, 51.
51?
2025.
5125.
Yes.
ಒಂದ್ ವರ್ಷ ಆದ್ಮೇಲೆ ಯಾಕೆ ಹಾಕಿದ್ರಿ?
ಅಲ್ಲ, in the meantime, we are settled the matter before the trial court, my lord. You accused, complainant accused his friends, my lord.
Friend, check transaction ಆಗದೆ ಫ್ರೆಂಡ್ಸ್ ಅಲ್ಲಿ.
Yes. We are try to settle the matter before the trial court, my lord. Kindly stay the matter, my lord.
Why? No, sir, ಹಂಗೆಲ್ಲ
Small amount is there, only 3 lakhs, my lord.
3 lakhs ಅಷ್ಟೇನಾ? ಕೊಟ್ಬಿಡಿ ಮತ್ತೆ.
ಕೊಡ್ತೀವಿ ಸ್ವಾಮಿ.
ಯಾವಾಗ?
Settlement ಮಾಡಿ.
The learned counsel appearing for the petitioner submits the amount is only 3 lakhs and is ready and willing to give the amount. In that light, there shall be an interim order of stay of further proceedings before the concerned court till the next date. In the event the petitioner would not come up with a solution of payment of 3 lakhs or otherwise, the interim order would get automatically vacated. Yes.
31,
20%, 10%?
10%.
Jambu Bandari. The petitioner is before this court, calling in question an order of the concerned court dated so and so. The petitioner is the accused gets convicted of the offence under section 138 of the Negotiable Instruments Act and is and prefers an appeal in Criminal Appeal 25368 of 2025, the issue in the list is not with regard to the merit of the matter. The concerned court suspends the sentence subject to the condition that the petitioner would deposit 10% of the amount. The order of the concerned court reads as follows, page
17.
Page 17. The concerned court, though records that the petitioner though records that considering the principles laid down by the apex court in the case of Jambu Bandari, the order of 10% is made, while there is no reason indicated in the order as is necessary in the case of Jambu Bandari. The apex court in the case of Jambu Bandari has held as follows: 410 SCC, page 446, paragraph nodiyalli. In the light of the said judgment, the matter requires reconsideration at the hands of the concerned court. The concerned court shall now reconsider the suspension of sentence, reconsider the imposition of 10% on the suspension of sentence and pass necessary orders in accordance with law. For the aforesaid reasons, the following order.
Till such order, Madam, this
One
order.
ನಿಮಿಷ sir. ಪೂರ್ತಿ ಹೇಳಕ್ಕಾರೆ ಬಿಡ್ತೀರಾ? The petition is allowed, so and so stands quashed, the matter is remitted back to the hands of the concerned court to reconsider imposition of 10% or otherwise as a condition precedent for suspension of sentence. In the light of the suspension of sentence operating in favor of the petitioner, the same shall operate till the concerned court would pass necessary orders as is directed. ಅಷ್ಟೇ ತಾನೇ ಕೇಳ್ಬೇಕಾಗಿದ್ದು? ಮತ್ತೆ ಪೂರ್ತಿ ಬಿಟ್ರೆ
Orders 32.
Appearing for the petitioner.
My lords, I request for the short accommodation as my senior is not available.
where has he gone?
Supreme Court.
Supreme Court.
My lords, we are ready in the matter.
Supreme Court, sir, wait. Yes, we'll adjourn it by 2 weeks.
My lords, the date may be fixed, my lords.
List the matter on, madam, with the 24th though. All the applications should be considered along with the main matter. List the matter for admission on 11th.
My lords, a shorter date if possible, my lords, we are ready.
18th.
Yes. Interim order may kindly.
25th.
No, interim order. may
okay,
kindly be-
all right.
11th.
11th, yes.
Counsel for appellant, my lord, not keeping well, you want, seeks a 1 week time.
You are not keeping well?
My lord, my friend, who is on
Friend.
counsel on record, my lord.
Same day, but 18th.
My lord, connected matter 41 is also there, my lord.
Interim order may kindly.
Other accused, I am the same complaint, same crimes registered. Serial number 41 also.
Tag ಮಾಡೋಣ? Tag the petition along with 41. List the matter on Thursday, 24, madam. Wednesday. Any Wednesday.
11th.
11th.
Interim order has to be extended.
Continues.
34.
For the petitioner, my lords.
Non-filing of report by HCGP.
Notice to be complainant to be served, my lord, sir.
Non-filing of report by HCGP.
It is, my lord, sir, report.
ಅದೇನು?
Notice to complainant. my lord.
ನೀವು ಕೊಡ್ಬೇಕಾಗಿತ್ತಾ?
That is the, my lord.
ಕೊಡಿ.
I had taken out steps as per the address mentioned in the charge sheet, my lords.
Notice and respond number 2 and report the same. Yes, sir. ಇವೆಲ್ಲ ಯಾಕೆ ತಗೊಂತೀರಾ ನೀವು? ಅವು ಬೇಕಾದ್ರೆ ಬರ್ತಾರೆ.
The direction, my lord, sir.
There is a direction already. The coordinate bench on 27/6/2025 had passed the following order. Learned HCGP seeks
2 weeks.
2 weeks time. 2 weeks time to comply with the order dated 27/6/2021. List the matter on 18th. IO till then.
27/6/2025, my lords, sorry.
Who said, sir?
2024.
25.
Sorry, my lords, yes.
Yes, he has to pay the process, my lord.
He has already paid.
I have paid it.
ನಿಮಗೆ ಪೇ ಮಾಡ್ಬೇಕಾ?
ಅಲ್ಲ, process, my lord.
ನೀವು ಸ್ಟೆಪ್ಸ್ ತಗೊಳಕ್ ನಿಮಗೆ ಹೇಳಿರೋದು. ಪ್ರೊಸೆಸ್ ಕೊಡ್ಬೇಕು ಅಂದ್ರೆ ಅವ್ರ ಮತ್ತೆ
To serve through the police, my lord, sir.
ಪೊಲೀಸ್ ಚಾರ್ಜಸ್ ಕೊಡ್ಬೇಕು.
35.
ಪೊಲೀಸ್ ಚಾರ್ಜಸ್ ತುಂಬಾ ಜಾಸ್ತಿ ಇರುತ್ತೆ. ನೀವೇ ಹೋಗಿ ಸರ್ವ್ ಮಾಡಿ ಬಂದ್ಬಿಡ್ಬೋದು.
For the respondent number 2, please.
Yes, sir.
Priyanka Srivastava.
ಇಲ್ಲ
they're going to
ಅದನ್ನ
stay
ನಾನು
there.
ಇದ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಸುಮ್ಮನೆ
You
ಸೀನಿಯರ್
are not relying on Priyanka?
ಅದು
ಅದೇನು?
ಸೀನಿಯರ್ ನಾಟ್ ಎಟ್ ರಿಕಾರ್ಡ್
Not Priyanka. Senior is not recovered.
Last time ಅದೇ ಕಾರಣಕ್ಕೆ
ಅಲ್ಲ ಅವರು ಪ್ರೊಸೀಜರ್ ಆಗಿದೆ ಒಂದು ವಾರ ಬಿಟ್ಟು
ನಾನು ಏನ್ ಹೇಳಿದ್ದೀನಿ ಇಲ್ಲಿ ನೋಡಿ.
ಇಲ್ಲಿ ಹೇಳಿದ್ರೆ ಅವ್ರಿಗೆ ಈಸ್ ನಾಟ್ ಎಟ್ ಬರಕ್ ಆಗ್ತಾ ಸ್ವಲ್ಪ ಇನ್ನೊಂದು 4-5 ದಿವಸ ಸುಮ್ಮನೆ.
I have more than a
I
prima
request
facie
only,
case.
I also request my learned friend. Next week ಹಾಕೊಂಡ್ರು.
Last
Sorry,
chance ಅಂತಾನೆ
madam.
next last date.
ಅವ್ರು ಹುಷಾರಿಲ್ಲ ಬಂದಿಲ್ಲ ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ.
There is no grounds. Priyanka Srivastava, it's overruled. And even I have more better than more than a prima
You are
facie
better
case.
than Priyanka?
No. I have better case than a prima facie case. I have proved my employment, transaction, everything. They're enjoying the stay from past 1.5 years. That is the reason.
For last 1 week they will enjoy, don't worry. Yes. List the matter on 5th. This court on 14/1/26 had passed the following order. In the event the counsel for the petitioner or in the event the arguing counsel or the counsel Narayana would not make his submissions, interim order would get automatically vacated. ಮೊನ್ನೆ ಬರ್ದಿದ್ದೀನಿ ಅದನ್ನ ಸರ್ಜರಿ ಅಂತ ಸುಮ್ಮನೆ
ಅದು ಬರ್ತಾ ಇದ್ರು ಅದು ಸ್ವಲ್ಪ ಟ್ರೀಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದೆ ಅದಕ್ಕೋಸ್ಕರ
ಬರ್ತಾ ಇದ್ರು ಟ್ರೀಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದ್ದಾರೆ. ಏನ್ ಎರಡು ಒಟ್ಟಿಗೆ ಹೇಳ್ತೀರಾ
ಅಂದ್ರೆ ಇನ್ನ ರಿಕವರ್ ಆಗಲ್ಲ.
ಸರಿ ಆಯ್ತು.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲ
ನೀವು ಕರೆಕ್ಟ್ ಹೇಳೋದನ್ನ ಕರೆಕ್ಟ್ ಆಗಿ ಬರ್ಕೊಂಡ್ ಬಂದ್ಬಿಡಿ ಏನ್ ಹೇಳ್ಬೇಕು ಅಂತ. ಹೇಳ್ಬೇಕಾದ್ರೆ ಸ್ಪೆಲ್ಲಿಂಗ್ ಮಿಸ್ಟೇಕ್ ಆಗ್ತಾ ಇದೆ.
ಇಲ್ಲ ಸ್ವಲ್ಪ
ಅದು ನೀವು ಹೇಳೋದ್ರಲ್ಲಿ ಸ್ಪೆಲ್ಲಿಂಗ್ ಮಿಸ್ಟೇಕ್ ಮಾಡಬಾರ್ದು, ಬರೀ ಅದ್ರಲ್ಲಿ ಇದ್ರೆ ಪರವಾಗಿಲ್ಲ.
ನೆಕ್ಸ್ಟ್ 5th ಮಾಡ್ತೀನಿ.
ಆಯ್ತು
ಸಾರಿ ಎಂಟ್ರಿ ಮಾಡೋಣ.
ಅದೇ ಕೇಳಿಲ್ವಲ್ಲ ಅಂತಿದ್ದೆ ಇಷ್ಟೊತ್ತು. ಎಸ್ ಎಂಟ್ರಿ ಮಾಡಕ್ಷನ್ ಮಾಡಿ.
Great.
4 as well, my lords, interim order.
Don't worry. When have I vacated the interim order without hearing? Yes.
36 to 40 withdrawals.
All withdrawals in
41.
terms of memo.
41 connect along.
41 connected.
42 withdrawal.
Withdrawal, yes.
43 PF cut.
Paid. Yes. But office to verify.
Please.
44 police.
44 post immediately after service of notice upon the respondent. Interim order continue ಮಾಡಿ. ಇಷ್ಟೇ continued. 45 post immediately after service of notice upon.
I undertake to file wakalat.
45 ಅಲ್ಲ
45.
Learned counsel so and so undertakes to enter appearance for the respondent complainant registry to print the name of so and so is appearing for the respondent complainant. Next.
46
Withdrawal, yes.
47 police report.
Post immediately.
Interim order. 48
Interim order will continue. 48
furnishing of PF.
a week's time is granted to do the needful. Failing interim order, madam. 2 weeks time is granted to do the needful. In the event the needful is not done, interim order would stand automatically vacated.
49
49 madam. Permission filed by we have respondent.
Sir, I have already
Permission?
already I have filed this one. Just the counsel of the opposite party, he has asked for the copy. On 27/10, I have already filed a memo. It has been accepted by the honorable court.
1 minute, sir. Application for allowing GPA of the respondent in hearing the case. You are the GPA? Respondent, you are complainant?
Respondent.
Complainant?
Respondent.
Who is the respondent?
Respondent is my daughter.
Daughter? She is the victim? Wife?
Nature, my daughter. He is wife of this petitioner, of the petitioner.
Again, reject ಆಗಿದೆ madam. Permission can be granted, no?
Sir, I was been already allowed
Wait,
on
1 minute.
27/10, sir.
GPA. No, you have to appear, you have to approach the committee. To appear in person, you will have to approach the committee.
Sir, on 27th, I have given, 27/10, I have given a memo to this court. And this court has already allowed me.
Already allowed, huh?
Sir, already, after that, he has asked for this memos, sir.
You come this side.
After he was allowed.
You are not allowed, but anyway, yes.
My
You
lord,
are the husband.
I'm the husband.
Now
my
what's
lord.
the issue?
My lord, this marriage is since 2011, my lord. They stayed only for 20 days together.
Is it dissolved?
It's not resolved, my lord.
Then how much maintenance you're paying?
15,000 I'm paying as.
Then why you challenge that order?
I've challenged that order. It was ex parte order before the trial court.
No problem. Continue to pay 15,000.
I'm
Send it
continuing
back.
to pay.
So actually, this order has been communicated to him.
You don't worry, sir. This order will be confirmed. I'll send it back. You hear the get the matter heard there only.
Please, my lord.
Ashta, that's all.
Sir, already this, he has received the copy. Received the
You
copy.
don't worry about all that, sir. I'm confirming this order. The court will proceed further. ಈಗ arrears ಎಷ್ಟಿದೆ?
Arrears ಕೊಟ್ಟಿದ್ದೇನೆ ಸ್ವಾಮಿ.
So this month they have not paid.
They will pay.
Yes. This month I'll just ascertain, my lord. Till now it is paid.
Disposed.
Please.
Matter to be placed, matter is, there is no warrant of interference with the maintenance awarded at rupees 15,000, though interim or otherwise. The petitioner is at liberty to file necessary application before the concerned court in the event of need. The concerned court shall answer the issue on its merit and pass necessary orders thereon. Ordered according.
My lord, the only contention is, my lord, with regard to the application which is filed, whether he can contest on behalf of the.
He can.
The Advocates Act.
Can. Father.
My lord.
It's a stranger, Andra, I would not have permitted.
My lord, the only
It's
thing
the
is,
father.
they have put me out of my own house and they are residing, both of them.
No, sir, it is wrong, sir.
They are not even allowing me to come inside the house.
Where are you staying?
Sir,
I'm in a rented place, my lord, rented
Sir,
premises.
they have left the
In the FIR
left
which.
my daughter.
This is not family court, don't worry. Yes.
Sir, they have left.
Arey,
my-
Yagu, case is over. No more submission, case is over. Yes. One more 14%.
My lord, in this I am seeking for speedy disposal.
Speedy disposal.
Yes, my lord.
All right.
My lord, IA number 1, 2 and 3.
How
my
fast
lord.
you want?
My lord, only speedy disposal.
Then how fast?
How fast? According to your court, my lord.
According to
Your
my-
lordship decision, my lord. But then I have filed it on 2024, 28/5/2024, my lord. IA number 1, 2,
What is
3.
this matter?
This matter is a domestic violence case which I have filed against my own parents, my lord.
All right.
Uh,
Will
My lord,
direct the court
kindly,
to 3 months, 6 months?
no, my lord, 2 months,
No?
2 months. My lord, and one more, I am,
4 months.
my lord, one more, I am seeking prayer to set aside an order, which is, I have asked for protection order that they have not granted, my lord. I am challenging that order also.
No, you can't challenge many things. In asking speedy disposal, you go on challenging everything. Now, I've granted speedy disposal. You ask everything before that court.
Setting aside the protection order, my lord. They have not granted me protection order, my
You
lord.
should file separate, madam. You can't seek both in one petition.
In one more petition to have.
Anyway, you are always here. You finished your law? All right. You'll be the best advocate, don't worry. Yes. All right. Only speedy disposal. For that, you file some another thing. I'll
One
take
more
it.
petition. Deeply obliged.
Yes. ಎರಡು petition ಇದೆಯಾ? ಎರಡು previous petition disposed ಅದು. Why is Panindra sir waiting?
Needful has been done, my lord.
ಎರಡೇ ನಿಮಿಷ. Yes.
Needful, 51 needful.
Needful has been done, office to verify. Entry
Interim
model.
order to-
Next.
Hearing on 52.
52. Please.
52
Your Lordship, I'm seeking for a short accommodation as the arguing.
Rejected. Yes.
The interim order, my lords, we have prayed for vacating the interim
Your
order for
Lordship,
this
the
reason.
arguing counsel is not in
Who's
town.
the arguing counsel?
Urmila Pulat.
Sorry?
Urmila Pulat, the counsel on record.
All right.
So I'm just seeking a short accommodation, Your Lordship.
What's the matter?
The matter is regarding.
You have a colleague?
Yes, Your
Where's
Lordship.
the file?
I have it with me.
All right. please. You've not seen the file?
I have your lordship, but she's the arguing counsel and she's well versed with the facts. As I
Number-
for vacating stay has also been placed, so she's well aware with the facts.
Several cases pending. Accused number 1 is already in custody in Delhi. Now my lord, some other accused persons have saw, my lord, they 2 and 3. My lord, they have approached this on court, and there is an interim order stay. The problem is, my lord, because of that investigation in that case, a lot of economic offences involved, my lord, pertaining to this
Economic
case.
offences.
Economic offences involved, my lords. And therefore, the Delhi economic wing, my lord, economic offences wing has arrested accused number 1. He is in custody. Investigation is going on. Now,
What
because
is this about?
it's connected to this only, my lords. Connected to this. He has cheated many persons, series of cases of fraud, my lords. Unless your lordship is pleased to permit the further investigation in the case to proceed, my lords.
Let's see.
It will be hampering the.
Arguing counsel illa. Doesn't know. I'll take it on 5th, madam.
Much obliged.
Finally.
The interim order, if it may be extended.
The Leonard, what's your name?
Sakina.
So and so appearing for the petitioner submits that the arguing counsel is unwell,
She's not in town.
has some inconvenience today. Therefore, as a last chance, list this matter on 5th. In the event no submissions are made by the counsel for the petitioner, the interim order would stand automatically vacated. Subject to the aforesaid, interim order stands extended till the next date of hearing. Yes.
Great.
ಆಮೇಲೆ heard ಅವರು ಆಮೇಲೆ PP senior counsel PP yes
Please.
ಹಾ
53.
ಇನ್ನೊಂದು ಯಾವ್ದೋ ಇದೆ ಮೇಡಮ್ ಇವ್ರದ್ದು
53, the matter will have to be heard. An interim order granted after.
Make one submission, my lord, before that, my lord. But the respond to in this case, my lord, 2 weeks time to grant. I engaging senior counsel, my lord.
Engaging.
Please, already engaged, my lord.
You can't keep engaging in the act of engaging senior counsel.
We filed a vacating application also, my lord.
ಮತ್ತೆ ಅದು will dismiss it.
Please. ಅಲ್ಲ.
ಹೂನಾ?
No, my lord. Short account is
Who appears for R2? Venkatesh Dalwai.
Illa Venkatesh Dalwai, I think, has filed.
Kirti Reddy ಅಂತನೂ ಇದೆ. You also appear, is it?
I've entered appearance, my lord.
He is not there.
It's colleague, my lord. He appeared, so I didn't appear, my lord.
ಯಾರು ಅಪಿಯರ್ ಆಗ್ತಿದ್ರು ಇಬ್ಬಿಬ್ರು ಇದೆ ಎಲ್ಲರನ್ನ
I appear for R2. I've just entered.
Venkatesh Dalwai, you have entered appearance now. The registry to delete the name of Venkatesh P. Dalwai is appearing for the respond number 2 and retain the name of Kirti Krishna Reddy is appearing for the second respondent. Who has filed vacating stay now?
R2.
R2.
But this is a complaint under 7.
7?
PC Act.
Trap. PC Act.
BC, their trap has, I am not involved in the trap.
Failed trap, huh?
I am not even. But so far as I am concerned, I am not.
Accused number.
Accused number 1 minutes. I am accused number 1. Official.
Accused number 1. Who took money?
A2, my lords, who is supposed to be my friend.
Friend? Friend or subordinate?
So not even subordinate. Friend anta. And the complainant is a advocate who says, I went for the cause of my client. And there are 2 FIRs against him, my lord, not relation to this. Subsequently, also 2 Tahsildars and 1 Tahsildar AC filing complaints that is harassing all of them whenever. This is the complaint. The landowner whose thing, he is not the complainant. Advocate says, I wanted to help the client.
I'll make my submission, my lord. I require some time. I've just come.
Heard the learned senior counsel and Panindra appearing for the petition. There's an interim order already.
There's already an.
The coordinate bench has granted an interim order of stay. The learned senior counsel submits that the petitioner, though is arrayed as accused number 1, is not. There is neither demand nor acceptance on behalf of the petitioner, as the amount is said to have been received by a friend of accused number 1. Friend?
He's not a friend, my lord. He's the mediator.
NOC ಕೊಟ್ಟಾಗಿದೆ ತಾನೆ?
ಇಲ್ಲ, we are
together.
My colleague, my lord.
My lord, he's not a friend, my lord. He regularly, my lord, he is a broker. He's a mediator, my lord. He's through, my lord, they recount the amount, my lord. Dear my lord, the 5.
Mediator.
Please, 5 lakhs, my lord, I'll be receiving, my lord. Accused number 2 is receiving the 5 lakhs, my lord. At the time of trap, not 2 lakh rupees seized. Earlier, my 3 lakh rupees already received from the accused number 2. As instruction of the accused number 1, my lord. The evidence, voice record also clearly showing that.
ಆಯ್ತು ರೆಡಿ ಆಗಿ ಯಾರಾದ್ರು ಲಿಸ್ಟ್ ಆನ್ 2 weeks ಬಿಡ್ತಾವಂತ ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಆನ್ 18th 19th sorry.
Interim order.
19, interim order subsisting, we'll continue to the next. Please.
54.
I appear for the respondent in this matter, my lord.
What happened?
My lord, they have not ready for the settlement, my lord. If what I have given to them, my condition, one copy I can give you, my lord. Nothing extra within
Yes,
this,
madam.
my lord. But they are not ready, my lord. And they are also forcing me to
She is
withdraw all
asking for
cases.
38 lakhs, my lord. And he has no place to stay also. He is on a rented premises in paying 8,000 rupees. And he has to pay 5 lakhs to the child for boarding and the boarding score. And he is left with nothing. And he cannot afford to pay so much of maintenance. And that too with no visitation of seeing the child. This is the terms and conditions that she has put. Those conditions are not.
He only, before the Kerala court, my lord, he only told that he does not want to visit the child. And there is an order also in their custody case. Order
If
has
that
been
is the
finalized
case, if
also.
Kerala matter, Kerala consent petition was filed.
How
if
in,
she is
I have to go
agreeable
in
with that,
all the
we
states
are
of
also
India and
agreeable.
type cases, my lord. What is this, my lord?
Wait, yes.
If she is agreeable for the memorandum of settlement that she had filed before the Patnam Titha court in Kerala, and she has
What is
filed
that
contempt.
settlement?
In that nothing is there, but in that 1 rupee also I have not asked from them, my lord. But that settlement happened in the year 2023. It was a case which we fought from 2021 to 23. But now it is 2026, my lord. 3 years I am running behind the court. Unless I need cost, my lord. And meanwhile, what happened? I could not look after the child. I put her in a good school, my lord. And the school fees is very high, my lord. And I am unable to afford it. So only for that sake, I asked them 40 lakhs. 1 year, my lord, only the school fees is coming 5 lakhs.
ಯಾಕೆ ಅದು ಕೊಡ್ತಾ ಇಲ್ವಾ ಈಗ?
The child
ಅದು
is
ಈ
put in
ವರ್ಷಕ್ಕೆ ಮಾತ್ರ
boarding, it
ಕೊಟ್ಟಿದೆ,
is
my
5
lord.
lakhs.
ಬರುತ್ತೆ ನಿಮ್ಗೆ. All right.
3 ವರ್ಷ ನನ್ನ ಮಗುವಿನ ಹೋಮ್ ಸ್ಕೂಲಿಂಗ್ ಮಾಡಿದೆ, my lord. Only from second standard my child started going to the school, my lord. Second standard and third standard only they paid the fees. Before that I was the one who homeschooled the child, did not even go for work, my lord. I couldn't, there is a career gap of around 20 years also for me, my lord. Kindly pass an order on interim maintenance, my lord, which include my cost for the legal fights, my lord, and also for the treatment I need to undergo, my lord.
Yes, madam.
In this matter, my lord,
Now you
the
agree for a
qualification of the
particular amount. Agree for a particular amount.
But she will not agree, my lord. There were consent
Yes, how much?
petition
You
which
want
was
37
asked.
lakhs, is it? How much you want?
No, 37 she is asking. 38.
How much?
38 lakhs and there is a
38.
gold ornament which is with his mother. If he is giving back the same, it is fine. Otherwise, accordingly, I ask the money. So it may come around 40 lakhs.
He is incapable of paying so much, my lord.
He has 8
He-
crore worth Benami properties, my lord.
Benami property.
Yes, my lord. In his brother's name, he purchased and he is acting too innocent. He does not have a single penny and he is paying to his lawyers 50,000 per month. In his affidavit,
Oh, you
he
are taking
filed
so much,
30
madam?
lakhs. He already paid to his lawyers, my lord.
You
And I am asking 40 lakhs. He is unable to pay.
will pass orders on Saturday. Saturday is a working day.
Yes,
Deeply obliged.
Which year are you in LLB?
First year, my lord. Sorry, second year.
Second year.
One more year we have to do.
Your Lordship, this matter is connected with 5 other petitions which are listed tomorrow, so kindly be
ಆಯ್ತು, ಅದ್ರ ಜೊತೆಗೆ
serial number 56 as well. Watch.
Tomorrow.
57.
Your Lordship, appearing for petitioner. In this case, the petitioner was directed to appear before the authority on 26/9, Your Lordship.
extension of time.
Yes, Your Lordship.
When was it when was it directed?
26/9 of 25.
26/11.
9 September.
You have not appeared?
Actually, we appeared on 27th, Your Lordship, due to communication issue. But the authority refused to accept the judgment copy or the letter.
All right, we'll pass orders tomorrow.
P group 58.
My lord, I'm for the petitioner, my lord.
Ah,
My lord, the petitioner had filed the MC number.
MC?
Please, my lord. For restitution of conjugal rights against the respondent wife. Remained absent, my lord. The wife.
Wife remained absent.
Absent. Then court passed the decree directing the respondent to join the family of the petitioner. Can you see the order passed by this court, my lord? On 25 to 2025.
All right. She did not join.
Not join, my lord.
Oh. What did you do then?
Then, my lord, the respondent wife had filed the criminal misnomer, my lord, 518/2023 under the DV Act. These are dismissed. The DV Act filed by the respondent against the husband are dismissed on a
no.
second matter. It is. The two matters. My lord, the petitioner challenging the criminal misproceedings initiated by the wife under DB Act. The trial court giving sufficient time to the respondent wife, the evidence, it did come forward the court, my lord. The court dismissed the case of the respondent wife for default on 30th December 2024. Then both the petitions may be clubbed together, pass the order, my lord, according. Yes, my lord. Please, my lord.
Intermodal ಇದೆಯಾ?
Intermodal ಇಲ್ಲದರಲ್ಲಿ. The dispose of ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ.
ಏನ್ ಕೇಳಿದೀರಾ ಅಂತ ಹೇಳ್ಬೇಕಲ್ಲ. ಮತ್ತೆ ಸ್ಟಾರ್ಟ್ ಮಾಡಬೇಡಿ, ಇನ್ನೊಂದ್ ದಿನ ತಗೊಳ್ಳೋಣ.
My lord, the
restitution conjugal rights, wife filed, she did not come, court passed order, ಎಲ್ಲ ಗೊತ್ತಾಯ್ತು.
Please.
We'll take it on 11th.
Please.
12th.
Please. Submitting the records.
Registry lab.
Please. Please.
File it.
59.
For the petitioners, my lord.
We'll pass some order in this and upload it. Yes. Yes. Come.
Password 5.
Lord, before
I
my,
have 60 seconds.
Lord, before my learned friend begins, Lord, I want to raise a few issues on maintainability of the writ petition. Lord, firstly, my Lord, the petition is filed under 226 read with 528 BNSS. There are no proceedings whatsoever under BNSS, so 528, my Lord, is not maintainable. Number two, as far as 226 concerned, the officers had jurisdiction to conduct the search. There is no violation of principles of natural justice. So on 226 as well, my Lord, the writ petition is not maintainable. Thirdly, my Lord, when after the search was conducted, all the safeguards which are recognized under Vijay Madan Lal Chaudhary have been followed. The authorized officer has recorded the reasons to believe. After the search was conducted in a sealed envelope, the report has been sent to the adjudicating authority.
No, that's the issue is predicate in Ilvanta.
I'll come to that. That's on merits, my Lord. That's on merits.
Merits only.
But these are maintainability issues. Then
no, if predicate is not there, ECR is not maintainable. Petition is later.
No, without ECR I can do this. That is what Vijay Madan Lal Chaudhary says. Without, sorry, I'm
without ECR,
without FIR, I can do the search. It's a civil. It's a nature of a civil proceedings.
But
Para 79, Vijay Madan Lal Chaudhary.
Registering what?
I'm sorry.
Registering ECIR.
No, my Lord, ECIR. My Lord, first thing that we need to understand is ECIR is just like a number. It's like a number we write in the register. It is not a statutory document like a FIR. That is what Vijay Madan Lal Chaudhary says.
Correct.
Now, the point that I wanted to make, the third issue on maintainability is that after the report was sent to the adjudicating authority, a notice was sent. The writ petitioners have participated in those proceedings, raised all the grounds which are now raised before Lordship before that authority. That authority is seized with the matter. How can the petitioners run parallel proceedings? The Honorable Supreme Court has said, no, that should be allowed to complete its legal course of action. So they should pursue their remedies there and then come here. So therefore, let him address on these maintainability issues. Then, my Lord, we will file our objections and then matter may be heard on merits.
Till then, don't precipitate the matter. We'll hear it. Maintainability mele, but allivargu don't make it fait accompli. That's all.
The investigation will continue, but precipitation
that is not saying should not continue.
Precipitation would be arrest.
Arrest yak ಮಾಡ್ತೀರಿ ಈಗ?
No, as of now, my Lord, we do not have any such.
I'll only say
we'll
hear it on maintainability.
Monday is fine, my lord, then, but let there not be
Monday
any.
alla, Tuesday.
Tuesday, very well. But then, my lord, when there is a cloud of doubt on the maintainability of the writ petition, my lord, my request is the writ petition is not entitled for any.
We'll decide that, but on that ground arrest ಮಾಡೋದು ಅದೆಲ್ಲ ಮಾಡಬಾರ್ದು.
My lord, as of now, my lord,
No, it's not, see,
no, we have not even summoned.
No, that's
Make
a
this
different
request.
thing. Now, see,
No.
there is no predicate offense. Predicate offense is gone.
Lord,
No, I'll tell you why I am.
No, why I'm saying
I
this
will
is-
hear on the issue whether predicate offense is necessary or not necessary. ECIR can stand on its own or otherwise. Till I hear it, then don't.
No, maybe I will just give an hint, my lord. My respectful submission is that procedures under section 17 is akin to the one under 5 and 8, that is attachment.
No problem.
No, the Honorable Supreme Court says those are all in the nature of civil proceedings. You don't even need a FIR for that. Arrest, my lord, I will need. Arrest, I will need. So therefore, my lord, that is
What
the
he says
maximum
is
hint that I can draw.
Let the seizure continue is what he himself said. Let the seizure continue. Let them not conclude the proceedings of such seizure till the matter is heard. That's all. Don't conclude the proceedings and make it fait accompli.
Very well.
That's
Very well.
all. I'll hear it on merits, not a problem.
Concluding the proceedings.
Concluding the proceedings. That's all. Yeah, I'm
All
not
right.
saying you give away the seized property.
All right, all right.
Its seizure will continue. You don't close the proceedings of seizure.
Very well. That's fine. No, my lord, that, my lord, why, I do not, why, my lord? If, my lord, so now,
You should not confirm it.
no, my lord, if the, what I do not, I want to understand what is the apprehension. From what fell from the court is that he should be arrested. What is the difficulty in appearing before the adjudicating authority?
No, what I am saying is let the adjudicating authority not conclude the proceedings till I pass an order on it, that's all.
Very well.
Seizure will
Very-
continue,
very-
he will not conclude the proceedings.
Very well.
I'm not staying the proceedings, but
Very
they will not conclude the
Very
proceedings.
well.
ಅವ್ರು ಹೇಳಿದ್ದು ಅದೇನೆ. Yes, heard the learned counsel for the petitioner and the learned additional solicitor general of India, Shri Arvind Kamath, appearing for the enforcement directorate.
Yes.
The learned ASG would submit that the EC with or without ECIR.
No, without registration of a predicate offense.
The learned ASG would submit without even registration of a predicate offense. The ECIR can be registered the attachment proceedings.
The search.
See, the search and seizure can take place even without a predicate offense. That is what is that is in the light of the said contention, he would submit that the search and seizure proceedings should not be stalled at the hands of this court. The learned counsel for the petitioner submits that the search and seizure would continue, but let not the adjudicating authority conclude the proceedings by passing a final order.
Right.
In that light, I deem it appropriate to direct that the adjudicating authority would not conclude the proceedings of search and seizure till the decision is arrived at in the case at hand.
Very well.
List the matter on Monday and Bada. Innೊಂದು ವಾರ ಆಗಲಿ.
There is a protection, no? Lordship may give any convenient.
We'll take it on 12th.
Very well.
ಆಗ್ಬೋದಾ? 12th, yes. ಆಮೇಲೆ chamber ಕಳಿಸ್ಬಿಡಿ. I think that should not create a problem.
Yes.
Alva. We are not directing him to return it, but we'll decide. If it is not maintainable, andre you can proceed.
In the meantime, we'll complete the pleading so that we
whatever,
can.
yes, no problem. Because this issue needs a decision. Because whether ECIR can be updated, all that, ಬೇರೆ ಕೇಸಲ್ಲಿ ಬೇಕಾಗುತ್ತೆ. But ECIR is an administrative document.
In your
It
lordship's
is not a
court,
statutory document.
No, we are glad law will be laid down now on that.
We definitely will do it.
And we'll assist in that.
Unlike FIR, which is under 154 or 175 of BNSS, this does not have a statutory foundation.
Yes.
ECIR does not have a statutory foundation. It's an administrative document.
Yes.
And purely internal.
Absolutely. Yes.
So let's see whether updation is permissible or not. You may be right also.
Updation, my lord, now there are so many judgments on updation.
On updation?
Yes. There is a recent Bombay High Court judgment, Allahabad High Court judgment. So we have said, I would place it before law.
Yes. All updations, yes. 5 and 6, all right. Yes.